Conversations don't just inform you, they open your eyes. And today, you are going to hear from someone whose insights can really do something like this for you too. We'll get into that later, but before I do that, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right. After this very, very important disclaimer, welcome back everyone to Immigration Talk Show, the place where real stories, expert advice, and powerful conversations come together to guide you through the ever changing world of US immigration. And now, let me set the stage. Imagine navigating one of the most complex legal systems in the world, not just once, but over and over and over again. Nearly for 30 years. Imagine being the go to person for companies trying to bring in top talent, for entrepreneurs chasing the American dream, and for professionals trying to make a life here. Our guest today has done exactly that and more. She's the kind of attorney who doesn't just handle paperwork, she builds strategies, solves challenges, and helps people turn opportunities into reality. Whether it's H1B, L1s, EB1s, green cards, compliance issues, or even litigation, she's seen it all. And she's done it with precision and heart. So get ready. Joining us today is the powerhouse behind Imandi Law Firm, the incredible attorney Rani Imandi. So Rani, welcome to Immigration Talk Show. It's your first time. I wish I could like stand up and maybe welcome you with a round of applause. But it's a pleasure having you on the show. Most welcome.
Dear Rajni, thank you for that wonderful introduction. I'm honored to be here. Frankly speaking, I'm very honored to be here. And thank you for inviting me and your team as well. I'm happy to share my insight during the last almost 3 decades on immigration law. And I'm happy to provide some hope, inspiration, strategy, advice, whatever I can in this time.
Thank you so much for being here, Ronnie. It's a pleasure. It's an honor. And yes, we are going to get into that, all that discussion. We are going to discuss the topic of today. How do you handle H1B travel and the challenges? So we are going to get into all that. But before I do that, guys, I would like to inform you that we are live on YouTube, LinkedIn, Twitter, which is X now, and Facebook, and also on Instagram. So make sure that you follow us, subscribe to us, and also share these handles with someone who you think can help by following or subscribing to our platforms. So make sure you do that. And now, without any further ado, Rani, I would like to come to you. And so I've already introduced you to the audiences, right? They already know that you have these 30 years of experience handling immigration, U.S. immigration. But I would also like you to, talk a little bit about your journey before we get into the topic. So, how has these 30 years been for you? I mean, I'm sure you must have gone through a lot of challenges, right?
Absolutely. My family, I'm an immigrant myself, and that's why I take everything to heart with what I do with my clients and anyone else who needs that legal advice, because I've experienced the same fears, uncertainties, and anxiety to some extent through my parents. When we came into the country, we came in around the 1970s with my two brothers and my parents. Um, and it was definitely a bit of a trying time back then because, we were one of the first batches of people. I would like my brothers and I were the only like brown people in school, frankly speaking. I'm in my high school, literally I and my brothers were the only Indians in our high school. So in experience these situations, and there was a certain certain challenges that even my brothers and I faced, but It was necessary, I thought, that with my parents' struggles as well and their uncertainty, for them to understand, for us to actually be in a very secure spot. And I felt that's what led me to law, to conquer the law of the United States, so that I knew that no one could have anything over my situation or anyone else that I knew, that we would persevere and we would be able to, I would be confident and I would be able to be successful knowing the law. And that was very crucial and important to me. I ended up going into immigration law. It was kind of some pull that led me to the field of immigration law. And then it seemed to make sense because I could help. Um, I felt that it was rewarding to help my own people, my kind, and any other immigrants into this country. And that's basically my journey. And we started my practice in like 1996 in New York City. And I've been there ever since with a great team that supports me. I have wonderful staff who've been with me for over 15 years and they're still with me. So I'm very pleased with what we've built. Um, I am pleased to have seen companies grow from 0 employees to hundreds and hundreds of employees to thousands of employees that we started helping back in the year 2000 or 1998 that are still my clients. I have seen immigrants who initially were on work visas and now they're citizens. So it's very rewarding and they're just so happy. And we always join in their happiness and um, uh, their goals and their dreams. So we're part of that. And we always are just pleased whenever we can say, congratulations, your immigration journey is over and you've made it. So that's really it. So it's a great rewarding
Right.
position to be in.
So beautiful. That's such an inspiring journey and such a beautiful journey you have had. So you basically have paved the way for so many others, who aspire to be a US citizen or who aspire to be in a foreign land and make that foreign land their home. So thank you so much for doing what you're doing. And especially in tough times like these, I think the uh, immigrants really need someone like you. So thank you.
Thank you.
So, Rani, now I would like to come to the topic. And before I ask you my first question, I would, ask you that if you can tell a little bit about what can our audiences expect from today's episode.
So I think that we had discussed, it seems to be there's a certain challenges occurring today with for work visa holders in regards to their travel in and out of the United States. Currently, as we have heard, that there are many challenges at the borders, at the port of entries, if it's the airlines, for travelers coming back in, work visa holders, students, so those travel challenges, there are challenges at the consular posts in obtaining the visa stamps. There's challenges in relation to their dependents, their spouses, and their children. So we wanted to address that and provide other options, even if even whatever options we can provide, we would like to discuss. And yeah, primarily it's that and the challenges that they're facing today in travel.
Right. So, guys, if you have any question related to the topic, related to any kind of challenges that you're facing, while traveling, or if you plan to travel, and if you have any question that comes in your mind, you're more than welcome to post them in the comments below. And we are live on LinkedIn, YouTube, Instagram, X, and also on Facebook. So make sure you post your questions in the comment section, and we are also available on call. So you can dial this number 425-436-6335, and you can put this access code, which is 988888. Yes, and you can join us on call too. And with that, don't forget to subscribe to us. We are Immigration Talk Show, your go-to source for every immigration update. All right, so Rani, lately there have been, a lot of reports talking about the scrutiny, the increased scrutiny at U.S. ports of entry. So, I would like to know from you that what should people expect if they are traveling outside the US? So, with this increased scrutiny, what should they be expecting, and how should they be prepared also?
Right. Well, definitely recently, due to the additional screening and incidents surrounding the ports of entry, as we said, work visa holders are facing those travel issues at the borders. And sometimes having an H-1B approval notice is just not enough. You need to have full knowledge of your petition in addition to what your roles are, your role is, your responsibilities, and you should they could ask you many questions that could include what it could include what where are you working, uh where is your latest show us your latest pay slips. So the type of documentation that we suggest carrying includes, the H-1B approval notice, the last four pay slips, perhaps. In addition to your valid passport, you should present a employer letter that is current and demonstrates a real need for your services immediately. It should outline your title, your duties, your salary, and your responsibilities. That is very important as well. Um, so possibly to also carry, just for your own purposes, in a separate area so that you can access it, a copy of your H-1B petition, which includes your labor condition application. You don't need to keep present it right away, but in the event there's some discrepancy that they're questioning you on, you have the information right there with you. So keep those sorts of things handy, and that's what's important. So as I mentioned, familiarity with your H-1B petition, your position, your responsibilities. And the other issue is that if you have moved locations for your work site, I hope that an amendment petition has been filed by your employer. If it is outside the MSA, which is the Metropolitan Statistical Area. So that's very also crucial that your current H-1B petition filed has has correctly depicted your new work site location, and or if you have had a change in salary, that is a material change. So that's what
Right.
I would suggest in terms of carrying.
Okay. Thank you so much for answering the question. I thought of getting into material change a bit later, but now that you have mentioned, okay, maybe let's just get into that a little bit later, and we can, discuss a little in detail about material change. But now, I would also like to ask you that did you like get a chance to interact with any of your client, and like did they talk to you about what kind of challenges are they facing, and or maybe what kind of questions are these officers typically asking?
Yes, the officers are asking, okay, where's your H-1B approval? Where are you working? Who is your, where's your work location? Who is your immediate supervisor? So the generally speaking, it goes to that route, and everyone's getting through. I've seen challenges in relation to where the officer may um, question further, but if you have answered all of these things fairly fine, and your H-1B petition is in order, that wouldn't be an issue. No, consular issues are more detailed, and we'll be discussing consular issues separately. But at the ports of entry, so far, that's the issue. Now, for travel from Canada and Mexico, we are seeing a greater incidence of refusals for TN visa holders. So, but that's if there is someone new, and if they're a TN visa holder who's been back and forth from Canada and Mexico continuously, um, that shouldn't be a problem. But sometimes they are delving more into details. So TN visa holders also have to be careful and carry, similar to H-1B holders, the similar documents that I just mentioned, employment letter, verification, pay slips, and whatnot. Sometimes we're seeing some challenges to new TN visa holders where they're just not they're outrightly refusing the TN visa. But as we know, there are other reasons at play. potentially due to the political issues with the border. And I suspect, because I've never seen this level or kind of scrutiny between primarily Canada, I think it's really a political. It's along those lines that TN visa holders, new TN visa holders may be refused. But
Okay.
yes, it's in regards to the type of issues that we are facing and seeing with our clients.
Okay, but then having H-1B approval notice, is it like enough these days?
Uh, as I said, that certainly to keep your petition with you in a separate area envelope, and it's not enough. It is just not enough. But I think that if someone is very confident, and it's also your approach and your demeanor when you're approaching a port of entry officer, you have to have a little bit of confidence also when you are approaching the officer, and hi, how are you? Be a little more uh, engaging as well, because sometimes it's your demeanor that can set things off. If you approach the officer scared and anxious, that's going to carry over. So that's also important too. But as I said, pay slips, employer letter. You don't have to carry your degree certificates. That's not required because you have an H1 for a certain number of years. But certainly, that sort of documentation is a must for sure.
Okay, right. Thank you again for answering the question, Rani. Guys, I hope you're enjoying this conversation. If you are, make sure to hit that like button, share this video with someone who you think can take can help someone. So make sure you subscribe to our channel, follow our handles, and also like this video. And Rani, coming back to you, I would also like to know from you that if, let's say, if someone has changed their location and has maybe forgot to file an amendment, so what could happen to that person at the border?
It's the question becomes whether he or she is questioned about their location, and um, if they if they're hesitant, there's only certain information an officer could have. I think the initial screening from a consular, from a CBP officer or at the port of entry is just focusing. I think it's about the demeanor of the person. It's seeing whether there seems to be something that's off. And then you go into secondary screening. So if you surpass and bypass the first screening, then there's no issues. If you're going to secondary screening and there's not an amendment petition filed, we're going to have some trouble. And they could very well say that we're revoking your H-1B, or that we feel that you have failed to maintain your status. And at that point, it's possible you could be refused entry and sent back on the next plane the same day or the next day back to your home country. So it's a secondary screening that has the detailed review and scrutiny of your actual petition, and it's not the first. And
Okay.
then that could be detrimental.
Okay. All right. Rani, also, I would like to tell you that a lot of people have joined us, and they have also started posting their questions. So let me quickly say hi to all of them. Hi, Robinson. Hi, Sakshi. I see your questions, and I'm definitely going to take them in a bit. But also, make sure to like, share, and subscribe to our channel. And yes, please give us some time. I'm definitely going to take your questions, but I still have a lot of questions prepared for Rani. So let me just complete them quickly. And yes, after that, I'll directly dive into yours. So, Rani, again, I would like to come to you and ask you that you already have informed about the documents that people need to travel. So but still, for our new joinees who maybe have skipped that part, or who are not able to watch that part, so I would again like request you if you can please talk about the necessary documents that people need while traveling, and also they will need in case they are re-entering the US.
So in terms of re-entering the US, as I mentioned, those specific documents apply again. Um, when you're traveling, as I said, I think that when you're traveling in and outside the United States, you need to carry that full set of documents. If it's the W-2s, your pay slips, your employer letter, confirming the need for your services, it confirms your job title, your salary, your duties, and even potentially also your location of work. So those type of documents would be crucial and necessary in addition to your H-1B approval, of course. If you're a dependent, then uh, I would carry a copy of your marriage certificate along with any birth certificates related to your children. That's what I would also carry.
Okay, all right. So, guys, make sure that you have all the documents if you're planning to travel. And yes, I think these documents are really important for you. So, make sure that you have the original and also the copies of all these documents with you while traveling. And now, Rani, I would like to talk about. We talked about changing the location. Before this question, you helped get an answer to that question. But now I would also like to talk about, if someone has forgotten to, update their address, then why is the AR11 form so important, and who exactly needs to file it? So if you can also talk about that a little bit.
So the AR11 form is required to be filed by any non-immigrant of the United States and including a permanent resident of the United States. The AR11 form is an electronic form which requires the United States Citizenship and Immigration Services requires you to update your your latest new address, the new address that you have moved to, and it has to be updated within 10 days of your move. If you fail to do so, it could result in fines and potentially even greater problems, as you're aware of the immigration center climate in this country at this time. So if the law tells you you have to update your address within 10 days of your move, do so. Work visa holders, B visa holders, F1 students, any other kind of work visa holders, H1s, L1s, EOs, you all have to update that. Permanent residents, even, can you believe it? Permanent residents still have to update their addresses as well. So you would do that for yourself and each of your family members. And it's in a form that's available online, the AR11 form on the uscis.gov website. So it's fairly quick. When you also do that, make a printout of it that you've completed it and it's been submitted, and hold on to that, scan and save it for yourself. That's important as well. We're not sure if you fail to do that, if you fail to file the AR11 form, at this point, you never know what could be the consequences if they are greater. Right now, well, we've never heard of someone in trouble due to failure to file the AR11 form, but do you think that in this climate that you should not file it? That's the question.
Wow. Okay. So, a really challenging times, people are going through. But hope everything goes well for everyone, and hope good times are ahead. Is all what we can hope for, right, Rani? But then again, I have a question for you. So let's say if someone, forgets to update or maybe file the form, and like what could happen if they forget to do it within 10 days? So are there like
So
bad consequences or repercussions?
right. So, I mean, there are fines associated with that. And as I said, we've not heard of anyone, I haven't heard of anyone really having a trouble with that just yet, but you never know when. And you don't know also because the law changes so rapidly that where it could become a greater problem if you fail to file the form. So I don't want to speculate as to what the potential consequences could be, but right now, it's typically supposed to be a fine of some sort.
Okay, wow. Thank you so much again for answering the question. And Sanjay has also joined us. Hi, Sanjay. I hope you're doing good. And also, guys, do let us know where are you guys joining us from. So please also let us know your locations too. And meanwhile, Rani, I would like to come back to you and ask you that could you also help our viewers know, how to file that form, and maybe also tell us that what documents or what proof do they need to file that form?
So it's available on uscis.gov. And the form is the AR11 form. If you just put a search in the website, it'll pop up, and it allows you to file it electronically. It does not require any documentation to be sent in. It's just a form that needs to that requires your biographical information, your name, and then your address, your name, date of birth, and the actual address. So it's something that should take you a few minutes, and it's very simple, and anyone can do it.
Okay. All right. So, Rani, also, lately, one thing that I hear a lot about is stressful visa stamping issues, right? So, like if you make plans to travel, but then there's the whole consulate appointment thing, hanging over your head. So, could you also explain the current procedures and potential challenges involved in obtaining H-1B visa stamping at U.S. consulate abroad?
Yes, we consular processing is always a very is a process that requires careful preparation. The first step is once your H-1B is approved, or the H-4, for a dependent family member, or an L, or any work visa that is approved, the the attorney and your employer has to submit the PIMS notification. The PIMS notification is a entry into the US database, which then updates your H-1B approval and all the details surrounding that, and sends in an electronic notification to the US consulate abroad. So this has to be performed at least 10 days prior to your visa stamping, and it's a job for the attorney to complete. The employer has a duty to notify the law firm exactly when the visa stamping appointment is, and typically will send the appointment notice to the law firm, and the law firm will then submit the electronic notification to the PIMS database. Once that's accomplished, then the consulate has verification, not just a document, not just a paper from the individual, but an electronic official notification from the government, from the immigration office, that this work visa has been approved, and hence then you can proceed with your interview. Now, oftentimes we see that many individuals opt for the Dropbox, and the Dropbox is where you can actually just submit your passport with certain documents to support your visa. And typically, many have been getting their visa stamped through that process. Now, we are seeing sometimes some incidences of the 221G notice being issued, which is a notice for administrative processing. So that is where the visa is actually refused under the section of the US Immigration and Nationality Act, which states that no visa can be issued unless the application is complete. And the application will now be reconsidered when administrative processing is complete. So this then they issue a notice with the 221G stating the type of information that needs to be clarified in order for this visa to be issued. Now, the list of information that may be required for the 221G consists of, they may ask for your W-2s for all your years, your latest several pay slips, of course, your H-1B approval. They could ask for verification of employment and the location of employment, and or the client, if it's a tech related case, of where the individual is working. So it could be a number of things. It could be also information about the company. They could ask for the company's financials, and they were doing so mostly in the past, over several years ago. However, today now we're seeing just the focus on the individual and his or her employment with pay slips and verification of who's his supervisor, what is his role, and that might be a proper detailed employment letter identifying and confirming the details surrounding the H-1B petition. So uh, while when they are appearing for visa stamping, similar to the whatever you're carrying to come to the United States, it's the same type of documentation that you require in general when you're appearing in visa for visa stamping. The H-1B approval, the pay slips, your W-2s, your employer verification letter, and be very familiar with your job duties for your position and where exactly you are located, where you are working.
Wow. That's a really detailed and a very insightful answer. So thank you so much for that detailed answer, Rani. I'm sure it helps our audiences and our viewers a lot. Also, I have one more question for you. Are there any countries that are, that you feel, or consulates that are generally more efficient or travel friendly for this process?
Uh, I think that any country other than India is travel friendly, frankly speaking, because sometimes people who appear for consular processing, they maybe they're Indian nationals who are in other countries. They tend to, if it's the Saudi Arabia or the UAE, even the UK. I've never seen problems in any, frankly speaking, in most of the other countries, with the exception of India, um, and perhaps China as well. Uh, but yes, I didn't see many issues at all in the other countries, frankly speaking.
Okay, wow. Um, Thank you so much for that amazing answer. I don't think people must be expecting this answer, but then, it is what it is, right? So thank you so much for clearing that out for the audiences too. Rani, this reminds me of one of the call that I got, during the weekend, this last weekend. So one of our viewer actually recently called in with a very important question. So he said, let me read out what exactly he said because I have written it. He said, I'm an Indian citizen, and while my H-1B visa stamp has expired, I do have a valid I-797 approval notice that runs till 2027. So he was asking that, do I really need to go back all the way to India, or can I just go to Canada or Mexico instead? So I told him that I'm going to take his questions in one of our shows. And yes, we are having this show with you. So I would like to ask you, and I think his name was Nilesh, and I think he must have joined us in today's show too. So if you can help him get an answer.
Right. We typically haven't seen issues related to H-1B holders whose H-1B visa has expired, but have a new additional time on their H-1B with a new employer or an extension. They have been typically able to appear for consular processing at the Canada and Mexico, either at their port of entry, at the consulates abroad. So at the consulates in those countries. So I've not seen any refusals recently. So I think that that's still viable, but I can double check, if there's any new policy issues. But I don't think there should be any major issues related to the fact that the consulates would continue to entertain the visa holders for foreign countries, for US visas abroad, for the visa stamping. But it remains to be seen. This is a period of change at this time, so one can inquire with the consulate directly. There's way to and see if they will entertain. But
Okay, I think there's a small technical error. So, no problem, guys. And Nilesh, Rani will be answering your question. And I still have another question prepared related to your situation. So, make sure that you're stay tuned with us. Um, okay, so I think Rani is back. All right, okay. Rani,
uh-oh.
yes, you were saying. Please tell.
Krish, Krish.
Okay, I think she's trying to set her audio and video properly to give you better answers and great answers. And Nilesh, she'll be answering your question, but make sure that you have subscribed to Immigration Talk Show, and also share this with your friends and families and relatives who you think can benefit from all this information and from this live show. So make sure to share this video with them. And yes, I think Rani is back. Rani, can you hear me and see me fine? Okay, can you hear me? I okay, but then you're not audible for some reason. I think. Are you on mute? No, I think not. Can you hear? Okay, there's still some error with the audio. Maybe if you can check that. Okay. Guys, what we can do is maybe we can quickly go for a short break, and we have a lot of questions lined up for Rani to answer. So I'm going to take all these questions after the break. But for now, and also you can give us a call on the number 425-436-6335. You can dial the access code, which is 988888. So make sure to give us a call, post your questions in the comment section, and yes, we'll be here waiting for your questions. So let's take a quick break, and yes, you guys stay tuned with us, Immigration Talk Show. Okay, that break was a little too long, right? But maybe that's something we also need sometimes in life too. A little longer break. Okay, guys, welcome back to Immigration Talk Show. I'm Rajni Bharara, your host, and today I have with me Rani Imandi. So, yes, if everything is all set, I would like to welcome back Rani. Rani, can you hear me fine, see me fine? Okay, I again, there's some audio issue. Okay, I think there's still an audio problem. So if we can fix that, I wish, guys, I could answer all your questions because your question seems amazing, and we are also really waiting, to hear from you. So you can give us a call on the number 425-436-6335. I'm really waiting for that call. So pick up your phones, dial this number, and give us a call on the number 425-436-6335. Yes, I'm Rajni Bharara, and we are Immigration Talk Show, your go-to destination for any immigration related problem. So give us that call and ask your questions from the attorney. It's and I mean, by now you must have already realized it that it's an amazing platform to get all your answers and confusions clear. So yeah, pick up your calls, pick up your phones and give us a call. And I am going through your questions here. And I also have the questions from Facebook too, which I'm going to ask from Rani. I'm really waiting to her to be back and her problem to be fixed. I think she is facing some technical issues. I think technical issues are something that everyone has, like, goes through in day-to-day life, right? But what is life without problems? So yeah. Okay,
Yes,
I think
don't.
Rani is back. Rani,
Yes, can you hear me?
finally. Okay, yes, I can hear you fine, and I think so can our viewers too. Okay, I think okay. Everything is fine. I think the audio is also fine. The video is also fine. Yes. So Rani, you are answering Nilesh's question about can he go to Canada or Mexico?
Yes. So as I stated that it's possible so far, we haven't heard anything negative about it. So I think it's something that you can try. Email the consulate first for that verification and take all the steps for the visa appointment, and then you should be fine.
All right. Okay. Great. So also, I would like to know from you that uh, okay. Also, Rani, is self-sponsorship possible? I mean, through their own company. I mean, do you think it's a viable path?
Yeah, so the great news with the new H-1B modernization rule that and policy that was implemented on January 17th of this year indicates that an H-1B individual, if they're running out of options, if they can't find their own employer and they want to maintain status, for instance, when an H-1B individual is has been terminated, you only have 60 days grace period to find another job. So your last paycheck, if it has a date, from that date, you have to file another H-1B within 60 days of that date that you cannot during the period for which you don't have employment. It's maximum of 60 days. Once you file that, you're good to go. So however, what if you don't have a new employer? It's not easy to find a job in 60 days. So one way is to actually self-sponsor yourself on an H-1B, and you can actually own that company. This is the great news about this. Of course, who's going to pay your salary? It's got to be either you or your partner. So if you're able to open a company with a partner or some partners who can then help you get sponsored, you can sponsor yourself on the H-1B. But of course, your role on that H-1B has to be in line with the petition and that role specified in the petition. So for instance, if you are the director of technology, that you're going to be paid accordingly. And you will then also have to perform those duties as a director of technology. So the great news about that, it's possible now. In the past, you could do it, but it's very specific about the fact that if you had some ownership in the company in the past, you could not be a director, you could not be directing the company. There had to be a separate board from you. However, now the the position is much great. It's a great opportunity for individuals to actually have this additional H-1B. For instance, you can be full-time on one company, it's H-1B, where you get your steady pay. And then say you start a consulting company, you can actually start the consulting company, but you need to, you can't just start a company by yourself. In other words, you can, however, you have to sponsor yourself on that H-1B because your employment has to be authorized, always authorized in the United States. So you can have that company and then you can be part-time on that company. You could be the director of technology for 20 hours. So it's definitely feasible. The H-1Bs where you are being sponsored, you're sponsoring yourself through your own company, they're only valid for up to 18 months at a time and renewable for another 18 months. So those are the conditions for those, that H-1B, but it's a great option. At
Okay.
least it's, people in the past, I've seen situations where, some individual, ran his own company. And then when he went for adjustment of status, went for adjustment of status, the adjustment of status was denied because he had started his own company and never, it was unauthorized work. So unfortunately, that was in the past, many years ago. But the point is that they they don't have that fear anymore, and you can have this great opportunity here right now.
Okay, thank you for answering that question so brilliantly. And I have so many questions coming in my mind that I would like to ask to you. But then we have so many pending questions, and we don't have enough time. So I'm thinking that Rani, this sounds like a great topic. How about and I want to dig deep. So maybe how about we dedicate one episode to this topic and maybe completely talk about self sponsorship.
Yeah, sure, we can. Absolutely. I'll be happy to share any information that I can for that.
Okay, because a lot of questions about finances, documents, so many things are coming in my mind, and I would like to get answers to that. But I don't think so. This show will be enough to answer all of those questions. So maybe yes, we can do another episode. For now, let's go to our viewers' questions because they are waiting for quite some time now. So yes, Robinson. Is here and he says, I'm considering switching employers while on my H1B, but I'll need to travel abroad in the middle of the process. How does this impact my ability to travel and maintain my status while I transition between companies? What do you have to say?
So, there are some risks that you take when you want to travel abroad, when you are transferring employers. While number one, when your H-1B petition is pending in the United States with the immigration office, the receipt notice, the question then becomes, when is your H-1B visa actually that's stamped in your passport valid till? So you can only re-enter the United States with a valid visa stamp. So make sure it's good for up to 6 months before your entry back into the country. And it's now with a new employer. It's okay if the old visa has the prior employer's information, that's okay. Now, the other issue, however, may be the fact that what if you're not on good terms with the prior employer and the prior employer withdraws your H-1B visa petition? Well, that could affect your ability to enter the country as well and your H-1B visa. So that's a challenge. That is a risk you take, a chance you're taking, because what if you're on bad terms with your employer and they withdrew the prior H-1? Furthermore, if they withdrew the prior H-1B, then your H-1B, the new H-1B with the new employer will may not be processed for the change of stat, for the extension of stay. It'll be processed for consular processing. So, which means that you may not have an H-1, you will not be able to re-enter the United States. So if you're on good terms with that employer, you can return into the United States on the with the valid H-1B visa stamped in your passport, but and carry your receipt notice from the uh, petition that's pending with the USCIS.
Okay, okay. And Rani, what happens if, like, if somebody gets picked in the lottery and then maybe suddenly loses their job? So, what option does that person have?
Well, if you're picked in the lottery,
Uh-huh.
There's two scenarios, and say the employer does file for you, but then after the H1's approved, you don't have, they say, well, we don't have that job, but it's not no longer available to you.
Yeah.
The good news with a situation like that is that you are now, your H1B has now been counted against the H1B cap. And hence, you can actually have any other employer file for you as soon as possible to then work with that employer. Um, so that's the good news, that if you, the most important thing is to try to get that H1 filed. And even if they say that the position is not available, then you're at least counted against the cap, and you don't have to go against the try each year for the H1B lottery. Now, if the employer does not want to file for you after your H1B has been selected in the lottery, unfortunately, you you're out of luck, and you're not going to have an H1B that has been selected against the lottery, and hence you will have to try for the lottery the following year.
Okay. All right. Thank you again for that insightful answer, Rani. And guys, if you're enjoying this discussion and this conversation, make sure to hit that like button, share this video with someone who you think can benefit from this episode, and also make sure to subscribe to Immigration Talk Show on all the platforms, LinkedIn, YouTube, Facebook, X, and also on Instagram. And yes, you can, if you have, if you'd like to directly get in touch with Rani and would like to consult Rani for any problem or any challenge that you are going through in your immigration journey, you can give her a call on the number 212-686-7782. Yes, 212-686-7782. You can also email her. Her email ID is rani at emandi.law.com, Rani at emandilaw.com. And you can also visit her website, which is www.emandilaw.com. So yes, make sure to get in touch with her. And now let me quickly take Rani. I know we only have like 4 minutes left, but if you have some time, can we extend the show for?
Absolutely.
Okay.
Absolutely.
Thank you so much for that. Okay. So Sakshi's question, let me quickly take. She says, if an H1B visa holder travels abroad and their visa is revoked or cancelled due to a perceived abandonment of their US residency, what are the chances of successfully arguing that individual maintained their non immigrant intent and thereby avoiding a finding of abandonment? And what specific evidence or case law would support this argument? Okay, too many questions there, but if I think I should take one by one, right?
Well,
So,
yeah, but the first question, the first part is that it doesn't make sense. It's not clear, because if the H1B is revoked and she's asking about the fact that they've abandoned their residency, that has nothing to do with it. So that doesn't make sense. So can you please ask them to clarify? Because that's a question, like if you're a permanent resident, you're abandoning your residency, that's where it's relevant. But you don't abandon your residency with an H1B, you're a non-immigrant. There is no expectation for you to have a residency in the United States. So
right.
it's not clear.
Okay, so Sakshi, if you can please clear that out for us and maybe reframe your questions or try to tell us what exactly are you trying to say.
Yeah.
And yes, and please,
Because if you're, I'm sorry, Rajni, because if your H1 is revoked, okay, so game over, it's revoked. However, you can always find a new H1B employer. If you're in your foreign country, in your home country, a new employer can file for you, and it'll just be for consular processing. It's just that you can't, you're not going to be permitted with a revoked H1B. You just have to wait in your home country for a new employer to sponsor you. And it would be a new H1B for consular processing, but it's not subject to the quota, as you know. So
right.
that's just the answer to a situation like that where an H1B is revoked.
Okay. All right. Thank you for clearing that up. And Sakshi, please make sure to, maybe try to reframe your question or try to tell us what exactly are you trying to say with your question, and can continue posting your question in the comment section. We are here to answer that. And make sure to subscribe to Immigration Talk Show. And yes, also follow us on all other platforms, LinkedIn, X, Facebook, and also on Instagram. We are Immigration Talk Show. And I hope you're enjoying our conversation. Rani, let me quickly take Sanjay's question too. So Sanjay says the Trump administration's history of restricting immigration policies, or what are the potential consequences for H-1B visa holders who travel abroad for extended periods, and how can they overcome the risks of visa denial or revocation upon re-entry, especially if their spouses who are on H4 EAD who may lose their work authorization. And because I asked him if he can tell us his location, so he said, "Hi, Rajni and Rani, I am from Bangalore." So he's watching us from Bangalore, and this is his question. What would you like to tell him, Rani?
So if there are some extended periods of time that an H-1B holder needs to travel out of the United States, what's crucial is that number one, there should be documentation on record that you've taken, if, for instance, it's personal leave, say some family situation has arisen. So make sure you have a documentation that you've taken personal leave and that your employer has approved that leave. So it's almost like a leave letter, which outlines your dates for your personal leave, and that the employer is going to also has approved of it for that period of time, and then the expectation as to when you're going to return. Number one, um, and then secondly, what's important perhaps is the question is to clarify whether you will continue to receive salary during that time or not. Because if you do, that's great. If your employer and you have an agreement that you're going to work potentially from abroad, or you continue to get paid, that's also great, because then that's going to show your continued employment with your employer. Um, so primarily, those are the two things. In terms of the H4 visa holder, everything is any dependent, be it a spouse or a child, is contingent on the principal's status. It's all about the principal maintaining status. So everything follows from there. If the principal's not maintaining status, the H4 dependent is not either. So, but that's why if the H-1B individual needs to have proper documentation related to the personal leave.
Okay. All right. Sanjay, I hope you've got your answer. In case you have, please let us know with maybe a yes, I have in the comment section. And if you have a follow up, you can also continue posting your follow up. And if you would like to join us on call, you can dial the number 425-436-6335. And don't forget to put the access code, which is 988888. And yes, also do subscribe to Immigration Talk Show. Rani, we still have a lot of Facebook questions lined up for you, which people have posted in multiple Facebook group of ours. So if you allow, I would like to share the screen and
Please.
read out those questions for you.
Yeah.
Okay. All right. So this was posted by someone, an anonymous viewer, on yesterday at 11:26 a.m. And he or she says, "Hi everyone, just had a green card interview for my mom today. Me as a sponsor at Santa Ana office. The interviewer said at the end that she thinks there is no problem, but she has to review it with the supervisor. How common is that decision is not made on spot after the interview?"
This is fairly standard.
Okay.
We hear it all the time. It's very rare, actually, that we see these since the last few years, that an individual says, "Oh, it's approved. Your case is approved." It does happen, of course, but it's very much more standard. It's this is the norm that you will hear. We have to, we'll get back to you. I'm just going to review this last bit of information. It could be that maybe the officer is new and they have to check with the supervisor. So don't read anything into it. This is normal. So do
Okay.
not worry.
Okay. So there's nothing to worry about then.
Yeah, I've never seen any in my almost 3 decades of practice. I've never seen a when a child sponsors a parent, or a parent sponsoring a child being refused. Everyone gets their green card. Now, the only reasons you could be perhaps refuse is maybe for the financial reason that you don't have the ability to pay. But again, I've never seen that. So don't worry, I'm sure it'll be approved.
Okay, so then can I say that the news is almost like 99% good?
Okay, you said it, not me. I don't want to say
Okay.
anything.
All right. Okay. As a host, I can. Okay. All right. Let's be hopeful.
Yes.
And for this anonymous member, and okay, someone on LinkedIn has commented if checks. Okay. If checks if your job is legitimate and matches what's on your petition. I don't quite
What was the
understand.
first part?
There's no
If
first part actually. It's just that this person says it checks if your job is legitimate and matches what's on your petition. Is it an
okay,
answer or is it
yeah,
a
it doesn't
question?
look like it's much of a question.
Yeah.
Yeah, I mean, it's standard that your job should match your petition. That's standard, yes.
Okay. All
Yeah.
right. Thank you for so much for that comment. I can't see your name, but thank you so much for posting that answer or comment. Thank you, and also for tuning in to Immigration Talk Show. Make sure to follow us on LinkedIn and subscribe to us on YouTube and also on all other platforms too. And Rani, there's other questions also. There are other questions too. So maybe Control, if you can quickly share the screen. Okay, so this is by Darshan Patel, and he says, "Hi everyone, I submitted I-130 paper based on April 1st, 2024, and since then the status is online portal has never changed from your case was received and notice of receipt was sent. Is this normal? As I see a lot of people in this group and elsewhere already getting case being actively reviewed in a few days after the submission. Please advise. Thank you. What do you have to say to Darshan Rani?"
Uh, Hi, Mr. Patel. What we see is that it's actually standard for the receipt notice, the status online to just say pending until final review. An I-130 for a family member, typically if it's your sibling or your parent, can take over. First off, specifically, was it for his parent, Rajni? Who was it for?
I don't think so. It simply says that I submitted I-130 paper.
Okay.
Yeah.
Okay. So typically it'll take a year and a half. The current processing time for I-130s is about 18 months on average. So nothing's going to change until you get closer to that time. So if he was April, we're just now a year away. So he's probably going to see a response within the next 4 to 6 months. So nothing will change until that time, unless a request for evidence is issued. And a request for evidence means the immigration office requires more information on this. And that's what could be the issue. But other than that, nothing's going to change much. 18 months is your mark. And there are thousands of cases. So when the USCIS gives an average processing time, they're saying the average. There are thousands of cases under, there are thousands of cases over. So no one should ever, you have to be flexible with the number of months. It never means just that period of time.
Okay. All right. So, Darshan, I hope you have got your answer. If you have, yes, do like this video. And also, if you have any other problem that you're going through related to your immigration case, you can directly get in touch with Rani. Her contact details are already scrolling below, but I would also like to read them out for you so that you can write it for yourself and give her a call. Her telephone number is 212-686-7782. Yes, you can give her a call on 212-686-7782. You can email her. Her email ID is rani@imandilaw.com. You can also visit her website, which is www.imandilaw.com. Okay, all right. So let me quickly move to our next question from the Facebook. And this is from Chloe. So Chloe says, on form I-765, do I have to write NA in all the blank spaces? Some people have told me to leave blank spaces, and some people have told me to write NA.
I think that it is, if it's not relevant, it doesn't hurt to write NA. Just this way, you're very clear about what applies to you and you don't want to make any mistakes. So if it doesn't apply to you, write not applicable, N/A. That's fine.
Okay. All right, so I think Chloe was the name. Hi, Chloe. I hope you've got your answer. In case you have, yes, make sure to like, share, and subscribe to Immigration Talk Show. Um, okay, another question. I see one question from LinkedIn too. So maybe let's quickly take that first. So, Control, if you can please tell me the name of the viewer because I can't see it here. So the person says, can you explain the chain of command between your H-1B petition employer, any middle vendors, and the client? Why do you directly report to? Who do you directly report to? And how is your work monitored? Okay, yeah. And his name is Malika Arjun. So the question is from Malika Arjun. Rani, what do you have to tell him?
What was the first part of his question? He's asking
Can you
under
explain?
what circumstance? Okay. Uh-huh.
Can you explain the chain of command between your H-1B petitioner employer, any middle vendors, and the end client?
Well, from an H-1B petition perspective, as that's all I'm going to uh, as that's what I am going to focus on, is that the employer, you would have to have your supervisor be your employer, and that's the way it has to be documented. Because if the client is supervising you, that is not something that you bring to light. The focus is the fact that the H-1B employer is their supervisor. You report to the H-1B employer. You turn in your timesheets to the H-1B employer. Then forget the middle vendor. That's nothing. That's just a contract. The end client is just where you perform the work. You might have a point of contact to the end client, but they're not really supervising you. Rather, it is just you are supervised by your employer. So that's the way it has to be documented, and it should not be presented any other way, be it to the consular officer, to anyone at the port of entry. It's your employer, your supervisor.
Okay, and the second part says, who do you directly report to and how is your work monitored?
Everything's monitored by your employer. That's where it has to be presented. Otherwise, then they can poke holes in the petition and say that, well, then that's not your true employer, and then you're being supervised by the end client. Now, the H-1B modernization rule did issue new policies about the fact that since the past decade or several years, the employer had to demonstrate that they were always supervising the employee, and you'd have to, when you filed an H-1 petition, the employer had to provide specific documentation demonstrating that the employer is supervising the employee even at a client site, and you'd have to indicate how they were supervising. There were numerous requests for evidence based on the fact that um, who is the true supervisor? They're trying to get you to say, they're trying to verify who's the supervisor, and if you say to end client, the case is going to be denied. So, however, the policy just recently in January that was issued with the H-1B modernization rule does not focus. They've taken out the supervisory requirement out of the H-1 petition in the sense that you don't have to demonstrate it all the time. However, the policy remains the same, that your employer needs to continue to be your supervisor. So I hope that's clear.
Okay. So Mallikarjun, please let us know if you have got your answer. And if you have a follow up, you can continue posting the follow up in the comment section. And yes, if you got the answer, make sure to like this video and also go on YouTube and hit that subscribe button and also turn on that notification bell so that you're notified with more such shows. Yes, thank you so much for being here. And let me quickly again share the screen and show those Facebook questions. Okay, so this next question from Facebook says, my mom is a green card holder and she applied for my younger brother who is 21 now. Do you know how much it will take to complete his case?
That's if there are two different categories. If a child is 21, if they're greater than 21 and or married, there are two different categories under the visa bulletin. The visa bulletin is the US Department of State's um, update for different categories of green cards filed by different individuals. For instance, if it's a green card holder sponsoring your sibling, that's a different category. There's the F1 through the F4 categories, and each of them have different time frames. The categories, so there's siblings, there's the green card holder sponsoring their child over 21, or married child falls into a different category. So the or green card holder sponsoring your spouse, those dates are not current. There's actually a little bit of a backlog by a few months for different countries. Each country, the national of each different country has different backlogs and processing times. For instance, um, the nationals of India, China, Mexico, and the Philippines
Mhm.
all have greater backlogs due to the fact that the United States has received the highest number of applicants from these countries: India, China, Mexico, and the Philippines. And that's why Indian nationals, your period of time for immigrant petitions for family members sometimes can go to 2, 3, 4 years. I don't know that number right off the bat. I'd have to look at the visa bulletin, which I don't have in front of me, but we would look at the US Department of State visa bulletin for every month for the month of April. So other than those four countries, the rest of the world is actually quicker because they don't have those backlogs. But if you're an Indian national, we would just have to check which one they fall under. And the every month the processing times change. That means that they're saying that if you filed your case a year from now, now that date is current. So once the date is current is when the person can appear for their consular visa processing or apply for their final step of the green card here. So that's the process, and you'd have to check the U.S. Department of State, and it's very clear, it tells you which category you fall under and which date is being processed. So you take the difference between the date you filed a case and you look at the bulletin and you see what cases are they processing currently, and typically they're always behind. So then you know, you take the difference between that the date they are processing currently and your date that you filed the case, and that's how much time you're going to have to wait for that to be final for them to receive their green card.
Okay. All right. Thank you so much, Rani, for answering that question. I think we are done with today's questions, line of questions. So we still have some, but how about we take them in another episode that we already have planned?
Sounds good.
Okay, so thank you so much, Rani, for being here. It was amazing and lovely having you, and your answers were amazing, insightful, detailed. So thank you so much for those amazing answers too. And yes, we already have decided the topic, what we are going to talk about in the next episode. So yeah, okay. Malika Arjun is here and he says, "I'm not clear. Can you please give me some more elaborate? What would you like to know about Malika Arjun? If you can also tell us that what
He
more
can send me an
elaboration do you need
email
about?"
too. Rajani, he can send me an email and
Right.
we'll be more specific at that time. Yeah.
Absolutely. So, Malika Arjun, what you can do is maybe give Rani a call on the number 212-686-7782, or you can also send her an email. Her email ID is rani@emandilaw.com, RANI at EMANDI law.com. And you can also visit her website, www.emandilaw.com. So she'll be able to help you with all the confusions or all the questions that you have in mind. Right. And guys, you can also, reach out to Rani for a detailed consultation regarding your cases. Make sure you do that. You already have heard her brilliant answers. So yes, she can be your, like we are your go-to source for all the immigration problems. She can also be your go-to source for your immigration case. So make sure to give her a call, send her an email, and check out her website. And yes, with that, don't forget to like our video, share this with someone who you think can benefit from all Rani's answers. And yes, subscribe to Immigration Talk Show on all the platforms. Rani, like I was saying, it was lovely having you here. such an insightful episode, such a brilliant episode. I would say a blockbuster debut, rather. So, yeah, hoping to see you real soon.
Thank you so much. It's been a pleasure. And if I can just say hi to someone real quick. Hi, mom, dad. Thank you. Thank you very much.
Thank you so much. That was such a lovely thing that you did at the end. So okay, I think I should also say hi to my mom and dad. So hi, mom and dad. I hope you are doing well too. So yeah. So yes, thank you so much for being here. Can't wait for another episode with you. Until then, please take care of yourself and yes, have a great rest of the day.
Thank you.
Okay. All right. So, guys, I'm Rajni Barara, and we are Immigration Talk Show. That's it from our side. Hoping to see you all real soon. We have another amazing show lined up at 4 o'clock, Daily Immigration Dose. So don't forget to tune into that and drop your questions in the comment section. There, that's a discussion show where Nipasa and Sam they both join, have a healthy conversation, a great discussion on our decided topics. So don't forget to tune into that. And yes, for now, I'll have to take your leave. You guys have a great weekend and take care of yourself. And please don't forget to subscribe to Immigration Talk Show. Take care.
Hey everyone, welcome back to Immigration Talk Show. I'm your host Sam, and we are live right now at 2 p.m. EDT on YouTube. And I'm so happy to have you all here, and thank you so much, guys, for joining us on this platform as we are back again with another very exciting and very insightful session. And before diving in, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information at your own risk. All right, once again, friends, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And so happy to have you all here. And also, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So, do follow us on these many platforms. And if you haven't subscribed to our channel yet, then do it right now because we come up with latest updates and also some amazing webinars. And similarly, we do have this webinar today on the topic H-1B visa myths versus reality. What is the truth? That sounds super interesting. Also, with the guest whom we are going to have this session is also very, I would say, energetic and very much bold in her statements. So I'm really happy to have her here again, and let me welcome attorney Nandini Nair, who is a partner at AY Strauss and leads the immigration practice with over 25 years of unmatched expertise. And her insights have been featured in the New York Times, CNN, Bloomberg, and more. And she is being recognized as a trailblazer in the legal field. So, hi Nandini, and thank you so much for being here with us. It's really our honor to have a show with you.
Thank you so much, Sam. I really appreciate asking me back. I'm glad the last time went well, and I'm happy to be here.
That's great. And in fact, we all are so happy and excited for the show. And this is the second time that we are meeting. So thank you so much again for joining us. And I'm sure our viewers are excited for this session because, Nandini, whenever we talk about myths and facts, we have multiple questions. I mean, there's no limit to it. So many myths we didn't even, understand, like, oh, are these myths? So it's like going to be really exciting. And before diving into the topic, if you could please give us a brief what our viewers can expect from today's webinar.
I think the big overall thing today is to break down what is actually the reality, right? I know that there's a lot of forums out there, WhatsApp groups, Telegram, where a lot of information gets jumbled and it's very wrong, inaccurate, misinterpreted, and it really creates a lot of turmoil and probably issues for individuals. So the goal today, let's break down some of the myths. Let's break down and show you what actually is the reality. Is there possibilities? Is there none? So that you have an accurate picture of what you isn't there in store for you tomorrow. So that's the goal of today's show.
That's right. I think it's really going to be very insightful as you are going to separate facts from fiction. And this is what we all need. So I think without any further ado, Nandini, let's go ahead with my very first question. And this is a very important one because, you have so many years of practice and you have been with so many people around there. So,
Mhm.
according to you, which is one of the biggest myth about the H-1B visa that you come across often in your practice?
One of the biggest myths I would say is, outside of people who use the program or understand the program. So a lot of people think the H-1B program is used by companies to bring in cheap labor, right? Foreign labor, right? They're underpaid, they're working, 60-hour weeks, all of these type of things. That's the common mentality, scenario, perspective of individuals who are not in immigration, who don't, use foreign talent. So, and again, that's an absolute myth. So we're talking reality. Majority of professions in the H-1B program are actually paid incredibly high compared to an average US worker. Now, if you go to San Francisco and you look for a job as a software engineer, for example, you are making over $100,000, maybe $150,000. I mean, at a base level, that's what an entry level H-1B person can work at. It has to work at. So how is that cheap labor? Cheap labor, I would say, is somebody making less than $60,000. That's cheap labor. So there is an absolute myth across the country, that this program just brings in these individuals and they're being paid, $10 an hour, and it's not regulated. It's not, there's not compliance, and it's a complete abuse going on. And that is actually false. Now, I'm not here to say that there isn't abuse in the program. Every program you name out there, whether it's Medicare, whether it's, the education, anything, there's going to be a small element of fraud in it or misrepresentations. And the H-1B program is no, better than that. But the thing is that there are so many legitimate people. There's so many legitimate employers. There's so much that is right with the program that people just don't understand. They just fall for that myth. This is cheap foreign labor, and that we should eliminate this program because of that. That's the number one myth I here all the time.
Wow. Thank you so much, Nandini, for putting that up. And I think it was very important. Of course, cheap labor, we all have that thing in our mind. And most of the time, when we also hear from most of the workers themselves, then they also put up these point of views. Of course, different people have their own opinions, but it makes creates a lot of confusion with that. And of course, you mentioned it clearly, it's nothing about that.
Mhm.
So that's really good, and thank you so much for just clearing up that very important confusion. Okay, so let's move ahead with the next very important question, and that is about green card.
Mhm.
So Nandini, many believe that the H-1B path is directly connected to green card. If you're going to get H-1B, you are going to get your green card. So is it true, and how accurate is that assumption?
Well, if there was such thing as a guarantee in life, I would be a millionaire. There is no such thing as this. Okay. No, you cannot. Just because you come here on an H1 does not guarantee any sort of pathway to a green card. Because you know why? It's not in your control. It's up to an employer to file for you. And even along the way, there's so many steps involved. It could get denied. The employer can withdraw it at some point. You may move to another job. There's just different things that can stop and put hurdles up where there is no green card at the end of the day for you. Now, the good thing about it is, yes, is there a pathway? Absolutely. There is a path once you come here. If you have an employer who's willing to do that for you, they follow the correct steps, they have a good attorney on their, helping them through this process. Yes, there is a pathway to the green card. But is it guaranteed? Absolutely not. Immigration is not something that is a guarantee in life at all. It is something that has to be evaluated, looked at based on the current law, not what was happening 20 years ago, right? So it's an evolving and fluid situation always. So don't fall for that. Oh, come here on an H, I'm going to get my green card. That's not true. That's absolutely a myth.
That's right. Because so many people think that if they are going to get H-1B, automatically they are going to be a green card, get the green card. But absolutely,
Right.
there's no guarantee. And if there will be guarantee, then everybody will be a millionaire. But that
Yep. I would be, I would not, I would be living like a different life if I could get you. If I said to someone, I can guarantee you that green card, yeah, that would be a different life whatsoever. But no, it's not true. The best part is, like I said,
Mhm.
there is a path, and you have to get onto that path, but there's no guarantee at the end of the day.
Yeah.
So, but at least we have an avenue for you.
Absolutely, and that's very well put up. All right, so let's move ahead with the next question, or I would say next myth. As Nandini, there's a lot
Mm.
of talk that H-1B visa holders are underpaid as compared to the US workers.
Mm.
And this is not only, we have been hearing like from past 1 year, from past 2 years. I would say from the time, people are crazy about for the H-1B. So it's been a very
Mhm.
long time that people are being complaining, I would say, or been saying that they are paying less as compared to the US workers. So what's your call on that? If you could please
Right.
let us know the reality.
I mean, I don't think that's the reality. I think that, we have a wage scale that's mandatory for the H-1B program. It's not that an employer can just pick out a salary and pay the worker that way. No, there are things that are in place by the US government, and not by the employer, by the US government, who've done these surveys, and they say, hey, you need to pay at this level, you need to pay this minimum salary. Now, sometimes those salaries, I will say, are not moving up to inflation and certain standard of living. But regardless, I don't think it is underpaid compared to US workers. So for your viewers to understand that wage levels, where it comes from, the Department of Labor, which runs the labor of us, as employees in the United States, they do surveys every year through sampling of companies. So it's not like the Indian company or the Chinese company is the ones who are providing this data. No, they do their own data survey. And that's where they come up with an average estimation of where the salaries should be for this profession in this county. So there's actually metrics and there's actually data behind that wage that you're seeing on that website. So it's not arbitrary, it's not randomly selected, it's none of those type of things. And when you do a comparison of that salary to a US job, you are going to see it's not equal, it might be slightly better. Are there areas and professions that are going to be a little bit less? But that's data that the Department of Labor said, hey,
Yeah.
that job is not as you're paying this way. So I don't like that talk that H-1B workers are underpaid. I think there is metrics involved and there's boundaries and guidelines and guardrails available. Does it move up based on inflation? Maybe not. And that's what I would give to a foreign worker who's here complaining about the job or complaining about wages not going up enough. Maybe there's some truth behind that, but it's not like the program is looking to do.
Wow, that's great. And I think most importantly, it's about the earnings, that is why the H-1B workers go to the US. And when they says about these things, it really stops the other people also to move to the US, and it demotivates them
Mm.
because they are not ready for these things. But Nandini, I mean, why these confusions are happening? I mean, what do you think? What can be the cause? Why these so many myths are rising for the H-1B?
I mean, I think we have a really big population of H-1B workers now. I've been practicing 25 years. When I first started, this was not a known program like that. I think Y2K, the tech booms and all have created an influx of people. So when you have an influx of people,
Yeah.
they're going to talk, right? And they're going to have a friend of a friend of a friend who had one bad experience. And that seems to set some sort of story or rumor out there in all of these, forums and stuff. Oh, well, this is what's going on. I think I said in the previous show, I joined some of these forums, right, as like a bystander to see what's going on, what's the talk and stuff. And I'm amazed by the misinformation that keeps spreading. And I think that's what's going on, that why people are holding on to these myths and these stories and these rumors, because it's just going like wildfire in a lot of these WhatsApp groups and telegrams and stuff like that. It's one person's experience, two persons experience, 10 persons experience. It does not define the program and define everyone in that who's on an H-1B. That part is not being looked at more carefully. It it's kind of like you want to believe the bad, but what about the good?
That's right. So, what message would you like to share with our viewers who are planning to go with the H-1B, or who are experiencing H-1B? Like how they can be careful regarding myths versus reality.
I mean, I think talk to an obviously lawyer. Like one of the things that people don't realize is there are a lot of lawyers who will do free consultations, or they'll do a consultation for $100, $150. And I always tell people, go get that opinion. If you're worried or concerned, or you don't know for sure, do the
Mhm.
consultation. It doesn't hurt you at all to spend half an hour with an experienced lawyer who corrects you. Wouldn't you go do that with a doctor? If you don't feel well, right? You're going to the doctor. And if you get a bad diagnosis, aren't you going to a second opinion? Of course you are. So do the same. This is your life. This is your status. This is your everything. Why not get the correct information? Don't fall for those forums. Go to the source. Ask the questions you want to ask and go.
That's perfectly explained. And I think, Nandini, the way you are saying, it really feels so motivating. I mean, you just look into the eyes and you go on and speak. It feels so good. So I'm sure our viewers are not just, getting the information, but they are also getting that motivation that from now on, they are not just going to sit and listen, but they are also going to stand up and take the actions. Because, creating these confusions are really destroying everything. So these sessions
Yeah,
are really important. And thank you again for your time and for your support that you're here. And with that, I
I
would say,
appreciate
friends,
that.
yeah, yeah.
Yeah, I would tell your viewers like the one of the most important things to me is putting out correct information to individuals. I'm very straightforward. I don't want someone's life ruined because I said something wrong. So I'm very strong about these type of things and stuff. So and I care. I really deeply care about their lives and stuff like that. So for my clients, I want them to do well. So they do well, I do well. You know, I don't want to go home and sleep and be like, oh man, I messed up that case or something. I don't want to do that. You know, that's somebody's life in their hand. You know, in my hands. So that's kind of how I think.
Wow, that's great. And I think that's how everyone should be. And that too, when you are actually, I mean, somebody is relying on you. So I think that's great. And thank you so much, for putting up these very important information. And friends, till the time, we have covered few questions. We also have time, and we have 45 minutes another. So go ahead and put as many questions as possible, because this is the time you can get directly in touch with attorney Nandini Nair, and you'll also get the contact details. That is the best part of our session. That you can see the contact details on your screen: 973-287-0966, or else you can also go ahead and share your case or any doubts that you're having through email. Her email ID is nnair@avstrauss.com, and the website is www.aystrauss.com. So, with that, friends, also don't forget to like, share, and subscribe to Immigration Talk Show, as this is not just the amazing webinar we are having right now, there are more to go. So, to keep you updated with those amazing webinars, make sure to like, share, and subscribe to Immigration Talk Show. All right, Nandini, so I'm loving the conversation, and let's go ahead with another one. There's also a common perception that H-1B workers are tied to single employer and have very limited job mobility. So what's the reality behind it? What options are actually available to them?
I think I'm gonna say it's dual thing, a myth and a reality. Okay, why is it a myth? Myth is no, you're not tied actually to um, one employer. You can move. If you're on an H-1B, it's portable, so you can move from A to B to C to D. You know, whatever opportunities are in front of you, you can absolutely do that. Of course, the challenge is every time you move, that new employer needs to go through the whole process, right, of the H-1B. And where is this the reality that hits a little bit? Because you have to refile, there's always that doubt of whether I'm going to get approved if I file that transfer, right? There's a risk. You know, I'm not going to take that away from anyone to say, you know, it's not a big deal or no, it's a risk, right? Because that petition can get denied, right? So
Yeah.
even though you might have moved A, B, C, and then D gets denied, that's an impact. So there is this nervousness in the foreign national employee population where they're scared to move because hey, I have approval now. I have 3 years on this. I don't want to move because you know what happens if I get denied. And especially you know now we're in a difficult time in immigration. People would be more nervous about moving. So the myth is, you know, I can't move. No, the reality is you can move. You can file. You can move from A to B to C to D, whatever times, how many times. There's no limitation. There's no waiting period. You can do it. The reality is every time you move, you got to refile from scratch. So there's a risk of denial, risk of, you know, some other issue going on every time you do that. So it can kind of create that doubt, whether and almost like a feeling of like I'm stuck if because I'm so scared I don't want to make that attempt. But there are ways around it. And I always tell people, like, don't join the second employer. Like, you know, you want to join until the case is approved. Don't be like moving on top of because you got a receipt notice. Try to premium process the case. So there's ways and strategies to minimize the risk and get it down to as low as possible. But that is where the strategy has to come in from your lawyer to understand how the process works.
That's right. That's wonderfully explained. And thank you so much, Nandini, for clearing up this factor because, so many employers are also there who gets like confusion on this topic as well.
Yeah.
So I hope that our friends are understanding this thing and you can move, but of course, you have to start from scratch. So keep those pointers in mind, don't get confused, and have a proper, clear picture in your mind so that it will be easier for you to have your immigration journey in a smooth and relaxed manner. Okay, so Nandini, as you mentioned about premium processing, also, my next question will be that we have heard about premium processing, right? So, is it something to do with the chances of the approval for the H-1B visa holders?
Okay, I know there's a big myth out there, and it's actually a dual myth. One myth is that if you file in premium, your case is more likely to approve. The other myth is that you file in premium, your case is most likely to be RFE'd, because that clock is ticking on the officer. And both are false. In my practice, I have seen none of that to be true, meaning that I have filed cases in premium and things I thought would should got an RFE, never got an RFE. Things that I thought were straightforward cases, getting RFEs. It's a very random thing. What is premium processing to your viewers? It's not for them to look at it and, make a judgment call or anything. It's to act upon the application. Yes, the officer's on a clock, right? That 15 days, tick, 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 is going on in the background. And maybe, the myth is they just issuing the RFE because they don't want to look at the case, or they're issuing the approval because they just want to get this off of their desk. Those are all, I think, personally myths. But, do I like premium processing? 100%. Do I like the $2,800 that I have to pay? Not a chance. That's ridiculous for them to do their work. But, it is something that's available. Here's the biggest benefit of premium for your viewers
That's right.
is that you get to talk or maybe email the officer. So there's the ability to make a little bit more contact with your case and on your case if you use premium processing. That is the biggest benefit. Otherwise, when you file in regular, and your viewers will see this, you got to call that 1-800 number or you got to put the online inquiry. You're not hearing back from anybody. I don't even think there's a live person there sometimes. I don't know where it's going to. So the benefit of premium is not about the approval or the denial, more that communication is available directly sometimes with the officer. And that is a critical thing in your application.
That's right. Absolutely. I think thank you so much, Nandini, for clearing up that because whenever we think about premium processing, spending more money, so we obviously think that now we spend more money, so we'll get more benefits. Benefits, as in our chances of getting our visa approved, is becoming more and more. But that doesn't happen. It's all about the process that becomes faster.
That's
So
right.
that's great. That's wonderfully explained. And with that, let me go ahead with my next question. And this is something for the entrepreneurs mainly. So, is that H-1B visa holders can't start their own businesses? How much truth is there to this?
Okay, this is a more nuanced question. So the legal answer is yes, an H-1B can start their own business. Okay.
Mhm.
But the reality of it is different. The reality is that when you start your own business, you are not going to be able to start it and just be the own person in it, meaning that you have to be able to show your separation from the company. Okay, that the company stands on its own and you are a worker but even though you're an owner. So how do you do that? The company has to have a board of directors. There's got to be other people who are able to control your decision making about the business. You cannot be the sole decision maker. So a lot of people are like, oh, you can just start your company. I'm just going to go incorporate. I'm going to work out of my basement. It's going to be in my wife's name, all of these type of things. And they think that is okay. No, that is not okay.
Mhm.
That means you are working without authorization. If you're going to do something like this and you're going to get sponsored by that company and you're owning that company, you have to do it properly. You have to have that board of directors. You have to have a hierarchy. You have to have people who are able to override your decision, things like that. So to show what's called the employer-employee relationship. The employer is the business. You are still an employee, even though you have percentage ownership of that company. So it has to be looked at very, very carefully.
That's right. That's absolutely right. And I think that was very important because so many, our friends only, our viewers only, when they go for H1B, one thing is for sure that they ask regarding business also.
Mhm.
So I think this is what the answer is. And let's go ahead with my next question. And this is something about like, is it true, Nandini, that the H1B holders have no right if they are fired or laid off? Because currently, also, like few days back, also, we have been hearing in Silicon Valley, so many H1B visa holders have been laid off.
Yeah.
So I think it is a very timely question. So please go ahead and let us know about the reality.
Okay. So the reality is that, you're here in the US based on work, right? That was on a work permit, you were sponsored by an employer. Like
Mhm.
that's how you came here. So when that employer does lay you off or fire you for whatever reasons, um, there is an issue here for you because the reason you're here is because of that. So, but what are your options? Okay, if that happens to you. Well, luckily, about, I want to say 6 to 7 years ago, we got a new law that says that you can have a 60-day grace period if you are terminated or laid off, as long as you have still 60 days left on your I-94, then you can stay in the country. You can't work, but you can stay in the country. And that gives you an opportunity to find another employer, change your status, or wrap up your life and go and depart, the US and stuff. Those were not available, guys, to your viewers for like until 6 years ago. So if you got laid off 6 years ago, you're done. There's no, options here. Um, the other thing that H-1B holders really need to be aware of is if you get laid off or fired, you know, you are entitled to return transportation back home. What does that mean? So when they lay you off, let's say they have to give you money or buy your one-way ticket back to your home country, not for your spouse or your kids or anything. They just have the obligation to you. So that's a second thing that has to be there as a right that you have to be aware of. So they can't just be like, okay, bye, end of the day. No, they got to give you this opportunity.
Mhm.
Third is, and remember this very, and I know people don't want to sue and all of these type of things, but you actually have the same rights of anyone who's a US worker, meaning that if you were fired because you are a whistleblower, you were fired because there was some reason because they're trying to just get rid of you or something because you're older or any of those things, the same protections that a US worker has, you have. Now, what does that mean? Now, let's say you are a whistleblower and you got fired because said you complained about something that the company was doing wrong, and they fire you because of that. You can sue them. I know H-1B people and people won't think of doing that and stuff like that because they're so afraid. But you are not some separate category of an employee. You have those rights. You are protected in this country under those same guidelines that I'm protected under. So don't be afraid that of, if somebody you did something like that or whatever, and you get fired because of that, don't like consult an attorney, labor and employment attorney, and maybe there's an option for you to get a settlement or something of that. Again, these are not things I'm advocating, so please make sure that people understand that, and it should not be some sort of frivolous thing. If you got laid off because they don't have work, there's nothing you can do about that. So this is again simply about other circumstances, which is provable, not any fantasy that's coming up in anybody's head. It's actually provable that you are still having that same protection. So keep that in mind if any of these things are happening. But if you're laid off, you got your 60-day grace period, you return transportation, money, and that's it, really. Those are your options in front there. But at least you have the 60 days. Not a lot of time. I wish they would have moved it to 90 at least, but at least you got that much time.
That's right. And that's very well said. And That was really insightful, Nandini. But also, there's a follow up question that is coming in my mind. All right. For once, for example, if there's any employer who got laid off, then
Mhm.
is it like if he's applying for the H-1B visa for the second time? I mean, not he's applying, but maybe the next employer, somebody
Mhm.
from USA is applying and hiring the same candidate who got laid off maybe 4 years back or 5 years back. Then
Mhm.
is that laying off thing going to impact their future visa application?
No, not at all. As long as they didn't work without authorization. So let's say these guys got laid off, right? Last week, and we've been hearing about this for the past many months, right? Of layoffs going on. No, just because they got laid off does not impact their visa application the next time around or a year from now. Any of that. There's no like, negative consequence that's going to happen to their application. Now, if in during that 60-day grace period before they file, they go and work somewhere and and they find out about this illegal work, yeah, then that you have an impact. But you got laid off, you had 60 days on day 42, you filed the petition, that got approved, and then you started working. No, it has no impact. I
Okay.
have filed so many of those type of cases, and I explained it. Hey, he's not subject to the 60-day grace period. The clock began here. We're filing timely. You explain it out in the letter. You're perfectly okay.
All right, that's a great thing because Nandini, I asked this question about the future visa application. This maybe I didn't add it in the questionnaire, but this is another myth. I don't know, of course, it's a myth that
Mhm.
what people are having in their mind. So thank you so much for that explanation and clearing up that doubt because that was also very important. And okay, let me go ahead with my next question that I have here. In the current immigration climate, as we all know, it's little uncertain. So, what are the biggest new challenges or changes that you are seeing for H-1B applicants?
I mean, I'm seeing a lot. I think, you know, at the core level, at the real basic level, this administration is not interested in keeping this program alive, right? They want to dismantle the program. The good thing is it's a program that can't be dismantled by executive action. Trump cannot just dismantle it. It was created by Congress and it has to go through this whole process. And so I don't think that's they can dismantle it. I don't think it'll ever get dismantled. But I find the biggest challenge H-1B people, and this is again for everyone who's on a visa here, they are going to find that things that were routine previously, like a routine application, is going to get more difficult. It's going to get kicked back a little bit more. It's going to be a longer processing time. I mean, I think your viewers need to understand that he's planning on closing a lot of consulates
Yeah.
across the world, right? Now, what does that do when you do that? It creates that queue for the visa interviews, right? Now we're instead of 120 days or 30 days, you might be looking at a year to get a visa appointment, you know? So I think the biggest challenge is the mindset of this administration that is seeking to really tamp down this program where all foreign workers try to make it harder, put up hurdles in front of everyone, take away certain protections that are in place, and add new restrictions, right? One of the things yours might be interested to know is at some point, and I think this will become shortly, he, especially for software consulting companies who place people at customer sites, they're asking, well, what's the customer's requirements for an H-1B for this type of position? How is somebody supposed to find that out? Sometimes my client doesn't even know the end customer because there's layers in between and things like
Mhm.
that.
Yeah.
So it just makes the application difficult. It makes it nerve-wracking. It makes it something that was routine 1,000 times more difficult now. So I see that as the biggest thing. It is the environment we're working on under right now in this administration. We are going to face challenges on the daily. And we're not going to have a heads up. That's the other part that, we're not going to know in advance of anything. We're finding out just like everybody else finds out through the media, through what's happening when they're going and picking up F1 students and canceling their CVAs.
Mhm.
It's not like some announcement went out, right? So that is a real challenge for people because you always have to be nervous then if you're on a visa during this administration. So, but you know, you got to do the best you can with that and try to stay out of what could potentially cause problems for you if you can. I mean, that's all advice I can give on that. But yeah, your challenges are this administration coming up. It's coming.
All right. I think now it's really, I would say, high time for everyone, to be aware about everything, to be very vigilant, to be cautious. And I think, friends, if you will get the right guidance and, if you're updated with everything, then of course you're going to make your own way. And there's no one who can stop you. You just have to make sure that you like, share, and subscribe to Immigration Talk Show, because we come up with these insightful webinars and also with lots of different news updates that is very important for our viewers to be aware about and to get themselves updated regarding anything that's happening in the world of immigration. So just make sure that you like, share, and subscribe. And also, the best thing is that you can also press the bell icon so that whenever we come up with any news update or any live webinar, you'll get the notification. So thank you so much, Nandini, once again, for explaining these things in a very simpler term, and that too in a very interesting way. So I think let's also greet to our audience. I can see lots of viewers have joined us: Sonia, Kritika, Christopher. So thank you guys for being here. And let's take one of the questions of Sonia. I'll take first. So Sonia is saying a lot of people say that the H-1B visa is only for people in tech jobs. Yeah, this is again a very important one. But I have heard that this isn't necessarily the case. So can you clarify which types of jobs or industries are eligible?
Okay, that's absolutely true. That their H-1B program is not for tech jobs. The program was created in 1990. So decades and decades ago, and the tech boom had not yet really happened. It was on its way. Um, the H-1B can be filed for any job. Okay, if you have an employer, any job that requires at least a bachelor's degree for that industry. So I do tech, absolutely, but I do physicians, I do dentists, I do accountants, I do finance people, I've done marketing executives, HR people, you know, fashion individuals, civil engineers, like anybody you can think of that they're going to work in a profession that requires a bachelor's degree or higher. That position in itself qualifies for an H-1B. Now, of course, who uses the program the most? Yes, tech people uses the H-1B program because outside of the United States, there is a great talent. We see it from India, we see it from China, and Europe and things like that, that the technology curriculum is strong in those countries, and there are individuals who are willing to come to the United States or want to come to the United States. And so the program is utilized a lot to bring in that type of talent. But that is a myth that it is only for tech workers. You can use that program for definitely other professions out there. So don't let that be the thing that everybody thinks. It's not true.
That's right. All right. So, Sonia, thank you so much for your question. And in case, if you still have any follow up question, then please go ahead and put them on the comment section. We are really going to take that question, and I'm sure Nandini is going to provide the best answer for that. Okay. So, let me take Kritika's comment here. So, hi Kritika, and thank you so much for joining us. She's saying, can you clarify the distinction between work authorization and immigration status in the context of H-1B visa, particularly with respect to the differences between H-1B approval notices, I-94 cards, and I-797 forms, and how do these documents impact an individual's ability to work and remain in the US?
Oh, Kritika, that's a long question. Wow, I'm gonna have to do an immigration class at this point. Okay, so let's talk about this. And there is a distinction. You're absolutely right. Work authorization does not mean that's immigration status, and vice versa. Okay, so let's talk about. So, what is your status? Your status in the country is H1B, is H4, it's L2, it's L1. Like that's your status, right? That's what you are doing in the country. Like that's where how you came into the country. Now you can be here, like for example, let's take this. H4. You're here legally, your immigration status is H4, but that visa does not allow you to work without other things happening first, right? So you don't have work authorization. You can be in the country, you can live here, you can go get your driver's license, you can do all of those things, but you cannot work, right? It doesn't allow that. It's not enabled for that status. Now, for an H1B, you can come into the country, you are an H1B, that's your status. Now, let's say we talked about before the transfer petition, right? You do employer A, and then employer B, you file that application, the transfer application. That case gets denied, okay? Now, your ability to work under that employer, your work authorization is gone if you joined employer B. Think about also people like got laid off. We were just talking about this, right? So that's 60-day grace period. So you got laid off today. Today is April 30th, okay? Because the law allows you to have those 60 days, tomorrow someone asks you and stops you and says, what is your immigration status? You can say, I'm on H1B, because the law allows you to say that for that 60 days. But are you allowed to work for anybody? No, you are not. You are in the country legally. Nobody's going to do anything to you. But are you allowed to work? No. And that is the difference. That status does not necessarily mean you can work. And you have to remember that distinction very carefully. Because if you think just because you are here in valid immigration status, whether it's H4, whatever, that automatically that translates into you allowing to work for, at a gas station, work for at a store, work at an employer, whatever it is. No, that is not the same thing. So be very mindful of these two terms. It does not mean it is the same thing. And you have to understand that. And if you don't, you really need to talk to someone and make sure you don't work without authorization. Because one of the things I will say, the challenge the Trump administration is going to look at is individuals who have worked without authorization. These are kind of the questions that are coming up in H-1B applications now that we're seeing. So we're very mindful, and we're doing a lot of review of someone's work history before we're filing a case, because we have just kind of started, and I started about a month ago that we've been seeing some of these things coming up. So be careful.
That's right. And I think, Kritika, be very mindful and be very particular about the steps you are taking. And in case if you have any doubt about your case, or please let us know what your status is right now in the comment section only. And the great thing is that you can also get in touch with attorney Nandini Nair. And the contact details are on the screen, so you can go ahead and give her a call on the number. Also, share your case or share your query with the email ID, and you can also go ahead and check out her website. That will be really helpful for you and the best we can advise right now. So, Kritika, I hope that till now you have subscribed to our channel. If you haven't done it yet, then make sure that you do it right now. Okay, Christopher is here, and let's take Christopher's comment. What are the potential implications of AI and machine learning on H-1B visa requirements, particularly with respect to the definition of specialty occupation and the assessment of an individual's qualifications? And how might AI driven tools impact the H-1B petition process?
Okay.
Interesting.
Very interesting. What do I think about AI? I get this asked all the time. I'm not afraid of AI for myself. I think, for example, I think I have value besides my H-1B petition drafting or my support letter. I think there's more to me, than that. So that's one. But what do I think is going to have to be the impact for an H-1B? I think the impact for everyone across the globe is that AI is going to reduce the number of available jobs,
Yeah.
in certain sectors.
Mhm.
And so that will create a less of a need for foreign talent, right? That's where the impact is going to, you're going to see. You're going to see employers like, I don't need to hire anybody extra. I don't need this, because now a project that I needed 10 people for, and I hired two H-1Bs because I couldn't find them. I don't need 10 people. I only need 4 because AI can pick it up, the rest of it. So where do I see impact? The economic impact of AI is going to be that there's going to be less jobs out there, and the top of the top or the middle of the top, all of those people are the ones who are going to be employed, and the people who are more in the lower level with less technical skills and less skills generally are going to not be able to rise into those type of positions. So that's what I think. One. Now, like again, AI tools for the H-1B application process. I think, the goal of CIS and all of these government agencies is to use AI to facilitate a less paper filing process, which I would welcome. I don't want to be filing paper. I want to file things online as much as possible. It's easier for all of us, right? So I think we're going towards that process. But here's the part of AI. Now you are going to have a computer or these high-level tools who are going to be able to check an application for thoroughness, check the applicant's information so quickly that if there is incorrect information in your profile, it's going to come up like this, right? Whereas an officer, again, we're human beings, right? The officer's like, okay, this application looks fine. I'm tired. Like, I'm going to just approve it. They don't have to work like that anymore. The AI is going to do that. If you notice, they ran a code, a script to pick up the F1 students. That's how they found the ones who had issues. They used AI in the background went through state databases to see anyone who's been arrested, charged, and things like that, and pulled up those and cross-matched with CIS to see who's on a visa. And they filtered that out, and that's how they picked up the F1 students and canceled their visas. So as much as it's going to go forward to be, I think, great, and hopefully streamline the process, this is where the background will be.
That's perfectly explained. I would say, Nandini, that was really insightful. And of course, talking about AI, this is another myth. And of course, it is related to H1B because people are thinking that AI is going to replace jobs and they are so afraid. But what you explained, that is very well put up. And I'm sure that it's nothing to be afraid of. In fact, it's more about, supporting humans as people are doing manually and they may get tired or they may be overburdened, so they may overlook works, but AI is really helping, and just within a second it's making things very easier. So
It's an evolution. We have to accept it. I don't know that why people jump crazy about it. Did we not go from horse and carriage to a car?
yeah,
That when that happened, a lot of people lost their job.
exactly.
That's what happens. So it's going to happen here.
That's right. And there's nothing to be afraid of, friends, because that's how you are going to develop. And if AI is developing, I think you should also develop your skills.
Yeah, agree.
So that's
Agree.
great. Yeah, be competitive, be positive, be hopeful, and also keep watching our session. I'm sure that our friends are watching our session and really enjoying it. And with that, Shiva is here. So, hi, Shiva. Thank you so much for your question. Let's take up your question. Can we change employer before landing into US? I mean, can we transfer employer from India itself after stamping done? Okay, so let me go ahead with the next one. Is this a myth or a fact? Presently working for MNC in India, but coming to USA via consultancy. Is that fine during stamping interview if I have proper answer why I'm coming via consultancy? Okay, so let's answer the first one first. Yeah.
Okay. So let's take this one at a time. So can I change my employer before I come to the US? So I'm assuming, got an employer A to file the H-1B, got it approved. You went for stamping with employer A information. And now you're like, I don't like employer A or whatever. Employer A is not wanting to bring me on board now, but I found employer B. Can I file a petition under employer B? And the answer is it depends on how long ago employer A filed your application and got the approval. So there is a time frame of 6 years, generally how I do it. Okay. And different lawyers have different ways of calculating this, but mine is 6 years from the day, from the fiscal year you got your H1 approved. If you got within, let's say, 2 years, okay, employer A didn't want to bring you on, but you have this H, you got your visa stamp. Now B's like, oh, you have a visa already approved? Come on board, let me file for you. Can they do that? Yes, they can do that. Because, and not go through the lottery, because that's the follow-up question. Do I have to go through the lottery again? No, you don't. Because the point was that you've already been counted against the lottery, right, within that 6-year time frame. And so you're not subject to it. So is it possible to do that? Yes, it is possible. Again, timeline is critical. When was the H1 from employer A approved? We would have to look at that and see if then we can take you to employer B. But yes, it is possible.
All right, that's a good one. But I wonder, Nandini, that does this even happen? Can we change employment? This is a very new question for me. But still, viewers are interacting with us. We are getting to know a lot of information. So thank you so much, Nandini, for putting up that answer. And let's go ahead with the next question of Shiva. Yeah, presently working for MNC in India, but coming to US via consultancy. Is that fine during stamping interview if I have a proper answer why I'm coming via consultancy?
Yeah, that's all. Yeah, if you are able to articulate why you are going to leave the MNC and come to this maybe smaller company, I'm assuming in the US. If you're able to articulate a valid reason, and I'm assuming you're going to be saying something like, better opportunities in the United States, blah, blah, whatever it is, you're going to say, and you're able to successfully get the stamping done based on that. Yeah, absolutely. Again, just because you work for an MNC in India does not preclude you or stop you from getting a visa issued by the Department of State or the U.S. consulate. That's not going to be that relevant. I mean, now there are going to be officers who may ask some silly questions. You always have to be prepared for that. But if you have a good answer, and there are definitely good answers as to why you would want to come to the U.S., I think you should be okay. But you got to remember, you got 5 minutes or maybe even 2 minutes sometimes. So articulate well. Don't don't sit there and be shy. You got to speak well.
And I think speaking skills you should get from Nandini Nair because she's excellent in that. So we can understand, you'll be a great mentor to her. So Nandini, please go ahead. And I would say, Shiva, you can also get in touch with Nandini, not only regarding your immigration complexities, but also how to develop or, to get better in speaking skills. That will be great. Okay, so let me take up Rao's question. And hi, Rao, thank you so much for joining here. What are the H1B extension requirements in 2050?
I'm thinking he means 2025. I think that's
Yeah,
a type.
absolutely. Why 2015? I mean, it's 2025. Okay, yeah, please
Yeah,
go
10 years ago, I'm going to look a little bit younger, at that point. In 2025, again, I think the application process is very similar to what has been in the past few years, but the level of scrutiny, the level of review is going to be something that is going to be challenging. I think what everybody needs to understand is what's going to happen is your entire being, your entire environment, your entire background is now going to be looked at, right? Because there's rules now coming out that they're going to check your social media, right? That they're going to look at your phones and when you come back in, they're looking at see whether you're a pro-activist, right? Were you marching against Israel and all of those type of things. So I think the biggest thing for viewers to understand is all of you, your world is under their scrutiny now. It's not just going to be the H1B. It is all these external things that now you have to be mindful of. Did you file your AR-11 in time? You know, that's a question that people are not thinking about. There's a rule. They put that in the rule has always been there for decades and decades. But people would like, oh, I moved, I didn't do the AR-11 for 6 months. The law says within 10 days, guys, you know, and are they going to hold you to that? Yeah. Now they're going to hold you to it. What are they going to do about it? We have yet to know what's going to happen. But could they utilize this as an issue? Absolutely. So remember, your entire world is being looked at.
That's right. And that's very important for everyone, not only for Rao, but for everyone, to go ahead and look for this information. And Rao, I would say that, till the time, if you haven't subscribed to our channel, and I think you are little new to our channel because for the very first time you have asked any question. So we do have these amazing webinars, and, our channel is all about immigration world. So it's really going to be helpful, and also let us know, what are your current status, or if you have any other question for Nandini, then we are really going to take them up, as we are here for you guys only. And also subscribe to Immigration Talk Show, another very important thing. Okay, so Nandini, till now we have covered so many questions from our viewers, but just with your permission, if you have 5 more minutes extra, then we can also go ahead and take some Facebook questions as well, if you're comfortable.
Yeah, absolutely.
All right. Okay. So, control. Yeah. So this we got from Manav, and he's asking, I'm on F1 and traveling to India in the summer for 15 days, and will be coming back for the internship in June. Will it be safe to travel?
I'm going to say no. I'm going to say don't travel. I really am concerned for my F1 students right now. They seem to be really on the target for this administration. I have no idea why. There's so much more they could go after. But I, if you were my client, I would ask you to say to decline that trip. I would say please avoid that trip at least for another year or so until we have a little bit more information on what this administration is going to do and what the courts are going to do about it. Because I can't trust your ability to return at this point, without issue. So my recommendation is don't travel.
All right. So, Manav, I hope you got your answer. And, any other query, please go ahead and let us know. Okay, so let me take up Senem question. We had our interview on the 17th April 2025. My husband is the main applicant for our diversity visa. Our case went to 221G due to my husband's y- uh, arrest years back. Visa officer requested a court document, just 2 questions. Why do they keep all our passports? And once we submit the court documents, do we get a chance for approval? What do you have to say, Nandini?
Okay, so they always keep your passport for every visa interviews. That's a very common thing. It's nothing that's specific to you or to individuals. If you want your passports back, you're basically asking to withdraw the application. Because remember, if the application is successful, you're going to get a visa issued within the pages of the passport. That's one of the reasons that they keep it, right? They're not going to then want to call you in for another interview and do all of those things. They do it all in one shot. Now, submitting the court documents, do you get a chance for approval? It's all going to be dependent on what the reason was, how long ago was the arrest, what the issue was, a lot of those type of things. Do I think there's a strong chance of approval? I think you're in a tough situation because you're seeing that for any slight reason, the administration is denying applications or deporting people and things like that, right? So I would be concerned if that is the reason that you got the 221G and they're asking for these documents. The level of success might be a little bit lower. So I want you to be mentally prepared for that possibility. It doesn't mean it can't get approved, I'm not saying that, but just keep that in mind that submission of those court documents is not the end of the story. It is just the beginning of the journey you're going to be on for this.
Wow, that's really great. Thank you so much, Nandini, for making us aware about the reality, but that too with some motivating lines, because that is also very necessary, because people are quite scared and very anxious. So,
Mhm.
friends, if you are on the right track, I said that nobody's going to stop you. So be little hopeful, be little resilient, because with right guidance, that too, if you're going to approach with the right attorney, then that's going to be like wonderful for you. So get in touch with attorney Nandini Nair, and share with her any doubts, any questions, any queries, and she is here to give you the expert advice. And I'm sure that you'll feel better and you'll do better. Okay, so let's move ahead with the next question. And this we got from anonymous participant. Hello, I'm looking for an immigration attorney. Okay. My husband and I have been married 5 years. We have a house and children. We have filed I-130 and it is still being reviewed. However, my husband's I-485 was declined due to not sending the correct documentation. I sent 2020 W-2 and not 2023. We have to appeal with an I 20, 209B. They are revoking his EAD to work. So, has anyone gone through this? Any recommendation? Yeah, any lawyer? Of course, we are going to share your contact details, Nandini, but what are your views on that?
Okay, well, I'm trying to understand what kind of preference category they're under. I'm going to try to assume U.S. citizen filing for spouse, because the way they're saying married, and file the I-130 and the 485. In my opinion, I don't think the 290B, again, not knowing a lot of the facts on this and what exactly happened, is going to be helpful. If it's a category of U.S. citizen spouse,
Mm-hmm.
um, I would refile that 485. That would be my advice. The 290B is not. It's the processing times are ridiculous, and you know,
Mm-hmm.
getting that EAD to be reinstated is going to be ridiculous. Based on the limited information, my gut is like I'd rather refile that 485. You know, in my opinion. But again, facts matter. The entire story matters. So take this with that information that I don't know the full facts and stuff, and kind of maybe talk to an attorney and give them the full facts, and maybe there will be a difference in a strategy at that point. But just this limited way, yeah, I'm looking at refiling that.
All right. And this anonymous participant is looking for an immigration attorney. So, friend, here's the detail. Here's the expert here sitting in front of us. The contact number is 973-287-0966 with the email ID nnair@aystrauss.com, and the website is www.aystrauss.com. So, Nandini, I think that's all for today's episode. And these were the Facebook questions. And we also got two questions from Rao. So, I mean, if you allow, can we take that questions because it's
Sure.
already 1-6. All
Yep,
right.
that's fine. No problem.
That's so sweet of you. So, Rao is here and asking, is it mandatory to carry client letter with consulting company? Client won't share letters to contractors. Any guidance on it?
No, it's not mandatory. No. I say that very quickly and don't jump on me on that, because I'm going to go into more about it.
All
Is it
right.
mandatory? No, it's not mandatory. Okay. However, let me give you what goes on the ground. Okay. They're going, especially with a consultancy company that may not be big and well known, right? We're talking like the TCSs, Wipros, Cognizants. I'm talking the smaller companies and stuff like that, maybe 25 employees and stuff. There is this issue where people or the consulate thinks that the letters might be fake, or there's issues whether the project is real and things like that, because there's been those issues, those there have been such incidences, right? um, and they're going to be wary of that situation. So yes, you don't need the client letter and stuff. However, if and when they ask you at that interview who's going to be the end client you're working for, and you say let's say Pfizer, right, is the end client or something like that, and you are not able to provide real good information that you are actually that's where you're going to go to, it creates doubt. It creates an issue in the officer's mind. And remember, you got that 2 to 3 minutes, 4 minutes in front of that officer. What's the alternative? The alternative is to see if you can get an SOW, a purchase order with your name on it by Pfizer. That's the way it will be okay or helpful. Now, again, what everything I tell you is in general. Okay. There are people who've gone without any issues. There are people who had the client letter and got the denial too. Okay. So it's not that just having the client letter. What I walk you through is how can you present yourself the best? It's not a guarantee. It's what do I do? Right? It's like you dressing up in a nice suit when you're going to an interview, right? If you came in sloppy jeans and a t-shirt, what's the impression you're making? It's the same concept when you go to the consulate. What's the best presentation I can show to this person in front of me that I am actually going to be working at Pfizer for this company? That's how you have to look at it. And yes, if Pfizer does not issue those letters, because many end companies will not do that, then what else can you show? What else is there available? Again, one case is not the same as the next case. One case can show this, another case can show that. It all is an individual situation.
Mm-hmm.
So walk yourself through that process as to think, how do I best handle this? Can I get that statement of work at least?
That's right. And I think this is almost the same question. I'm on H1B with consultancy company. The client is not sharing letters to contractors. Of
Mhm.
course, it's the same. Most insurance companies won't share letters to contractors.
Yeah,
Okay.
and it's a common scenario. What I like to prep people with when I send them to the consulate, when I don't have the client letter, do I have a end client contact? Possibly, because what's going to happen? They're going to reach out to the end client. We all know this, generally. So you want that point of contact to get that email and be able to verify, yes, we're expecting RAW on this project and stuff like that. So again, just like I said, what other things can we do to make you look
Mhm.
the best you can in front of this officer?
Yeah.
It's not a one size fits all situation, guys. It is going to be individualized. It's going to be customized, um, and that is how you go in front of them. And also speaking, you got that 3 minutes. You got to articulate it. I constantly have these issues with my clients who are not able to articulate things. You got to be able to practice. And I always tell them, practice some of the possible questions. You go online, you will find the typical questions that a consulate officer is going to ask you. Practice, be
Yeah.
strong, like you got to look like you're telling the truth. Not that you're not, right? But you got to be strong. And people who are strong in front of the consulate officer will be more successful.
Yeah.
Somebody's not going to push me, right? Because if I know what I'm saying, it's not going to, I know what I'm saying about immigration, right? It's the same way. But ask me a technical question or how my iPhone works, I have no clue. But, same way.
Absolutely. And I think it's not only Nandini, in consular offices, somebody is liking if somebody is providing strong answers. In general life also,
Mhm.
somebody is going to be confident and, share any insight strongly, then that becomes little more catchy. So it's
Yeah,
nothing hard and
preparation is
fast
key.
rule. Yeah, yeah, please go ahead.
No, I was just going to say preparation is key. Like,
Absolutely.
I mean, guys, I know what I've been doing for 25 years, but I still prepared for today, right? Like thinking about what I could, questions and possible things and stuff. Preparation is key. Don't go into that interview blind. It's like you got to know what you're talking about. You got to be able to answer these questions. So again, I'm like very strong with my clients about all of these things because I want them to get the visa, you know? And
Mhm.
sometimes I do interview preps and things like that. So they're, you know, yeah, do all that.
That's great. That's wonderful. And that is so inspiring. So thank you so much, Nandini, for your time. I know it is 1:13, I mean like 1 hour 13 minutes. And really appreciate your time. You patiently answered so many questions. So really honored to have a second episode with you. And that too, we didn't even realize how this 1 hour got passed away. So, again, thank you so much for being here. And as always, it's our pleasure, it's our honor to have a show with you. Any last message, any last tip that you want to share with our viewers, then please go ahead.
I would just say that, immigration overall is challenging. It is a beautiful thing. I think this country is the best when it has diversity of thought, diversity of people from all over. But it is a challenging time. Be mindful, be careful, get the advice that you need, tread lightly on whatever you're doing. Is what I my advice to you is for the next couple of years. Be careful out there and stuff.
All right. That is a beautiful message with a very insightful tip as well. So, thank you so much, Nandini, for being here. And soon we are looking to have another episode with you again. So hope to see you again and have a great day. And again, thank you so much for being here.
Thank you so much for having me. It was my pleasure.
All right. Okay, friends, so that's all for today's episode. Hope you like this video. And in case if you still have any questions or any doubts regarding today's webinar, then please go ahead. The questions section is just on the left of your screen. Put them on there, and we are going to take up those questions even after this live stream ends. Don't forget that we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. Follow us on these many platforms. And also, if you haven't liked, share, and subscribe to our channel, then make sure you do it right now, because that is the only way you can keep yourself updated. And can keeping you updated is really a very important factor in today's preparation. So don't miss out that. Also press the bell icon. And it's me, Sam, signing off for now. So goodbye, everyone, and take care.
Hi everyone, welcome to Immigration Talk Show. I am Rajni Bharara, your host, and before I move ahead with our today's show, let me read out a very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. We are excited to have you here. Well, now, if you're an employer in industries like hospitality, landscaping, construction, or services, you're in for a treat. Well, you might be thinking that sponsoring foreign workers for green cards is something that only applies to tech positions, right? Well, think again, because today we are going to talk about how you can sponsor foreign workers for essential support roles such as restaurant staff, pool cleaners, and laborers roles that are crucial to the success of your business, yet often overlooked in the green card process. The topic is incredibly timely, and we are about to dive into the details you need to know. Whether you're a small business owner, a part of a large organization, well, the show is all for you. And to break it all down, we are joined by a true expert, attorney Rani Mandi, an immigration attorney with over 28 years of experience in helping employers and foreign workers navigate the complexities of immigration law. So, without any further ado, let's welcome Rani again on Immigration Talk Show. Hi, Rani, welcome back.
Hi, Rajni. It's a pleasure to be here to provide some information that might be interesting and informative to your viewers.
Of course, it was such a great show last time, and we were so excited to have you back. So it's a pleasure having you on the show again. And, I'm sure our viewers must also be really excited to ask you all the question about today's topic because, our topic for today is quite interesting, and I'm sure it's going to be also very insightful. So, yes, the topic is displayed on screen. How can non technical professionals benefit from perm process and other green card options too? So we are going to get into the nitty gritty. But before we do that, guys, I would like to tell you that we are live on YouTube, LinkedIn, Twitter, X, Instagram, and also on Facebook. And our handle is Immigration Talk Show. So don't forget to subscribe to us. And yes, if you have any questions related to the topic from Attorney Rani Mandi, make sure to drop them in the comment section. We'll be more than happy to take them. And yes, but now, Rani, I would like to come to you again. And, we have so many questions prepared for you, and we would like to ask you so many questions. But before you answer them, I would like to ask you that, what would you like to tell our audiences? What can they expect from today's episode?
I think that the traditional roles for green card, everyone is aware of them. Those are the professional workers, such as technology workers, software engineers, financial analysts, doctors, healthcare workers who, these are the H-1B specialty occupation workers uh, who are typically sponsored after they're being on their work visa for up to 6 years. They want to obviously continue to be in the United States. And
Yeah, I'm so sorry, Rani. I'm so sorry to interrupt. Can you hear me? I see. I'm actually facing some audio issue.
can you hear
I
me?
don't know.
Oh,
Yes, I can hear you, but I can see some audio problem.
okay.
If you can
Hmm.
please fix that, maybe you're facing some problem. Probably, yeah. Maybe the microphone got disconnected.
Can you
So
testing? Can you hear me?
okay,
Can you hear me?
we can hear you, but then again, there's some glitch or some sound that we are also getting.
Hmm. Okay. Let me try this again. Testing.
Yeah, Rani, I can hear you fine, but still there's some noise or
Okay.
there's some problem. Uh-huh.
Let me know what you want me to do.
I mean, it was fine before, but now, suddenly something has went wrong. Hi,
Okay.
Rani, can you hear me?
Yeah, I can hear you fine.
Okay. I think we can start the show again then. Okay.
Okay.
Yes, sounds good now. All right.
Okay,
So,
good.
I was asking you about, what can our viewers expect from today's show? So, if you can please talk about that.
Right. So the traditional thinking, what we've had is the focus has been on green cards, specifically for H-1B specialty occupation workers who are in the country on various professional positions, such as uh, uh, software engineers, programmer analysts, doctors, accountants, financial analysts. So there have been many. There's been the focus on the green cards for such individuals because they're here on that 6 year period for the H-1B. And in order for them to go to the next level and stay in the country before their work visa runs out, they need to transfer to a green card. Now, the issue with that is that it's not been it's been fairly easy or traditional to step into the green card. Now, when we look at other positions, such as you've got cook positions, specialty cook positions, you've got other positions that are at issue. For instance, you've got construction workers. We've also been successful with pool workers. We've been successful with landscape maintenance workers also in terms of the green cards. And these are non-technical positions. So people need to know that these positions are available for the green card process. People need to know that. Oh,
Rani, okay, thank you so much, Rani, for answering that question. I'm sure our viewers must be really excited to ask you the questions. I can already see Ranjit's question in the comment section. He has posted a long question, which we are going to take in a bit. But before we get into the viewer's question, I would again like to come to you and ask you that if you can please, because I'm sure our viewers know that what perm is, but still, I would like to ask you that if you can please explain what is perm labor certification and why is it relevant for non-technical roles like pool cleaners or restaurant staffs?
right. So the normal method of obtaining a green card involves the perm labor certification. And the perm labor certification is the main, there are three stages for the green card. The first, the perm, involves the employer demonstrating that there are no available jobs for the position. And the way that they do that is demonstrating that they've run advertisements for US workers, but these no qualified U.S. workers were available for the position. This process involves a prevailing wage with the U.S. Department of Labor. It involves filing the perm application, but prior to that, running advertisements for a period of 3 to 6 weeks, 6 weeks to even like for 3, 4 months. So that's called the recruitment process. And after the employer is able to demonstrate that there are no U.S. workers available for the position, you file the perm application. And so this total processing time takes about 1 year, up to 2 years time for the entire perm process. After that, the second stage is the employer demonstrating their financial ability to pay the prevailing wage for the worker. And that processing time can run anywhere from, it can be as quick in premium processing as, within 2 to 3 weeks, or it can take up to another year. After the perm process is approved, then you have the adjustment of status application, where the individual is able to ultimately file for their green card and receive it within a year and a half to 2 years. But the processing time varies according to the national, in which country the person is from, because different nationals in different countries have longer wait times. So that's it in a nutshell. That's the green card. But the fact is that you can actually file the same sort of position for the same process, which is the perm. What you do for a tech worker, any other individual goes through the same process. That's going to be a cook. Typically, you can actually sponsor an employer can sponsor someone for a specialty cook position, which is an ethnic position, ethnic cook, like that is for, it could be for an Indian cook, it could be for a Jamaican cook, it could be for a Filipino cook. So that processing time actually, the individual can actually receive their green card within up to 2.5 to 3 years. It is possible within 3 years for such an individual from some country, such as anywhere in the rest of the world, with the exception of India, China, and Philippines, to receive and Mexico, to receive a green card within up to 3 years. So the processing time is fairly good in that regard. And we have been successful with these different types of workers.
Okay, but Rani, I would also like to come here and ask you that how is the perm process? How does it differ for the technical roles and non-technical roles?
Right. So you might have less advertisements because as part of the recruitment process, which is the perm process, as I indicated, takes up to a couple of years. The first stage is the advertising, which for professional workers requires a U.S. Department of Labor ad. It requires a prevailing wage. It requires a job order with the U.S. Department of Labor. Then it requires 2 Sunday newspapers, in addition to 3 other recruitment methods. So for professional workers, the recruitment period and the steps are lengthier and greater. With the non-traditional positions, which only require they may only require 2 Sunday ads and additional ads. So non-professional positions require less advertisement, interestingly enough. So I actually see some chats, some questions in the chat. Someone's working in a customer service department, and wonder if they're eligible for a green card or under EB2 or EB3. Yeah, sure, you would be eligible under EB2 or actually EB3, because as long as you show 2 years of experience as in a position, then you would be qualified for the green card, typically. But don't forget, you have to be able to show that no U.S. workers are available for the position. So why would, for instance, a pool cleaner be able to get a green card? They would not be able to get a green card in Florida because there are enough pool cleaners over in Florida. So we have been successful in obtaining these positions approved in maybe Long Island, because that's not traditional what you can find, the type of positions that you can find there.
Okay, Supriya, Supriya, I think she goes on to say that could you break down the differences in these categories for someone like me who doesn't have a technical background? What would you like to tell her?
It's going to be, while it's doable, it depends on the geographic region you are from. And if from the geographic region you're from, to see whether there are U.S. workers available for that position. You'll know that yourself. For instance, when you applied for that job, were there tons of U.S. workers? Then that's not going to work for the green card. It has to be, and if your position should be a little more skilled, shall we say. It should be a little more skilled. So that's the other point about it. You should have some sort of skill sets that are important, that may distinguish you from U.S. workers, or that they cannot find qualified U.S. workers in that position.
Okay. So, but Rani, I would also like to come here and ask you that are there, specific industry trends that suggest, an increase in non-technical workers seeking permanent residency?
Are there some trends in terms of, can you just
specific industry trends? I mean, that suggests that, that there is an increase in, non-technical workers that are seeking maybe permanent residency.
Well, I don't think that there's any trends. Rather, I think that, for us as attorneys, when an employer seeks us out, we will tell the employer this is feasible for a green card or not. So it's on a case by case basis, depending on the type of employer. We have landscape companies that have nurseries. We've been successful with plant nursery workers,
Mm-hmm.
because some of the work that they do is technical. They have to have knowledge of certain pH levels
Right.
in the soil. They have to also learn, be able to run certain type of equipment. So whenever you get into some technical aspect like that, it can certainly work. Yep.
Mm. Okay. Okay.
Rajni, I have to put another I have another technical glitch, so give me 1 second. I shall be right back. Give me one
Please,
moment. If you
please.
can put it on hold.
Okay, no problem. Please take your time.
Yeah.
Thank you so much for letting us know. And guys, we are live here on Immigration Talk Show. We are live on YouTube, LinkedIn, Facebook, X, and also on Instagram. The handle is Immigration Talk Show. And if you're enjoying this conversation, if you think this is benefiting you, so make sure to share this video, make sure to like this video, make sure to also subscribe to us on YouTube and follow us on all these important platforms, because we are your one-stop destination for any immigration and for all the immigration related uh, videos and all the immigration related news and updates and also live shows. Yes, we come here every day, with attorneys providing you necessary and timely information regarding a lot of important immigration topics. So make sure you subscribe to us. And yes, we are having a great conversation with attorney Rani Mandy. I hope you are enjoying the conversation, and make sure to also share this video with someone who you think can benefit from these insights, because right now immigration is the most important topic that is going on, especially in the US. So I think people should have the access to all the information, all the updates that is going on. So make sure to share this video with your friends, family, relatives, with whoever you can, who you think will benefit and will, this video will help them. So yes, I think Attorney Rani is back. Okay, I hope the problem is solved now, Rani.
All good. Thank you.
Great. Thank you so much. So, yes, the next question I wanted to ask you, that is it actually legal and common to file perm for, these type of roles?
Oh, of course. It is, because as long as the purpose behind the immigration law related to supporting green cards for foreign nationals is if the employers are able to demonstrate that there are no US workers available for that position, then it only makes sense that to demonstrate that the foreign national is not displacing US workers. If you're not displacing US workers, there's no negative a negative impact on the US economy. Rather, you're helping the economy become more competitive in the world market. So that's why this test has to take place. It takes place through the green card labor certification process, through the perm. The employer also has to be able to demonstrate their ability to pay this foreign national. The first stage, I go back to the first stage of the perm process, and that involves obtaining a prevailing wage from the US Department of Labor. When you obtain a prevailing wage, for that particular position, the employer is presenting, this is the position that he or she is seeking,
Mhm.
and they're trying to find workers for that position because they can't find anybody to meet that position. Then the US Department of Labor will issue a salary that has to be paid for that foreign national based on that specific skill set, education or lack of education, and job title and duties.
Mhm.
So the US employer has to end up paying that full prevailing wage, which is the same that a US worker would have received. And the employer has to be able to demonstrate the ability to pay the salary for that US worker. And in doing so, this again shows that number one, you're not displacing US workers because you're paying the same salary. And first off, you can't even find any US workers for that position. So yeah, it is perfectly within the guidelines of the Immigration and Nationality Act and the guidelines of the U.S. Department of Labor to engage in this process so that employers can find qualified qualified foreign nationals to perform duties and the position that they can't meet uh, through the normal market.
Mm. Okay. But then are there, any specific industries or any specific roles that are, less likely to be approved under perm?
Well, again, that goes back to the basic point, which one would envision. If I want the easiest way to handle this is just someone can say, okay, I work as the manager of this store, of a shoe store. Okay, so let's pick that. And then they would say that, well, when I applied for this position, and I say they're a foreign national, um, the first question is, where would a foreign national be working? Okay, so for the H-1B specialty occupations, you know, say for instance, an accountant. And if you're working as an accountant, the fact is that there are a lot of accountants in America. I mean, it's a standard position in in that field. So what happens is you can't. It's understandable that if you apply for a job as an accountant, you're going to get tons of applicants. So that may not be the best position. That's not going to be a position that you may very well find as a green card sponsoring position. Rather, we have, instead of accountant, there's a position called an accounting consultant. An accounting it's an accounting consultant position, and they may have different skill sets and technical programs and that they may possess. And somehow we've seen approvals for accounting consultants. So there's certain nuances in different fields that work. For instance, technology that is in high demand in the United States. Yes, you have individuals who you have US workers, but you know what? The demand far outweighs the supply. And what we are seeing is, more than 90% of positions for tech in the tech field uh, are worth green card processing. So in the professional field, you're fine. But once again, if we're talking about other positions, which, uh, a good number of the country are in, and foreign nationals, if they're in that position, then you do have to ask the question, are there other US workers applying for the same position? And if they are, then it's very unlikely that it's worth sponsoring for a green card.
Okay. Wow. Okay. All right. Thank you so much for answering the question, Rani. With this, I would also like to ask you that, what factors actually influence that whether a non-technical role is, will be eligible for perm or not?
It goes back to the same criterion and the questions that I just now stated,
Oh,
that if I would tell if an employer contacts, if an employer contacts any immigration attorney,
oh,
the attorneys are going to be able to say, that's not going to work.
uh-huh.
You might have to be a little bit of a subtle change in the position because there are going to be qualified US workers for this position. So we cannot encourage you to file a green card. So it's going to be, as I said, it's going to be that question in each industry. We would ask that question as to, is this a viable green card position or not? So it's along those lines.
Okay. So also, Rani, I would like to know from you that what kind of businesses should be paying attention to this right now?
Well, it would be employers who are struggling to retain and find workers. And we're seeing that in every industry across the board. You are seeing companies struggling now. That could be restaurant owners, it could be construction businesses, it could be landscaping companies, it could be the plant nursery sort of companies. But it runs the gamut, and it's a matter of the employer reaching out to an attorney and saying, okay, can I sponsor this foreign national, because they do great. Now, we've had a lot of interest from the traditional H-2B visa workers, where their employers are like, this person's works amazingly for me. And the H-2B visa category is a category for a lot of unskilled positions. It does include the group that I told you, the plant nursery worker. It could be the specialty cook. It could be the landscaper, the construction worker. The reason why is
the United States, while they have individuals in this who could work, who are U.S. workers, the problem is the business has a peak load or sometimes an intermittent need. So there's four criterion that qualifies for H-2B visa workers, and when a business meets that requirement of being able to demonstrate that I don't need this person all the time, it's only for seasonal need, it's a one-time need because I'm setting up, or it is a peak load need. Along those lines, that's when the H-2B visa worker positions are available. Now, we have been successful with such positions for green cards because there's a process where you can actually show that these individuals or these positions cannot the employer can't find any real U.S. workers for that position, and we've been successful in filing green cards for those individuals, and they're getting their green cards for these unskilled categories. For instance, a cook, a specialty cook in a specific nationality, kind of, if it could be an Indian cook or a Chinese cook. Well, we can get their green cards within. It depends on the nationality because some countries have a backlog, but you can sponsor such individuals for green cards, and they run through the entire process. So yeah, it is feasible for all kinds of companies to basically conduct some due diligence to see what positions will work for them, what positions they can actually sponsor. But it's going to be a process of and a discussion.
Wow. Okay. All right. Thank you again for answering the question, Rani. And guys, we are live on YouTube, LinkedIn, Facebook, Twitter, which is now X, and also on Instagram. So our handle is Immigration Talk Show. So don't forget to subscribe to us, follow us, and yes, so make sure you give this live show a like and share it with anyone who you think will benefit from these insightful answers of Rani. And also, yes, subscribe to Immigration Talk Show, which is very important. And I see a lot of you have joined us on this show. So make sure if you have any question that you would like to ask Attorney Rani, you can drop them in the comment section, and also give us a call if you would like to ask your questions on, directly to her through call. So you can dial this number, which is 425-436-6335. I would like to repeat it again, 425-436-6335, and you can put the access code 988888. Yes, by giving us a call on this number, we can, put you through, and you can directly ask your questions from Attorney Rani. But now coming back to the questions, Rani, so, as an attorney yourself, I mean, I would like to ask from you, from your point of view, do you think, I mean, are there any particular regions or states in the US that where you feel that are seeing more demand for non-technical workers to go through the perm process?
I think that we have, it's very unique. It depends on, no, it's not across the board. It's in the industry. It's about the industry. So I think there are probably, where there are less populated areas, you can say that it's harder to find workers to meet a particular position. So that's one particular situation where it's the region. The region really dictates the availability of U.S. workers. So, for instance, if you advertise for something in New York City versus, Long Island, you may not find the U.S. workers available there, and maybe the green card may be viable for a position over in Long Island versus New York City. So, as I said, it does vary according to the region and the industry.
Oh, okay. All right. And Ronnie, what are the legal, key legal requirements that employers needs to know before sponsoring someone?
Well, it's important to know that the employer can, number one, be able to pay the prevailing wage of the foreign national. And the prevailing wage is one of the first steps that are taken with the United States Department of Labor, where the employer submits the job title, degree, the job title, duties, and the requirements for the position. And that prevailing wage request can take up to from 4 to 6 months right now. The Department of Labor will issue the salary that needs to be paid to that foreign worker. It's not a salary that has to be paid now. It's a salary that has to be paid upon approval of the green card. And that's so we always evaluate with an employer, this is what we estimate the prevailing wage to be. And if that's the case, let's take a look at your financials, your tax returns for the last year to see if you qualify for that position. So you were able to pay the prevailing wage, because the second stage of the green card is the immigrant petition, where the employer actually has to submit the tax returns of the company to then demonstrate they have the financial ability to sponsor that individual with that prevailing wage. So that's one of the most important steps that have to be taken. And once again, you're demonstrating that no U.S. workers are available for that position, and that the prevailing wage will not harm U.S. workers, because it's a higher wage and it's in line with what U.S. workers are paid. So it should not be something that's lower than what U.S. workers are being paid.
Okay. So, and let's say, if an employer is not following all these rules and regulations precisely, then, are there like bad consequences for him?
There are many, when you're working with an attorney who ensures the validity and the legitimacy of the process, you do have steps along the way. The first is clearing the perm application. So that's, once you're clearing the perm application, you've obtained the prevailing wage. You place the advertisements. All those steps have to be placed and surpassed and crossed in order to file the perm application. If there's something that is not in line with the process, then the perm application could get denied. If you didn't do the right advertisements, if you didn't engage in the full recruitment period, etc. If so that case is going to be denied. So these are the safeguards for U.S. workers, that look, the employer is following the rules of the Department of Labor and the Immigration and Nationality Act by taking steps by crossing each stage of the green card process. So that's it's if it's denied at any stage with the financials at the second stage, then it's out. So there are safeguards for the process to ensure the continuity of the process, so that the individual obtains their green card and the employer is following the rules.
Okay. And let's say, if someone wants to sponsor a pool cleaner, so how should they start the process?
So again, first off, we would evaluate, look, which region are you in? We ask the employer, have you placed ads? Are you getting any results? And they would say, no, we can't find anybody. And then that means that, okay, let's move forward. Let's check your financials to see that you can sponsor the prevailing wage. What do you think a pool cleaner should be paid in that particular region? And then we start the prevailing wage process, where we check with the employer. They submit the position and the duties to us. And then that is submitted to the U.S. Department of Labor electronically, and that can take up to 4 to 6 months. So that's the first stage. Here's the salary that you have to pay the foreign national once they receive their green card. And if the employer is fine with that, that's at stage 2, the advertisements begin. So that's really the first step to take. And then, you have the other stages to take.
Okay. So, like, is this an option for part-time workers or only full-time roles?
The perm process is specifically for a full-time worker. It cannot be processed for a part-time worker. That would be probably hurting U.S. workers if we try to get away with that. But it's not available for part-time. It's only for full-time workers.
Okay. But then, can part-time workers be sponsored through perm process? I mean, if they later transition to a full-time employee?
That's a good question. What happens is that, and I want to clarify this, the individual need the perm or the green card is a future job offer, which
Mhm.
means that the individual does not even have to be working for that employer even now. They could even be working part-time, but
Mhm.
they even don't even need to be working right now. And then the question becomes, well, why are you sponsoring him? Well, we know he or she's qualified. We know that they fit our bill. We're willing to wait for them. That is feasible. So the bottom line is, you don't even have to be working for that employer. But of course, realistically, the employer needs help. So probably you would be working with the employer. But it's good to clarify, the person could be sitting in India or a different country or the United Kingdom and can still be processed for a perm application. So
Okay.
long as they,
Okay. So how long does the whole perm process plus green card process usually take?
the perm process, as I mentioned earlier, can take up to 18 months currently. So it's about a year and a half to, it can go, this is the average time. And so it can go to
Okay.
2 years, it can be a little quicker. So that's the first stage. The second stage is the I-140 process. And if it's premium processing, that can be processed within 2 weeks to a month if
Mhm.
you if the employer pays the quicker processing fee.
Mhm.
And then the last stage, the adjustment of status, normally takes a year and a half. So that's why we say between 3 to 4 years, 2.5 to 4 years, you can get the green card processing done and receive your green card. But the last stage depends on which country you're from. As long as you're not from China, India, Mexico, or Philippines, your processing time is fairly quicker. You could receive it within 3.5 to 4 years. Indian nationals currently have a backlog of over a decade. Um, Chinese nationals are over almost 4 to 5 years. I think Mexican nationals maybe a couple of years backlog. So that means they cannot file the third stage until they check to see if visa numbers are available based on the visa bulletin, which is a monthly bulletin published by the U.S. Department of State that indicates for each country, for those four countries, what the backlog is
Mhm.
and when you can file for your last stage.
Okay. But it doesn't differ, depending on the roles or the industry.
There are different categories.
Okay.
Di- good question and good point. EB2 is, so they have EB1, EB2, EB3, and then they have other workers. So the EB2, EB1 is for individuals of extraordinary ability and or who are able to, able to demonstrate extraordinary ability. They have a different processing time for EB1.
Mhm.
EB2 are individuals who possess a master's degree or a bachelor's degree and 5 years of experience. So those are professional workers. EB3 is for anyone who possesses a bachelor's degree or 2 years of work experience. So
Mhm.
some of these categories fall under EB3, and then otherwise they fall under the other category, and the processing times vary accordingly. Yes.
Okay. Okay. But Rani, I would also like to know that what factors could influence the process, could delay the process for non-technical roles?
Um, in terms of delaying the process for non-technical roles, I the again again, it would be maybe recruitment, but really everything is nothing, with the exception of just checking your visa bulletin and waiting for that deal to become current. Really,
Mhm.
there's no real delays as long as you are following the procedure.
Okay. And also, very important question, can employers file perm for someone who's already working for them?
Yes, you can always process for individuals who are working for them as well as individuals who are not working for them. So both ways you can sponsor and process green cards for. Yes.
Okay. Great. Thank you so much for answering those questions, Rani. I still have a little more questions lined up for you, but before we get into that, let me just quickly take maybe some of our viewers' question. So I think you were answering to Supriya. So Supriya has another, like she posted one more question. She says, "What type of skills, if you can elaborate on it?"
That is, the skills for a position are very much, it depends on the type of position. So if for a green card position, if you can then figure out, like if I'm working as this manager of this phone store, for instance, now if I'm working in this position, the question is, what visa am I working on? Maybe you have a tech background. So the more skills you demonstrate, if they are more technical, you always have a better chance of success. If you're doing something that is different from the normal workers, if you have these skills that make the company more competitive, and in doing so, when you have these skills, you are then you are able to distinguish yourself from the rest, and the employer has a need for your particular skills, and that's what's going to separate you. So see where you are different. What are the skills that you have? If it's technical, if it's a programs, if it is some sort of yeah, if equipment based that the others do not have, that can distinguish you, and you may be viable. It may be viable for a green card position.
Okay. So Priya, I hope you have got your answer. If you did, make sure to like this video, share this video with your friend who you think can benefit from these insightful answers. And yes, make sure to subscribe to Immigration Talk Show. And guys, we are here for maybe another 20 minutes. So make sure to post your questions in the comment section, and we are waiting to hear from you. You can also give us a call on the number, which is 425-436-6335, and you can put the access code 988888. Yes, dial this number, subscribe to Immigration Talk Show, and yes, let's get back to our viewers' question. But before I ask the viewers' question, Rani, I would like to again, I have one confusion which I would like to clear. So, what if an employee has been working under, maybe a temporary visa or is under a work authorization? Does this affect the perm process?
Typically, no. The status of the individual is not does not impact the perm process. What's important is the person is in status in the United States. If they're on a work visa, whatever it may be, typically they should be here working. And or they worked and then they returned back to their home country. Typically that happens with the H-2B visa workers. They're here only for like 9 months at a time, 9 to 10 months, and then they leave the country. So it's okay if you left, but if you're here and you want to adjust status in the United States, you do have to be on a legitimate work visa. We've got the H1, we've got the O1, we've got the L1. There are many, the TN, well, the TN visa and the E3. There's the E3 visa for foreign nationals from Australia as well as Canada. And the TN and the E3 do not permit, and Mexico, sorry, the TN is also for Mexican nationals who are professionals. And most likely they've had some specific education and experience. But there are some visas that do not permit dual intent. Dual intent is the ability to work and also have the ability to be sponsored for a permanent position in the United States. So the TN visa holder and the E3 are not permitted do not have dual intent. So they cannot be sponsored for a green card. But what we typically recommend to such nationals is to switch to the H1 visa whenever they make the lottery, and then they'd be eligible for green card sponsorship.
Okay. Okay. Thank you again for answering the question, Rani. Let me now quickly take Ranjit's question. So Ranjit says, I am a non-technical professional working in a managerial role at a small business. I have been hearing a lot about perm process, but I'm not exactly sure how it applies to me. Could you explain how the perm process can benefit someone in my position, especially when my job doesn't require technical skills? What would you like to tell him?
Well, Ranjit, It could work depending on, we'd have to discuss what your position is. And if it has certain special aspects to it that you think, again, are different from the others. If it's not technical, you really have to distinguish yourself from the other U.S. workers. What is it that makes this position unique about you while you're in it? Do you have these special skills? It doesn't have to be technical, but sometimes if it's a small store and if it's sort of maybe has some ethnic kind of paraphernalia, you sometimes we can incorporate the fact that the person has to have a language, a second language, because 50% of it's, if we're able to demonstrate that 50% of the customers actually speak a second language, we're able to incorporate the language requirement which you may possess. So that's one way someone can be sponsored, is also by having this language requirement where the individuals also, the customers are predominantly in a particular, speak that language. But aside from that, if you don't, if you do assess your position and you know, well, I really don't have much more that is different, and then it's going to be unlikely to be sponsored for a green card perm position.
Okay. Okay. Ranjit, I hope you have got your answer. Thank you so much for your question. If you have any more questions, please continue posting them in the follow-up in the comment section. Oh, okay. So I think Yuri is also here, and Yuri says, what alternative green card options such as EB1 or EB2 NIW might be available to non-technical professionals, and how can they leverage their skills and experience to qualify for these categories?
So the EB1 is definitely something that it doesn't require. There's the EB1A that is for like a scientific position, but you don't have to have education and to be qualifying for that position. You could be a top. It works for the theater. It works for being a top actor. It works for being a top model. You have to demonstrate, out of 10, there's about several criterion, almost 10 criterion, and you have to meet 3 of the 10 criterion. One of those criterion is having a very high salary, number one. Another criterion is having a lot of media and literature or media are about you. So again, this has nothing to do with having education, but it could be that you are a top artist, and hence you could be a top chef international. You have to be the top 3% in your field, and either nationally or internationally. The standards are pretty high. So if you have the high salary, if you have all this, you won these competitions, if you're a judge of other competitions in your field, and in order to be that judge, you had to be selected or you had to be the top in your field. That was another criterion. So you don't have to demonstrate for the EB1 that you have a bachelor's degree. So you don't.
Okay. All right. Thank you again for answering the question, Rani. Yuri, I hope you have got your answer. In case if you're looking for more, please continue posting your follow-ups in the comment section. We'll be happy to take them as well. Meanwhile, I think Jadhav is also here, and Jadhav says, I am a non-technical professional looking to sponsor my green card through perm process. Can you walk me through the specific steps I need to take and how my employer can support me in this process given my unique job role and qualification?
Sure, Yadav. Regarding the perm process, regarding the green card process, there are 3 stages. The first is the perm application process, which incorporates demonstrating recruitment for the position. And we said you had to obtain your prevailing wage. That takes 4 to 6 months. The employer has to advertise for the position and that particular salary. And then once the perm is filed online, it's taking up to 12 to 14 months for approval right now. That's why we say the entire process can take up to 18 months for the first stage. The second stage is where the employer has to provide the tax returns for the company and show that they have the ability to sponsor the position based on that salary. And once that I-140 immigrant petition is approved, which can take anywhere from a month to several months, then you may file the adjustment of status. But if you are a foreign national from India, your wait period can be a decade long at this time. However, if you're from Pakistan, Bangladesh, or any other country other than China, Philippines, your wait period may only be I think it's only a couple of years behind right now. So you can get your green card fairly quickly if you're not an Indian national or a Chinese national. In terms of the non-technical aspect, that has to be discussed carefully. It has to be a very a detailed discussion to first assess that your position. How does it fare amongst U.S. workers? Are there many U.S. workers for the position? So that's the way that it has to be assessed and discussed. Your employer and you can be on a call with an attorney to discuss that.
Okay. And Rani, also I would like to know from you that, I mean, while filing the perm, what common risk or mistakes that people usually make?
I think that if the position is not carefully drafted to reflect the true skills of the individual, then if this person really has great skills and is unique in some way, and it is not translated properly into the actual position, and then that position is advertised for, and then you get U.S. workers, then that's it, game over. Your case is you have no perm application, and you don't have an opportunity for the green card. So this is that's one common issue, is when it's not carefully drafted. A second common issue would be that someone failed to conduct the full recruitment required. That's why it's very explicitly identified. What is the type of recruitment? How many steps are required? A third thing is the advertisement may not, right, the advertisement, even if the ad draft was sent and it does have everything, somehow the newspaper didn't put in the right type of ads. So every aspect has to be carefully monitored. Our team is so analytical, and so we're looking at words to see if one thing is missing amongst all these technical skills. It is very detail oriented and requires such a team like that. In our firm, my senior paralegal is working with an advertisement team, with the newspaper, double checking what's being placed. After that's done, I'm double checking what has been placed. And then when we file the permit, it's so painstakingly detailed that that process has to be carefully supervised.
Wow. Okay. So, guys, if you're looking for, if you're looking for an attorney, so you can also get in touch with Attorney Rani Mandy herself. I mean, you can directly give her a call on the number 212-686-7782. Yes, you can give her a call on the number 212-686-7782. You can also email her. Her email ID is rani@imandilaw.com. You can also visit her website, which is www.imandilaw.com. So make sure to give her a call, write her an email, or also visit our website. She'll be there to help you with your immigration related cases or your immigration related concerns. So now, Rani, I still have one more question from one of our viewer. His name is Sunish. And Sunish says, if an employer has multiple locations and the perm labor certification was approved for a specific job role at one location, but the employee is currently working at a different location with slightly different job duties, what are the potential implications for the I-140 petition and subsequent green card application?
Well,
Yeah.
the fact is that the perm is a test of a geographic location in a job market. If the new location is it's called a different metropolitan statistical area, called an MSA, than what was envisioned for the perm, the case will probably be unapprovable. If you're, however, able to demonstrate the metropolitan statistical area is something within a 60-mile radius of that area. So if the position was just a move from one to another within that area, it's going to be fine. If the position is a different state, forget it. Your I-140 is not going to be approved. So these discussions related to the employer must be carefully thought out. Are we going to be here? Is the employer moving also? If the employer is moving, to what location? But so the answer is, if the position is within the same metropolitan statistical area, then the case will be approved at the second stage. But if it's not, it's unlikely to be approved.
Okay. Okay. So, Sunish, I hope you have got your answer. Thank you so much for your question. If you have a follow up, please, you can still post it in the comment section. We'll be glad to take it. And now it's time for the Facebook questions. So, I would request the control if you can please share the screen and show the Facebook questions. Meanwhile, guys, if you're liking this conversation, if you're liking the insightful answers of Attorney Rani, Mandy, so make sure to like this video, share this video with your friends, family, relatives who you think can benefit from all this information. And also, yes, subscribe to Immigration Talk Show on all the platforms. Yes, it's not possible to subscribe to all other platforms because there you won't be having the subscribe options. So make sure to follow them, follow us on all those platforms, and subscribe to us on YouTube. Now, coming to the Facebook question, let me take my very first one, which is from Sheku. So, Sheku says, my friend's details EB1, EB1B, I-485 application date 31st January 2025, fingerprint 26 Feb 2025, priority date May 2020. What is the likelihood of getting green card by June 30th? Any information? Or would you like to tell Sheku, Rani?
I'd have to check the visa bulletin because it's not something I memorize. That changes monthly. But for the EB1, what was the priority date? What was the priority date?
I think it says 31st January 2025.
No, that's the 40. No, no, May 2020. Well, is he or she a foreign
Oh,
national? Which country? We need to know which country. So if Sheku can identify which country, oh,
yeah, I
India.
think
Okay.
India. Mhm.
Yeah, so January 2020. Oh, well then. We also need to know, these are the things you need to know. Okay, it's EB1. They're currently working on, yeah, EB1B, they're currently working on February 2022 cases. So if that's the case, that means that he filed in January 2025. So then that means that any time now, he or she would receive the green card if the priority date was so if the priority date was May 2020 and the visa bulletin states that Indian nationals are currently being processed for EB1 at February 15, 2022, any date that is prior to that date means that you can file for adjustment of status, which this individual did. And typically within a year and a half to 2 years, the person will receive the green card. So if they filed, when did they file the 485?
I think that was, yeah,
January
31st January.
2020. Oh, yeah. It could happen anywhere within 6 to 8 months to a year. So
Okay.
June is possible. It could be possible into December. It's, there are thousands and thousands of applications. When they give you a particular date that is being processed, you have to estimate there are thousands of applications before that date. There are thousands of applications, tens and thousands of applications after that date. So no one can indicate that, or everyone needs patience, a little more patience towards the end, because it just drags on a little more sometimes.
Right, right. Okay, so thank you so much, Sheku, for your question. Let's move to our next question. So the next question that we have is from the viewer called Shahib. And Shahib says, what is the current time for EAD if I-485 is pending with USCIS?
Well, what we're seeing currently is still 6 to 8 months for processing time for employment authorization. When you file an adjustment of status application, you're automatically filing your employment authorization, which will allow you to work and not use your old, your H1 or your L1 or your O1. You can use this employment authorization document. But what we're seeing is of 6 to 8 months.
Okay, okay. So let's move to our next question. The next is from Gadhir, and Gadhir says, how to apply for EB2 NIW.
And the national interest waiver is for to demonstrate that certain work that this national has, this foreign national has completed, has qualifies and advances the national interest in the United States. And that work also has to show it's being supported by peers in the field. You also have to show that you've done something, which, for instance, say there's a person who's doing research in the field of for COVID, right? And that person has published several publications in journals of noteworthy or prominence. We're not just talking on the internet, we're talking about for the Journal of American Medicine, or multiple other prominent magazines. And then they've been speakers at numerous conferences. So it has to be promoting the national interest in the United States. Another interest may be someone who's promoting diabetes, who's not promoting, but who's done great research on diabetes or cancer. So again, it's something that the United States finds to be valuable for them, for the country. And that's what the national interest waiver is about. That falls within the category, the second EB2. An EB2, if you are not from China, India, Mexico, or Philippines, if you file your case, they're right now working on June 2023 cases. And that means that if you file your NIW, I think the processing time might be 18 months or 12 to 14 or 18 months to process the case. But that means that since we're in 2025, that's almost 2 years behind. So once your application for national interest waiver is approved, and since they're processing 2023 cases, by the time that's approved, it means that since that date you file your application is usually called your priority date. And once it's approved, you may have to wait another 6 more months, because as I said, if it takes 18 months and they're working on 2023 cases, wait 6 more months, and then you can file for your adjustment of status application, which again is another probably 6 to 18 months before you get your green card. But yeah, the NIW is another vehicle. It's for people who have demonstrated strong ability and to promote something within the national interest of the United States.
Okay. Wow. Thank you so much for answering the question. Rani, let me just quickly move on to the next one. Okay, so the next question that we have is from Mohammed. Mohammed says, hello everyone. Has anyone on a non-immigrant visa F1 or J1 with a pending or approved I-140 recently traveled without facing any issues at the airport? I'm talking about the current time. Well, I think this question is for maybe just the public who has traveled. But as an attorney, what would you like to suggest, Mohammed?
It's certainly not advisable for anyone who is on an F1 student visa or J1 to travel if they have an I-140, which is an immigrant petition pending. The reason why is the law does not permit dual intent for an F1 student. An F1 student it reflects a visa of a temporary visa to the United States to study. Technically, while it is possible to file a green card, but the moment they travel, they'll not be permitted back into the country because you're violating the fact that you can't have an immigrant visa. So absolutely, you shouldn't be traveling.
Okay, I think that's an important and most, I think this is one advice that I would say everybody should follow, especially in times like these. So, Mohammed, I hope you do. And let's move to our next question. So, the next question, if we have, okay, that's from Sam. And Sam says, hi, everyone. My I-765 got denied over an error on my part, and my I-485 is still pending on RFE, which I responded to over 2 months ago, but the status still hasn't changed. So I don't know if they even received my response. Okay, so he's asking if anyone went through this before. But what would you like to tell Sam, Ronnie?
Number one, there are two things that Sam can do. Number one, call the USCIS. You can get through. I know it'll take forever, but you have to keep trying at different times and register the fact that you would like to know the status of your case and make sure that the request for evidence has been received. So, number one, call different times, different days until you get through. Number two, you can also file an online status request through the USCIS portal. I think if you register and have your own account, you are able to request for a status on it. And they typically must respond within 30 to 60 days on the same. So make sure you do that.
Okay, all right. I think that's it from the Facebook questions. I think, Rani, that brings us to the end of our show. But before I let you go, I think we have taken all our viewers' question, I mean, from YouTube and also from Facebook. So yes, that brings us to the end of our show. But before I let you go, I would like to ask from you. I still have two questions. So let me ask you the first one. So, what advice do you have for employers thinking about, sponsoring a non-technical worker? What would you like to tell them?
So I think that it's worth a discussion if the employee is valuable to you and you'd like to see the employee not leaving the U.S. because they ran out of time. Then it's worth a discussion to strategize how to see whether they're viable. The position is viable for a green card. So it's worth a discussion. Reach out to an attorney and see. That's what we often do. Sometimes we tell the employers, nope, not feasible. Sometimes it's yes. So, but it's worth a discussion.
Okay, so guys, make sure to reach out to Attorney Rani Mandy. She has an experience of over 30 years. So, yes, you can reach out to her if you have any immigration related case. Her details are displayed on the screen. You can note down her phone number, which is 212-686-7782. I would like to repeat it again, 212-686-7782. You can also email her, write her an email. You can email her on at rani@imandilaw.com. Yes, rani@imandilaw.com. You can also visit her website, which is www.imandilaw.com. Well, okay, I think Al Nahar is here from Facebook and he says, can I ask questions, please? Yes, Al Nahar, please go ahead. What would you like to know about? Please drop your question in the comment section. And, in the meanwhile, let me come to you, Rani, and let me ask you that do you have any last advice for our viewers? What would you like to tell them?
Yeah, I think that the most important advice I'd like to give any foreign national is when you're not sure, ask a professional and you should not just when you see something that is upsetting to you on the internet based on questions or answers that people have provided, please don't give it credit or credence or believe in it until you have verified it with an attorney in the field and make sure it's an attorney. That's number one. Number two, I want to just mention that the EB-5 green card it's for an individual who possesses, who's able to invest over 800,000 in the into an economic project in the United States. But those green cards are current right now. That means that anybody with viable funds or family money where different family members can contribute to reach that $800,000, if they invest, the priority date is now current for nationals for the world, which includes India and every other country. So you can get your green card probably within 3 years or less, 2.5 to 3 years. So that's an important point to remember for anyone who does have those funds available. The EB-5 green card is current right now. Because, for instance, for EB-2, EB-3, for Indian nationals, right now they're working on 2013 cases. That's a backlog of 12 years. So here you can get your green card. Of course, it's a very high requirement. So anybody, and of course, you've got the gold card that has been proposed. That's a $5 million capital requirement. So in any event, you do have options. You do have options. But yes, does he have a question? It's okay to file tax while I'm on F1 visa. So the tax aspect is something that needs to be clarified with an accountant because there are certain taxes that are exempt that an F1 student does not have to pay. Probably it's a social security tax, but because I'm not sure because it's more of an accounting question and we don't focus on that, unfortunately. But please check with an accountant.
Okay. Alhar, I hope you have got your answer. In case if you're looking for more, you can continue posting your follow-ups in the comment section. We can take this when we have our next show with Rani. So yes, and we can also reply to your comments. So make sure you continue asking your question. Coming to you, Rani, again, it was such a great episode, very, very insightful. So thank you so much again for being here. And how about, because you have already, you mentioned about the gold card visa. So how about we do that and we take that topic maybe for our next show?
Yeah, we can certainly do that. There's not so much information released on it, frankly speaking, but we'll
Okay.
definitely touch upon it.
Okay.
Absolutely.
Okay, sure. Great. Thank you so much again, Rani, for being here. It was, lovely speaking to you. And again, I can't wait for the next episode.
Thank you, Rajni. It's a real pleasure. It's wonderful to be able to provide some information and working with you as well. Thank you.
Thank you so much. Thank you for your kind words. And guys, make sure to get in touch with Rani related to your immigration cases. You can directly contact her for a detailed consultation. Her numbers and her details are displayed on screen. You can note it down. Let me read it out for you. You can call her on 212-686-7782. I would like to repeat it again, 212-686-7782. You can email Rani at rani@imandilaw.com. Yes, rani@imandilaw.com. And you can also visit her website, which is www.imandilaw.com. Yes, and thank you so much for joining us on this webinar. It was a great one, and I really enjoyed taking all your questions. So thank you so much for also participating and asking your questions in the webinar. And hoping to see you real soon. And we are going to come up with another show at 4 o'clock, Daily Immigration Dose. So don't forget to, join us there. But for now, I'll have to take a leave. I'm going to see you all very soon. Until then, take care. And yes, subscribe to Immigration Talk Show.
Hello, everyone, and welcome to Immigration Talk Show. I'm your host, Sam. And today we are here with another very exciting and important discussion that is lined up just for you. So make sure to watch this webinar till the end because this is really going to be very important. And before diving into the topic and also inviting our today's very special guest, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information at your own risk. All right, with that, friends, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. And if you haven't followed us on these many platforms, then please do it right now. And also make sure that you like, share, and subscribe to Immigration Talk Show. Our handle is at Immigration Talk Show. So, talking about today's topic, I think this is a much needed one. And that is, what are the top alternatives to the H-1B visa in the US? So, of course, friends, whenever we talk about, go and work in the US, we always have this thing in our mind that, oh, now I have to look for the H-1B visa. But is it the only option for you to work in the US? Or there are some more alternatives that you are not aware of? If yes, then I think this is a must watch session, because in this webinar, we are going to share some great alternatives to the H-1B visa where you can have a great life in the US and you can have your dream come true. And some visas that are really easier to get, faster to process, and perfect for your goals. So, without any further ado, also let me welcome our today's very special guest and very honorable one as well, none other than Ruby Pars, who is a board certified immigration attorney and also the founder of Pars Law Group in Houston. With nearly 2 decades of experience, she is not only a skilled legal expert but also a passionate advocate for immigrants and their families. And there are more to go. She's an author, educator, and a respected voice in national media like the New York Times, CNN, and BBC World News. So, friends, whether in the courtroom, classroom, or community, Attorney Ruby is driven by one mission, that is to empower and advocate for others. So, hi, Ruby, and thank you so much for being here. It's really our honor to have a show with you. So, hope you're doing great.
Thank you, Sam. That was a very warm welcome. I'm very honored. Great to be back.
Absolutely. And to me also, I'm also very excited for this session because, right, Ruby, this is a much needed one. Right now, if we talk about current scenario, then everything is happening. I mean, most of the hot topic is happening with the H-1B workers. So
Yeah,
it's a very important one.
right. This is that time, the registration happened, those were chosen. Of course, we're talking about the cap, but again, cap, if you're cap exempt, you can apply at any time.
Mhm.
But what if you weren't chosen? What are options and what are alternatives? So that is a hot topic.
A very hot topic. And of course, I think, friends, this is a very important one. So you shouldn't also miss out. And to keep watching, also make sure that you have liked, share, and subscribe to our channel. If you haven't done it, then do it right now. Okay, so I think, Ruby, before diving into the topic, I also want to know it from you that what our viewers can expect from today's episode. If you can
Well,
just give us a brief.
Yeah, I'm going to give a little overview of the H-1B program. A lot of people already know that probably who are watching, but then I want to give like a walkthrough of some alternatives to keep in mind. And in many cases, when individuals come to us, or employers, HR advisors, CEOs, we walk through this option when we're talking about whether their candidates are eligible or not, and what would happen if they don't get chosen, with the registration process. But sometimes you're just fingers crossed everything's going to get approved and the registration happens, and so maybe you weren't really looking at the backup plans in earnest, and now it's time to do that because the first round has been chosen, and we're not sure if they're going to run more rounds of the registration through list of the registration numbers and names later on in the year to meet the numbers of the visa quotas. But yeah, we're going to walk through those, and then I can also stay on and answer some questions as well.
Wow. That's great. And I think this is really going to be a game changer episode because, most of the time people are just crazy about H-1B. And of course, it's a very popular and demanding visa. So I think, friends, this is a must watch session. And with that, Ruby, here's my very first question to you. If
Okay.
we talk about current scenario, then of course we have seen so many things that's happening, especially talking about recent news that Silicon Valley and tech giants H-1B layoffs are happening. So
Mhm.
I want to know it from you, like keeping the current scenario in mind. Do you think that H-1B visa is still popular for international workers, or are other visas becoming more attractive for them?
I think it's still attractive for the individual in the international worker space. There's a lot of different industries, growing ebbs and flows. And for the most part, the employment-based visa processing has not been changed that dramatically in the new administration, unlike some other areas. And
Mhm.
so I think a lot of there I know there's a huge labor shortage in different areas, and I think that the employers are still wanting to lean in to fill those roles with the H-1B. So I know that like sometimes there can be layoffs and changes in the labor market, but there are a lot of there's a lot of room for growth, and there are a lot of demand. So I think it's still it exists for a reason, for that educated specialized skill type of a worker. And the alternatives are really just if this doesn't work, but for the most part this is the ideal visa for certain types of work. And sometimes you just have to find an alternative temporarily until you have a chance to try again at the registration process.
That's right. And I think that's perfectly explained. So thank you so much, Ruby, for putting up this. And I also want to know, like, go ahead with the next question, and that too a very important one.
Mhm.
So besides the H-1B, of course, we have alternatives, but we want to know it from you in a detailed manner. If you can explain, like, which visa would you like to recommend for international workers and why?
Well, if I may show a little, I have a few slides about a couple of options,
Okay.
and I can sort of walk through what those might be. But there isn't, necessarily one that's like, okay, this is the alternative for everyone, because it really depends on your skill set, what your goals are, what the employer's goals are as well, and also like, are you bringing in family? Does the spouse need to work? Lots of those types of things. Those are all things to consider. So if I can, I think you can see if I can share my screen, I'll go ahead and walk through a couple things. So just like you mentioned, I'm board certified, about 17 years of experience. So bringing that to the table, we had the H-1B lottery or registration, if you will. It was closed out on March 24th. And we found out the results leading up to March 31st, a couple of days early for some folks. And then those who were chosen have to submit the I-129 before June 30th. And so those who choose not to go forward, or those who are found out not to be eligible, then those visas are going to go back to the drawing board, and they'll be giving those out to other individuals who had already registered. And so but it is important to know it takes a while for them to go through that process. And so don't put all your eggs in that basket, as one would say. If you have a U.S. Masters, we know you have a higher selection chance. You get 2 lottery attempts. And the second lottery possibilities, you can see that there were extra selection rounds done in many of the last years, except for in 2023. And really, it's going to depend on how many people go forward and apply, or who might be denied. And again, like I just want to mention, it could be that you are CAP exempt in certain universities and affiliated nonprofits, nonprofit research institutions, government research. So keep that in mind, because then you don't have to be concerned about this time frame of going through the registration process. Okay, so that is something to note. Okay, so let's go ahead and get into some of those alternatives. So the O1, okay, this is one that, individuals with exceptional skill in science, education, business, or athletics. Now, it is a pretty high standard, but if you can meet the qualifications, so 3 of the 8 O1 criteria in published work, major awards, membership in elite organizations, then this can be a really great option that could buy you some time here, and maybe you could switch over to another visa later on, or it could be a pathway to a green card, maybe a national interest waiver or something along those lines. Now, again, if a person doesn't meet H-1B for any reason, because they don't aren't make it in the registration process, they could go work on their skill set, their expertise, and then either try again the following year and or start building up their resume for potential O1. So this one is a one really good option, but the standard is pretty high, and it's not just for everybody. The L1, which I think somebody put a question about that. So you're usually looking at L1A for managers and executives. The bottom line with this one is that you've worked 1 year in the last 3 years in the foreign country, and then they're intercompany transferring you over here. There could be L1A for managers, executives. There's the L1B for employees and specialized knowledge, and there's also can be the blanket L. And some companies might qualify. They didn't realize that they did, and that could make it a lot easier for them to qualify for their employees. But the biggest thing to remember is 1 year in the last 3 years that they worked for the foreign-based location and that they're transferring over here. So that could mean like, okay, you didn't make it this time, go work for the company abroad for 1 year and then work on being transferred after that has happened. So that can be a great option. The other thing that's great about the L's is that spouse can work, and L1A has a 7-year cap and L1B has 5, but you can recapture time just like the H1B. And if you're gone from the country for 1 entire year, you can restart the clock as well. There's actually an L1 new office. So if you were to go start a company abroad and you wanted to make a new office in the US, you could also come here on the new office L.
I'm so sorry, Ruby, but
Yeah,
like asking you, so sorry to interrupt, but
no problem.
can you also please let us know the L1 and O1, how much long does it take for a process to get in completion? Because I think for H1B it takes years and years. So what's about the O1 and L1 also process? If you could please let us know about it.
You mean
The visa process.
completion? You mean like what's the max of it, or how long does it take to get it if you were to change status to it or to apply for it?
Not changing the status, only the beginner who is just going to, apply for the visa for the L1. So maximum, if you could please let us know approximate time, like how much will it take for that applicant to get the L1 visa approved?
Oh, okay.
Yeah.
Well, you could do either consular processing or you can do a change of status depending on where you are, and it really could mean a matter. So there's one aspect of how long does it take to get all your evidence
Yeah.
together, right?
Okay.
So that really is up to you and your attorney. And then there's how long does it take with the government to process. So let's talk about the consulate, because this affects pretty much everything we're talking about here.
Yeah.
There's a lot of there's a lot of consulates locations have been closing. There's been some staffing changes. I actually saw a headline about the State Department even today, that there's some changes happening. And when administrations change, usually there's a shift in personnel. What does that mean? Well, it could mean that things are going to take a little longer, or things that we knew before are not what they are today. So you can look online to see what the visa processing times are, visa wait times for certain visas at different posts around the country, around the world. I don't know if they're all accurate, but hopefully they are. And so it could be a matter of that processing time. Also with the change of status, if you can do a premium processing,
Okay.
right? That's $2,850, right? Yeah. And you can get the decision in about 3 business weeks. That's not available for everything, but yeah. So, I mean, I didn't exactly answer, one exact answer for everything, because it depends. Some things have premium processing, some don't. Some you might want to do a change of status because you're here in the country.
Okay.
Some you're going to do straight up consular processing. So it really can depend on that. So I think it really will, how quickly can you get the evidence you need? A lot of cases, I'm just going to tell you, it can take, I don't know, 3 to 6 months sometimes for clients to, like an O or a national interest waiver. I really see a lot of clients take about 6 months to get that together. So anyway, hopefully that gives a little perspective, but the processing times have been ebbing and flowing. So you really look to the State Department website about how long it takes to get visas scheduled, you also can look to the processing times on USCIS website. And then you also look to how long does it take for you to get your documents in order, and how busy is your attorney. So a combination of all those factors.
Absolutely. I mean, that is a little different thing. It depends upon case and case, and we can't just give exact number that these many months will be there and you'll get your visa. But also, Ruby, if you could also let us know that how L1 is better than H1B, or in what terms, if you can just give a brief comparison between the two visas so that it will be a little easier for us to understand that why this is one of the alternatives of H1B.
Yeah. Okay. Well, so one of the biggest things is that the L allows a spouse to work, and the H4, it's in very rare circumstances if they have like a perm pending, can they do that? That's
Mhm.
one big thing. The second thing is the L1A is usually goes to an EB1C, or more of a green card pathway, and you don't really have to wait too long to be in that L1A role to do that. So that seems to be a natural progression. The L1B, you're given that 5 years, but again, if you leave the country at during summer holidays, whatever, you can recapture that time. But it's a perfect. Um, it works really well with the perm process, just like the H1B does. So it's I mean, it doesn't mean like it's astoundingly better necessarily, but those are some of the things to consider. And you're not, you know, relegated to the registration process. If you
Yeah.
meet the qualifications, and you could apply it whenever you qualify, the 1 year in the last 3 years, and the company wants to go through the process. So those are things that come to mind that just sort of jump out at me. Yeah.
All right, that's great. And so sorry, Ruby, to cut your flow. You were going exceptionally flawless. Then please go ahead.
Oh, okay. Thank you. Well, I mean, there's still the STEM OPT extension. There have been a lot of like student revocation visas, unfortunately, in the last, week or two, but there has been a lot of litigation reinstating those. So, that's a very hot topic right now where things are, and usually that is a pipeline, right? It's usually F1 to H1B. That's a traditional pipeline. And then having the STEM allows you to have a couple bites of that registration apple, if you will. And so, that was great when they did the extension of the STEM OPTs. So, that's another thing what most people know about that
Mhm.
anyway. This next one is really only specific to Canadians and Mexicans. And this is so it probably doesn't cross some people's minds, but if you are eligible because of nationality, certain professions like a certain instructor, teacher, or lawyer, accountant, engineers, scientists, there are certain professions that are eligible for the visa, and Mexicans have to apply at the consulate. Canadians can apply directly at the port of entry. It's really seamless for the Canadians. And so this can be a really great option. It's a non-immigrant visa. Spouses cannot work, but there really isn't what do you call a expiration date? No, that's not the right word. I'm trying to say there's not a limit to how many you can extend it to. So some people can be in it for quite a while, but this is very limited to just those two nationalities. Another thing that's limited to nationality is the E2. So it could either be for the investor or the employee. But so maybe if you're like, I want to invest and be an entrepreneur and not actually be an employee, this is another option.
Mhm.
So it doesn't, the countries do not include India or Venezuela, but they do include Pakistan and Mexico, for example.
Mhm.
And depending on the reciprocity, you might get up as much as 5 years at a time, which is awesome because it's difficult to run a business. I mean, I know I've had one for like 15 plus years.
Mhm.
But it's difficult when you're in a foreign land and you're learning how things work, right? And so the E2 could be you make a business up from scratch. It could be you buy a franchise, and you also could be an employee of like if you're Pakistani, you could be a Pakistani employer of a Pakistani E2 business, for example.
Mhm.
Um, just to give an example. So this is a substantial investment. And and the other thing is spouse is allowed to work. So that's another great one to have as well. The H3 is another potential option. This is if your employer wants to bring you here to do some training, learning something specific to the way the business is done. And this could be a short-term visa to come here to the United States. It could help build up your resume, build up your options for the company wanting to keep keeping you in the fold and supporting you and keep trying at the H-1B in the future or some other mechanism, or even to do the perm process, who knows. So this is something I think a lot of people don't realize it exists, but it's an option. CPT program. And then like there's the there's the green card options, but again, like if you don't have a basis to stay in the country while you're doing it, then it would be done outside. I rarely find through consular processing, I really find a lot of employers willing to do this unless you've already had some type of relationship where they've seen your work product and won a petition for you. So, but at least I'm just throwing that out there as these are other options, including the national interest waiver, which it was a little bit, the standard was more clarified and easier under the prior administration, and we're starting to see things change as to what the national interest truly. And some of the things have differed dramatically. And then also just the standard has gotten a lot more stringent. So there were a ton of applications in the prior 4 years and a lot of approvals, and I think we're going to see a lot stricter adjudication. Thinking about dependent visas, who can work and who can't. We sort of ran through that while we were talking. In some limited cases, about H4, very limited. L2 is allowed to, and E2 is allowed to as well. And so, just evaluating what your options are. And the other thing to consider is maybe your spouse can apply for something, and then you can be a dependent. For example, if like they can apply for an E2 or an L, and you would be able to work on the dependent visa. So I often like to talk to individuals and say, what's your spouse doing? I don't mean to be, too inquisitive, but I mean, it's really because maybe we can have two options running at the same time. And, if we can look at their resume, we can try to see what we could try to get them into a visa, and then that can option, and especially if they have another nationality as well, that can also play into your options. So anyway, that was more or less those are some of the things to consider. There's also like the J1 and some other options, or going back to school, the F1, some people do that and get another degree and then have no more options on the OPT, but that can get costly. So, it might not be what people want to do. So
That's right.
That's a little bit in the summary of some options for individuals.
I think that was wonderful, and Ruby, thank you so much for putting up so much effort and preparing this presentation and showing up in front of our viewers. I think this was really giving a proper understanding and in a very detailed manner to each visa alternatives. Right? I think this was really important and much needed. So once again, I would say thank you so much for bringing that up. And friends, I'm sure that you have went through the presentation, and in case if you have any question regarding any visa or anything, then please go ahead and put your questions on the comment section. As I can see, there are so many people have joined us: Jadav, Shokat, and Jose. So hi guys, and thank you so much for posting your questions on Immigration Talk Show. We will definitely take these questions, but let me go ahead with one more question that I have. So, Ruby, I think, of course, this was a really very well presented, and we have got the understanding what each visa is made up of. So, I would like to know from your end that you are an immigration attorney and you have like a very good experience. So, according to you, what is that eye-opening case that you have went through where an alternative visa, anything O1, L1, or J1 have worked better for an individual who initially considered the H1B? If you could please let us know any
Oh,
case study, I think that would
well,
be great. Yeah.
it might take me a minute to think about that, but because sometimes when individuals don't make the registration, we part ways, and they maybe don't try again, or they with the employer that I was working with, and maybe they go to another employer perspective and another attorney. But I'll just share one thing that came to mind recently, because I see a question about TPS and someone having TPS. We just recently we had the whole Venezuelan TPS concern. And so we were like, okay, let's go out there. Let's check out. Maybe we have an H-1B. Let's do a registration. Let's consider other options. And not only did the TPS get, I guess what's the right word? I don't know. There's so much litigation going on, but
Yeah.
I don't think reinstated. I don't know. It's we still have it, right? I'm a loss for the words for the moment, but the client was chosen the H-1B registration, and we're working on an O as well. So I'm really happy for the client that we have, that we tried, that we put her hat in the ring, and she got a couple options, and the TPS didn't end, and so that gives us more options as well. So that I think really it is a team effort, right? It's the prospective employee or the employee, it's the employer, and it's the attorney. They all have to be working together in unison, and if anybody wants something different, it might, put to the process, hold it back, or not be able to go forward. So I think one of the things to say is just the more communication, the more the buy-in from the employer, the better, because then you're more willing to consider options, because sometimes employers are like, I'm going to try. If it doesn't work,
Mhm.
it is what it is, unfortunately. Or depending on the situation, they might work really hard to find other alternatives. So, um, yeah, that was we're still in the process, but it was a happy story so far, considering everything that's going on. So,
Absolutely, and that was really great. And also talking about TPS, Ruby, as you mentioned. So I think let's take up a viewer's question as well. So Jose
yeah.
is here, and Jose has asked, "Can I apply for H4 even if I have pending asylum and TPS?"
All right. Oh, righty. Okay, so I just listened to a CLE, Continue Legal Education, like about a couple hours ago on transitioning TPS,
Okay.
because it can be confusing, and it was an attorney who presented to other attorneys. But let me just issue spot with you some of the things that come to mind with this question. So the good thing about the H4, it's a dual intent. That's great. Asylum has a lot of immigrant intent in there about wanting to stay here in the country, and the TPS is, well, we won't. That's a temporary status. Now, one of my biggest questions to you, and we might not solve it on today's call, but I would say it's a consultation, is like, how did you enter? Did you have any unlawful presence time at all between your entry and applying for asylum or TPS? And did you ever work unlawfully? So those will be some of my questions, because depending on some of those answers, most of those answers will affect whether you could do a change of status to the H4 or not. But as I was saying, that call that I was on was really about this particular issue. How can we transition those who are on TPS to other things, especially we don't know what the future of a lot of the TPS is. Now, just in general, I when people have an asylum pending and they try to switch to another status, there's lots of different factors involved about whether they ever had worked illegally, had any unlawful presence, how they entered, and also can depend heavily on where they are trying to do a change of status, or an adjustment of status. And so that's where this can get a little tricky. So anyway, that's pretty much the extent of my answer. It is in theory possible, but it
Yeah.
really depends on your entry, how much unlawful presence or unlawful status time, and if you worked illegally in between your statuses. It would help answer the question. So I need to know that information.
That's right. All
Okay.
right, and Jose has shared something, so let me take up this as well. I entered with the tourist visa and I applied for asylum while I was here as a tourist.
hmm So in general, it should work. We didn't talk about working illegally or anything else or
Mhm.
any other aspect, but in general, if you entered legally and went from a status to a status, but I would be curious. Sometimes asylum is not considered a status, asylum pending. And I've seen this be inconsistent around the country interpretation. So really like to also see when you got your TPS in view of when your tourist visa expired. So yeah,
All right.
I don't know if we're going to solve it on this call. Like we might, because I would probably want to look at some documents and dates. But yeah.
Absolutely. I think that would be great. And Jose, why don't you go ahead and get in touch with attorney Ruby Pars, because she's definitely going to help you out. And we also have her email ID, phone number, and website, and that is just on the screen. Yeah, this is the number. 713-589-2085. With the email ID, you can also ask question by emailing her, and that is contact@rubypowerslaw.com. And you can also visit her website, that is www.powerslaw.com. So, Jose, go ahead and get in touch with Attorney Ruby. And till the time, if you haven't subscribed to our channel yet, and also make sure to get in touch with us as well and subscribe to our channel now. So, I think, Jose, you got your answer. And in case if you have any follow up, then please go ahead and ask another question. We are here for another half an hour and we will take your question again. So, Ruby, I think let me take up Shokat's question now. And
Mhm.
Shaukat is saying, I'm a current student on an F1 visa and I'm looking at options after my STEM OPT expires. So, could you help me understand the possibilities for transitioning into a work visa that doesn't require a lottery? Or is there something else I should be looking at?
I think we covered a lot in the presentation at the beginning, so maybe you answered your question since you asked this. It also depends on your nationality, and if you have a spouse, what their nationality, and like what other options there may be. Like we said, the E2, the L, the O, TN, H3. You could also go back to school. We didn't mention this, but there is the diversity lottery for certain nationalities. That also is another lottery. We are trying to stay away from the lotteries here. But I just wanted to mention that one because I didn't talk about that. There's also the religious worker R1. There's some of those other ones, or if you invest, there's also some creativity happening where, like, I mean, this might be too creative, but like if you get a visa, if you can get a citizenship in another country that qualifies for the E2, for example, and then wanting to, or it qualifies for the TN, or something like that. So you can think about those types of things as well. And while people are waiting out to come back in potentially, or if you're running out of status here, there's a lot of nomad visas that are around the world that can give people options to temporarily live in other countries where maybe they're working remotely for an American-based company, potentially, I don't know, but there maybe the individuals want in their home country, whatever their goals are, So really thinking outside the box is another thing when you're exploring alternatives as well. So hopefully some of that helps, but doesn't take the place of a consult. But yeah, there's exploring those options are important.
That's right. And I think thank you so much, Ruby, for putting up that. And Shaukat also, thank you so much for asking this question. In case if you have any follow up or want to know more about the topic, then please feel free to put them in the comment section. We will definitely take them up. And also, Ruby, as you mentioned about remote work and nomad visas. So I think let me also deep dive into this question that with remote work as it is becoming very common after pandemic especially, so how useful are visas like B1 or digital nomad visas for people who don't want to work, who don't want to go with H1B?
Well, you mean, so So it's really important to be careful about whether you're physically located in the U.S. and you're using the visa that doesn't allow you to work. So I'm not talking about that, but what I'm saying is, like, if an individual, let's say they're running out of, I don't know, H-1B time, and someone they didn't get petitioned, or they're running out of F-1 and OPT time, but they still want to stay relevant and in touch with like a US based company. Potentially, they could go work abroad, either like purposely, like with the foreign company's location, the company's foreign location in 1 year in the last 3 years, so they can get transferred over on an L, or maybe they just go work on the nomad visa, a nomad visa somewhere. I think they're popping up everywhere. Still working for the company, but they're not physically located in the US, so they don't have to have US employment authorization. But like what I've seen almost all the time is that you need to be in the US to build the connections with the US employers, to have somebody who knows you, to have some reason that they want you particularly, because it's, when you see a lot of different resumes, and they're trying to choose from one person to the next, it really can depend on having like that little extra connection as well. But if they know that they can keep working together, but maybe you're in another country on some type of temporary visa where it's legal for you to be over there, but you're still working for the US based company. Also could be possible you're working for the US based company and you're in the perm process too. And that that you're temporarily abroad waiting for more of a long-term solution for a green card potentially. So it's a very mobile world, and just sort of have to think creatively. But you also need to have an employer that really wants you to. So that unless you create your own opportunity and have your own business potentially.
That's right. That's wonderful. And also, Ruby, as you mentioned about that, it is also important to build up connections and to have a good networking, right? So you are an expert. So there are another question also that our viewers mostly ask, that how can they build up a better connection or have a better contacts? So if you could also give us a brief about just a little guidance, how can they have a better connection to US employers, or people those who want to get in touch with the US people?
Yeah, that's a good question. I think it can go different ways. Like it could be making a connection on LinkedIn, standing out somehow and trying to make a contact. I think it helps if you're a friend of a friend or something like that, where you're like, so and so said we should talk, or I'd love to make a connection with you. I think that warms things up and opens the door. If you're able to come to the US on like a B1, B2, whichever what your intent is, and you can go to some conferences or have some meetings, that aren't necessarily work, but you can make some connections, and then that can help start the conversation in the future that could carry through on over LinkedIn or Zoom and phone and things like that. I think that's why it's so valuable for those who've gone to school in the US, on an F1 or a J1, or temporarily even on exchange of some sort, because they've come to the US, they've made a connection, they've built up a little bit of a network, and that is helpful. But if you don't have that, then you got to work a little harder in different ways. Like maybe it could be through a webinar, or through mutual contacts putting you in touch, LinkedIn, or just reaching out to somebody and see if they'll respond. Those are just some, going to conferences. Those are some of the things that come to mind as well.
Yeah, I think that's brilliant. And these are the things that needs to brushen up through and through, because most of the time our viewers forget about these small pointers, and then they just get in trouble. So I think, Ruby, that was really important, and thank you so much for shedding light on those. And I think till now you have covered a lot of things, and I think let me go ahead with Jadav's question here. So, hi Jadav, and thank you so much for putting up your question. He's saying, I'm currently on an L1 visa, and while it's a great option, that's right, I'm wondering if there are any other alternative for someone in my position who wants to stay in the US long term but has a unique set of skills?
Yeah. So I think we covered a little bit of that in the presentation part, but usually if you're on an L1A, you're going to want the company to petition for your green card within those 5 years so that you don't run out of L
Mhm.
time unless you can recapture it. And that's usually your manager or executive of a department or individuals, and you can show how essential you are. The L1B, it's the perm process, and that can take a few years. And so you don't want them to wait too long to start that up because you want to make sure that you get it moving. If there's an audit, that could delay you some time. And unfortunately, and you really don't have a lot of control over that. But it can happen. So the L1A and the L1B, they are a natural pathway to a green card.
Mhm.
But if you're saying, but they are dependent on the company playing ball and being involved in that. So if they don't want to, or they get to it late, or you don't like the terms or whatever, if you have a unique set of skills, it could be an O1 or a national interest waiver. Those are the things that come to mind right away. Now, again, the national interest waiver is a green card process. You don't have to be in the U.S., but if you could take the control of that in your own hands, you don't have to have a job offer. So let's say the company is not wanting to do a perm or the EB green card process for you. I don't know which L you are, but then you want to take control of your destiny with a national interest waiver, or even potentially an O as well. So those could be some options. Again, we're just talking hypothetical without having more details, but that comes to mind as an answer.
All right, that's great. Okay, so thank you so much, Jadav, for your question, and hope you got your answer. In case if you still have any follow up or want to know more, then please go ahead and put them in the comment section, and we will definitely have a lovely conversation on that as well. So don't hesitate and put them right on there. And also, I would like to say, Ruby, with your permission, we do have some of our viewers in Facebook as well. So I think should we take up those questions as well if you're comfortable?
Yeah, yeah. I've got maybe another 10 or so minutes, so we can take some questions. So sounds good.
Okay, that's great. Okay, so Control, if you could please share the screen. All right. So this is a question we got from anonymous participant, and it is me and my husband are both Sudanese. I am a U.S. citizen, and my husband is currently living in Egypt. We recently got married through Sharia law, but we haven't traveled to see each other. So we don't have any pictures together. Unfortunately, we have a marriage certificate. Okay. Due to current circumstances, I'm not able to visit my husband in Egypt. So is there a way I can still submit the I-130 form without having to travel? I'm desperate for help. Any piece of advice, please help. Thank you.
Okay, so without me checking some things online, these are some of the issues you have to work through. Um, this sounds like this was a proxy marriage. I don't know if they were physically together when the marriage happened. If it was a proxy marriage, um, well, according to the law, I'm trying to remember if it's a regulation or where,
Mhm.
the relationship has to be consummated. So anyway, we're getting into some complicated territory if you physically cannot. Um, so let's just go back a second. Was this a proxy marriage, which means that you weren't physically at the same place when the marriage was officiated? That's going to cause more complications. Um, okay. And then the other one is that is the law of the land that where it was officiated, is that legal? Is that the way you have a legal marriage? So those two things, and then plus the fact that you haven't seen each other in a while,
Mhm.
those things are issues that I would my issue spotting brain is bringing up. Um, so if any of those are going to be an issue, then it probably is not safe to file the I-130. And I will say that when couples haven't seen each other for a while, I see the USPS and the State Department give a really tough time. So I think you might want to try really, 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 really hard to go see each other and
Mhm.
make sure it's legal wherever you officiated it without me knowing that off the top of my head. Um, and um, and I mean that's just the bare minimum, right? The other aspects are, commingling funds, photos, leases, taxes, all that other stuff. But I'm just trying to issue spot like the crux of the legality of the relationship. So anyway, I that's definitely a consult situation because you have to look at the reciprocity and the foreign affairs manual and things like that about the laws of the country that you officiated at. So it can get complex. So
That's right. I think, of course, those pointers are very great. And Ruby, I think we are definitely going to share with our viewers about the pointers, and I'm sure they will get their, solution in a better way. So let's move ahead with our next comment that we got. And Helen is here. Helen is saying, "Hi everyone, my employer applied for my H1B in January and I got approval last month. I applied for change of status for my spouse from F2 to H4 with the I-539 form online 3 days after my employer filed my H1B. So currently, the I 539 form is pending. I received the receipt notice for the I 539 form online in the account, but never received it in a mail. So is it normal? Will they send the receipt notice through mail for form I 539? I checked the address I put in there and it is correct. Anyone experience the same? Please let us know. Yeah.
well, okay. If they're sending it through USPS, I mean, it's been known to not work all the time, right? If you have an attorney, which I think you do, the attorney might have gotten the notice. So check to see what they got, because that's one of the benefits of having an attorney is that you get a copy and they get a copy. And if there is an email loss, that you have it in both places. I think there was a lot of change happening in the last few months with the change in administration. So it's quite possible that something went awry. But there's also, you can call USCIS and say you didn't get the notice and see if they'll send it to you again
Mhm.
after they confirm the address, all of that type of stuff. And sometimes when people just somehow the apartment number or the suite or the whatever, a drive or road gets taken off and or a zip code, and it could be a clerical error that has nothing to do with you or your attorney.
Mhm.
So those are just some things that come to mind, but it can happen.
That's
Um, I could
that's
probably take one more question if it's brief. So
Okay, that's great. And I think this was really important. And we are definitely going to share with Helen that how much it is important to have in touch with attorney. It's not only for Helen. I would suggest that, friends, it is a very tough time right now. And I think it will be great if you can directly get in touch with the attorney. So here are the contact details. As below your screen, you can see it is moving continuously throughout the show, the email ID, the contact number with the website of attorney Ruby L. Power. You can get in touch with her and also have any question or any issue if you're facing. You can directly share her on the contact number that is 713-589-2085, and the email ID is contact@rubyparslaw.com, and the website is www.rubyparlaw.com. So this is the contact detail, and with that, I think let me go ahead and take up another question that we got from James. So he's saying, "Hi everyone, our PD of Form I-130 is on September 2013. That is F3 category, married son or daughter. Petitioner is US citizen. So until which month can we expect to be approved? Please guide. Thanks."
oh well, who knows the answer? You go to the Visa Bulletin and you put on your thinking cap, and then um, you didn't tell me what country. You
Yeah,
didn't.
country it wasn't
Yeah,
mentioned.
it
Mhm.
was not mentioned. So, okay, Mexico. Okay, oh, Mexico. Okay, so, and then you said Could you put the question up a little bit higher, bigger again? So you said third preference, unmarried. So Mexico, third preference. For April's calendar, the final action dates for Mexico, third preference, they're working on January 2001. So about 12 years away from and the same for dates of filing. So they're about 12 years away from the date you just said. If it is in fact Mexico. So you just have to go to the visa bulletin every month and watch it. Again, it could move. A lot of times things move really quickly in October when the fiscal year begins and they clear out some cases. Sometimes people get green cards other ways, or they decide not to proceed, or they're not eligible, what have you. So, and do remember, like, this doesn't, if the individual is staying in the United States, it doesn't make them eligible to be in the U.S. just by having an I-130 pending. You need to have some other visa to allow, or you could be outside, preferably outside of the country if you don't have status. And so these are just, things to consider, as well as making sure that you don't overstay or work illegally, things like that. So it is unfortunately going to take a while, especially if the country of origin is Mexico.
Mm-hmm. Okay. Okay. All right. So let's move ahead with the next comment. And the next comment that we have got is another from anonymous participant. Is about last April 9th, 2025. My USC husband received an email saying USCIS has taken an action on our case. Till then, we did not have any further updates. We checked our document tab, but there's nothing there. PD was January 13, 2024. I am worried as it is already 15 months and I have seen a lot of approvals around our PD. So, what could it possibly mean?
Is this an immediate? This is an immediate relative I-130. I did just.
Mhm.
That's only a couple weeks ago. Um, if this is an immediate relative, I-130 spouse, I did, or even just immediate relative, I did get an I-130 approved for something I filed in January 2024 just recently. So, um, I mean, you could check again online. You can call the 1-800 number, but you're probably going to get something in the mail soon. You're probably going to get something because it's been a couple of weeks. Maybe it's or they're just still thinking about it. But yeah, keep an eye on that. I think you're in that time where you should get something soon.
Oh,
So, but I'm glad it's moving. That's good. Well, I appreciate you having me on today's show. I have to hop off to do some more immigration things, but hopefully this helped with answering some questions, and because there's a lot of changes going on, and I'm glad I could be a resource for everyone on today's show.
I think, yeah, that was absolutely great. And we are really honored to have a show with you, Ruby. It was my first time that I'm connecting with you. And I really enjoyed. I mean, I didn't know that you were, this energetic and this great in answering the questions. So I really loved it. And hoping to have another show with you. And soon we are going to connect again. But that's okay. You can continue with your work. Of course, we know how busy your schedules are. So that's completely all right. And thank you so much for joining us again. And it was really a pleasure having you, and have a great day.
You too. Thanks, everyone. Take care.
Thank you, Ruby. Thank you so much. Have a great day. Okay, friends. So those who have joined us, I think it was really great having you guys. And Jadav, Shaukat, Jose, and Seema, thank you so much for being here. In case if you have any other doubts regarding our today's topic or anything, if you're navigating any complexities in your immigration journey, then please go ahead and get in touch with Attorney Ruby Pars. The number is 713-589-2085. And you can also email her on the email ID contact@rubyparslaw.com, with the website www.rubyparslaw.com. And till the time, friends, that's it for today's episode. I hope that you liked it. And if you have liked watching this webinar, then make sure that you like this. Also, share this with someone who really needs to know about the alternatives of the H 1B visa. And most importantly, don't forget to subscribe, because by subscribing it really motivates us, and we obviously come up with amazing shows and amazing attorneys every week so that you can get more and more information. And also press the bell icon so that whenever we come up with any new video or any new webinar, you get the notification and you directly come up and participate in our webinars. So, till then, thank you so much, everyone, for being here. Stay connected, stay empowered, and don't forget to like, share, and subscribe to Immigration Talk Show. Meanwhile, I'm Sam signing off for now.
Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session that's lined up for you. And before we head on with today's discussion and also have our guest join us for today's webinar, I have this very important disclaimer to read out. So, by watching our videos, you agree and understand that information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind, friends, throughout this whole session. And I would like to tell you that you can also be a part of this session by commenting wherever you're watching us and also by calling us on this line where you can dial in. And the number is 425-436-6335, and the access code is 988-888. Absolutely. As you can see, the topic of discussion on the screen already, we are going to discuss about what are the do's and don'ts for the H-1B cap. And it's going to be very interesting a session. And most of you may have questions. So please feel free to join us with your questions. You can comment your questions or call in to ask. And also, if you're being thoughtful enough, share this link with your friends where they can also join in, especially if this is something they could benefit with. So share it, friends, with your friends and family, and let's do this together. And absolutely, without any further ado, please help me welcome our guest for today, Attorney Prashanti Reddy from the law offices of Prashanti Reddy. Hi, Prashanti.
Hello, hi Nipasa, how are you?
I'm doing good, Prashanti. It's always good to have you, and welcome back.
Thank you.
So, friends, Attorney Prashanti Reddy has been practicing immigration law here in the US for almost 3 decades now. So, you should definitely go check her out. And if you need a one on one consultation, why not contact her as well? Her number is 212-354-1010, or you can email her at prashanti@reddyesq.com, or go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy. So, yes, since it is the cap season and this is a very, very important topic of discussion, many of you have questions, especially with all the updates and this and that every day. We have a new thing, especially with immigration thrown at us. So, Prashanti, what would you like to tell folks out there before we start today's session?
Um, yeah, it's really hard to keep up, as you said, because something new is happening every day and not in a good way. I wish it was. Um, but and we are getting blindsided and losing focus with reference to our regular, immigration work with reference to H-1Bs, etc., because something or the other is coming up. But we have to keep in mind that there is regular work to be done and we shouldn't lose sight of that.
Yes.
and it's business as usual for the H1s. So, a lot of people filed registrations this year. People thought that there'll be very few registrations filed, but that was not the case. It might be slightly lesser than last year, but it's not that much less. So there is still demand. Companies still need employees, and they have enough business to require new employees. Um, we also have to keep in mind that the deadline for filing your H1B cap is fast approaching. So we decided to, go back on track and get back to our regular business of filing H1Bs and other work visas for our clients as they need them. With the whole, student CVIS termination, things seem to have been resolved in a positive manner. We can get back to, as I said, our regular work. So we thought we'll talk about, the H1B cap again and the do's and don'ts, so that we can help employers and employees navigate, their H1B filings this year, which have to be filed before June 30th. So let's get right to it.
Absolutely, Prashanti. And June 30th may seem like a long time, and you may think that you have a lot of time in hand, but I think I would like to say, friends, that don't keep everything till the end. Work on it while you still have time, so that if there's anything more to work on, you'll have time later. So, yes, Prashanti, let's go ahead. So, if you could tell us, some of the most common mistakes that can lead to H1B registration denial.
Registration denial. Oh, since we're already done with registrations, I think let's
Yeah.
talk about the actual cap, right, Nibasa?
Okay.
Um, so let's go to a question that addresses the H1B petitions rather than registrations.
Okay. Sure, Prashanti. But would you like to tell any of the common mistakes that they should avoid, while they are in their petitions?
While filing a H1B petition, you mean?
Yes. Is it allowed? Can you hear
Yeah,
me?
yeah, I can hear you. So, yeah, since the registrations are over and we don't have to worry about them until next year, let's talk about the actual filing of the H1B petitions.
Hmm.
And your question was, what are the common mistakes to avoid
Some
while filing?
some common mistakes, right? Some common mistakes that can, lead to denial of the whole petition also.
Right. So, one of them that I can mention, and we can go over a whole laundry list of items, but one that comes to mind is not paying the correct fee. USCIS fee is very complicated, especially for H1Bs, depending on the number of employees you have, depending on whether you are, um, a nonprofit, uh, or you are a for-profit organization.
Mhm.
The fees change, and there are many different kinds of fees, and all these different kinds of fees change. So it's very complicated to put it shortly. So it's important to know what the fees are. Number one, so contact your attorney to find out what the correct fee that you need to pay is, or at least do proper research to see what it is. And not only the fee changes depending on your number of employees that the company has, it also there are different fees, different kinds of fees applicable in different circumstances as well. So if it's an extension, it's a different fee. If it's a cap petition, it's a different fee. If you're over 25 employees, it's a different fee. Under 25 is a different fee. If you're a nonprofit organization, there's a different fee. So as you can see, and there are various different, there's an asylum fee, there is ACWIA fee, there is, a fee, the regular H1B fee. So, it's just so complicated that sometimes even I get confused. So make sure you know what the different fees are and make sure which fee is applicable to you and how much you need to pay. The second, again related to fee itself, is write the check properly once you've determined what the fee is. Make sure you put in the right fee amount. If you're especially filing by mail, put in the right amount, sign the check, date it properly, put it in numbers, and so often um, cases get rejected. And we're talking here not about how to avoid an RFE, but how to avoid rejections from the mailroom itself. And this is one of the reasons for rejections. It doesn't even go to an officer if you don't put a proper check or the proper fees. Another reason why it would get rejected in the mailroom is if you don't send it to the right address. Sometimes they do forward it to the right address themselves, but oftentimes they will just send it back. Third reason, if you're not filling out uh, tick marking certain boxes, especially with reference to fees and cap exempt and start dates, then they will just send it back from the mailing room itself. Because you might have sent the correct fee, but you might have marked the wrong box, so they think that you sent the incorrect fee. So that's another reason. Third reason is if you have not signed the petition. Even if one place, there are several places where the I-129 petition has to be signed by the employer, and if you miss out signing even in one place, then they'll send the entire petition back. They will not send an RFE. So that's another common mistake. And remember, the address is very simple for CAP cases. You just have to follow your registration notice to find out what the address is. So these are some of the common mistakes that can lead to the petition coming back from the mailroom itself.
Thank you so much, Prashanti, for going through all of these very important points that we need to keep in mind so that we avoid, making it fall heavy on us. So, friends, I hope you're taking notes. And I would just like to greet our friends who already joined us. Hi, Rag. He says, good morning, Nipa and Prashanti. Well, good morning to you, Rag. On our end, it's already afternoon. So, good afternoon to folks. Good evening. Thank you so much, everyone, for joining us. And we're looking forward for you to participate also with your questions. And we have Seema Patel. Seema, stay with us. We will take up your questions. But for now, we will head on with some of the other questions which I have also for you, Prashanti. And if you could tell us, if it is allowed for the same person to be entered into the lottery by more than one employer.
Um, yes, you can be. And um, again, Nipasa, I don't want to talk about the lottery, so let's
Okay,
try to avoid the registration questions. But
sure.
yes, it is. You are allowed. A beneficiary can file as many lottery petitions as they want, but a petitioner cannot file twice for the same beneficiary.
Okay, okay. So, all right, then let's go on with our next question, Prashanti. And this is if you could tell us if can an H-1B gap petition be filed for a future job position or should the job exist right now?
That's a good question. So, with reference to that, um, yes. Um, sorry, what was your question again? I was just sorry about that.
I was asking if, the question is, can an H-1B gap petition be filed for a future job position or should the job exist right now?
Okay, got it. So, with reference to filing any H-1B petition, whether it be cap or non-cap or a transfer, an extension or an amendment, you have to show that there's a bona fide job offer, and you have to show that the bona fide job offer exists as of the time of filing the H-1B petition. So, while the petition can start in the future, so all cap petitions can only start as of October 1st because that's when the new fiscal year starts. But you have to show that you have a job for the person as of the date of filing, even if it's a start date of October 1st. So, to give you an example, if you are a consulting company, you have to show that you have a purchase order or a work order or a contract from the client where the person is going to be placed, showing a start date of October. But the contract should have been signed as of the date that you're filing the petition. So you should already have work. You cannot tell USCIS that, I don't have a contract right now, but I will get a contract in October or November. or I will look for a contract once the person gets on my payroll. That's called speculative employment. So that's not allowed. So you have to show that you meet all the requirements, whether it be employment or the other requirements, uh, of the H-1B petition as of the date of filing the petition.
Okay. Thank you so much, Prashanti, for taking that up and for clearing some of the doubts maybe even our friends have out there. And hi, Jadav. Thank you for joining us with your question. We will take up your question very soon. And I also want to tell folks out there that if you haven't as yet subscribed to our channel, subscribe now. I hope you're not waiting too long or procrastinating. Subscribe now and ring that bell icon so that whenever we have discussions like these, you are notified and you can join us with your questions. Also, best thing is that you have this opportunity to take where you can call in and ask your questions to the attorney directly, and the number is 425-436-6335, and the access code which you'll have to dial right after the number is 988-888. So join us. Okay, Prashanti, now I have this next question for you, and that is, well, now that the H-1B CAP registration is over, what are the next steps for employers and selected candidates, and how can they prepare strong petitions before the filing deadline?
Next steps for employers, if they've already been selected, is filing the H-1B petition, and ensuring that um, meet all the requirements, as I just said, towards getting a H-1B petition approved. So in order to prepare a strong petition, you have to meet all the basic requirements of a H1. Um, and of course, as I said, you have to avoid the package coming back from the mailroom, and we already discussed in what instances it can come back. But with reference to the substantive requirements for a H1B petition, you have to know what those are in order to prepare a strong petition. So, first thing is that you have to have a job that is a specialty occupation, that is the job that requires a bachelor's in a specific field. And you have to be able to prove that your job requires a bachelor's in a specific field. And there are many ways of doing that. One of them is just going to the Department of Labor website, which is the Occupational Outlook Handbook. This is available online as well. And you can look at the various positions and that are listed in there and what the job requirements are for those positions. So and then you have to make sure that, um, as the other half of the specialty occupation requirement, you have to make sure that the employee has the degree that's required for the position. So you have to show that the job requires a degree and that the employee actually is qualified for that particular position. So that's a specialty occupation part, which is an essential part of filing a H-1B. And with reference to the specialty occupation, make sure you uh, produce enough documentation to convince USCIS that it is a specialty occupation. So that's one way of making your petition strong. And that information is, giving a strong job description, giving a detailed, specific job description, showing that the job is complex enough to require a bachelor's in a specific field. For example, if you're doing a bachelor's as a software engineer, if you're doing a petition as a software engineer, you would put in a job requirement, a job description showing that the complexity of the job. You would say design, develop programs, that kind of thing. You would use the word design and develop. You would use the word analyze, anything to show that the job requirement is complex. You wouldn't use the word test or because testing is not considered to be um, a high level requirement in the IT space. You wouldn't necessarily use the word program, because programmers, again, don't require a bachelor's degree for a programmer, just a computer programmer. So you would avoid using those kind of words, and you would use design, develop, analyze, that kind of description when you're giving a job description. So a strong job description, a detailed job description with examples really helps your petition and helps to show that your position requires a bachelor's degree in computer science. Just giving you that example of a software developer or software engineer. So that's Then you'd also make sure that, as I said, the job cannot be speculative. So one is specialty occupation, which we covered. The second part is speculative employment. So you have to make sure that the job is, you show that you have a requirement for the job, even if it's a future requirement. So in order to show that the job is not speculative, you would submit documentation such as a contract, a work order, an MSA, right? So that's the second part, showing that providing strong documentation to show that the job is not speculative. Third, documentation to show that you qualify for the job, for the specialty occupation job. So you would submit your degree copies, all your transcripts. Just a degree copy is not sufficient because it does not actually show what subjects you learned, and so the officer cannot see whether the subjects are related, the courses are related to the job description or not. So you would put in all your transcripts, you would put in your degree copies, you would put in an evaluation of your degrees if you have a foreign degree, because again, you don't want USCIS to speculate whether the foreign degree is equivalent to US degree or not. So that in order to avoid that, you would put in an evaluation from an accredited evaluation agency showing that your degree is actually equivalent to a US degree. And then if you're filing a change of status, even if it's a cap petition, last but not the least, you have to show that you're maintaining status. And in order to show maintenance of status, you would put in documentation to show the status. If you're on F1, you would put in a letter from your school showing you're maintaining status. If you're on OPT, you would put in your EAD document and a letter from your employer where you're working on EAD, or you could be putting in pay stubs to show that you're actually gainfully employed on a STEM OPT if you're on STEM, because on STEM you have, it cannot be work that is not paid. It can't be voluntary work. It has to be paid work. So you'd put in your pay stubs. If you're on CPT, you might want to put in documentation to show whether your college requires you to work while you're studying. Is it a work study kind of requirement? And you get credit for the work that you're doing. You put in that kind of information. So this is the kind of documentation that you can put in to show that, in order to prepare a strong petition to show that you qualify for the H1 and to avoid an RFE.
Okay. There you go. Thank you so much, Prashanti, for the detailed explanation, and I hope that folks out there were already taking notes. And I think we should take up a couple of questions also from the audience so that they don't feel like they're ignored too much. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Find us not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Connect with us. So now I got this question from, let's take up Seema's question. The first question we have is, I've been hearing about people getting their H-1B petitions rejected because they didn't meet the cap requirements. How strict are these rules, and can anything be done if a petition is rejected due to missing the cap?
You cannot even file a petition if you have not registered and being selected in the cap. You cannot file a petition after the period that you're supposed to file. That is, you're given 90 days. So you have to file within 90 days, and there's nothing you can do really if you filed after, unless you're able to show that you filed on time, but for some reason USCIS has lost your petition. Even though I have done that last year, and we filed a few petitions even after the deadline, and we filed them online and they were accepted, but they were actually filed on time initially, but there was some issue with the petition, and it came back, and therefore we were able to refile it. So sometimes USCIS might take that into consideration, the fact that you filed it and there was some issue with FedEx delivery, and for no fault of your own, it didn't get delivered on time, etc. So it's always worth a try. And I think that's what SEMA is asking, whether if you miss the date, filing the cap and it gets rejected because of that, can you refile? Yes, I've done that, but you can't always depend on USCIS accepting those kind of petitions. Um, if they didn't meet the cap requirements, that really depends on what you mean that they didn't meet the cap requirements. If it gets denied after an RFE because the H1B requirements were not met, maybe you'll have a chance to respond before it gets denied because you will most probably get an RFE. Um, and then you can submit your explanation in an RFE or hopefully make amends when you're responding to the RFE. Of course, there are some things that you cannot make amends on, such as if you already have an LCA approved, and if the LCA was not filed correctly, you cannot file a new LCA at that point of time. But rejections also, Seema, with reference to mailroom rejections, you can refile, resend the case if it gets rejected in the mailroom. But remember, this has to be sent out before the 90 days period that is given to you. If you get the package back for some reason after the 90 days period, then as I said, you can try sending it out, but you can't expect always to be successful in those cases. It really depends on a case by case basis.
Right, right. Thank you so much, Prashanti, for taking that up for Seema. And Seema, I hope you got your answers. If you have more clarifications to make, kindly keep commenting with your questions. So this next one is from Jadav, and he's saying, if I apply for an H1B under the cap and my employer gets audited, what should I be ready for in terms of paperwork and extra checks? Is that something I should be concerned about?
Yes, because if your employer gets audited, and these are called FDNS visits, and this is a good segue into a little bit some information on FDNS visits. So this is the fraud detection unit of the USCIS, and after cases get approved, they sometimes conduct audits, and they have in-person audits. So they come to the office, they might call the beneficiary to ask questions as to what kind of work you're doing, who you're working for, who the client is, what your work location is, and they might ask the same questions of the employer as well. So they want to make sure that you are maintaining your status as per the LC approved LCA. So they want to make sure that you are at the location as required by the LCA. You are getting paid the prevailing wage as required by the LCA. So they often do these checks after the fact, after the approval, to make sure that you're, maintaining status. And you have to be aware of this, because if FDNS site visit doesn't go well, then they can ask USCIS to revoke the petition, and then you'll fall out of status. So it is important that you speak to your employer if an FDNS officer contacts you. Speak to an employer, be on the same page as your employer before you actually talk to the officer. Be aware, take a copy of the entire H1B petition, be aware of what was submitted, what your salary is, that you're getting that salary, what the work location is, maintaining everything as per the terms and conditions of the H1B petition. So, yes, it's important that you know what is in the petition and that you maintain it and you're following
Very,
everything as per the petition. Yeah.
yes, yes. Thank you, Prashanti. Thank you for taking that up and for the detailed explanation. It seems like every point is so important. I really hope that friends out there, you're not missing out on anything. But the best thing is that you can always go back and rewatch even after this live stream has ended, and that you can do by watching it in our space. Our handle is at Immigration Talk Show. Don't forget to subscribe to our channel. All right. So Rag, hi again. He has a question for us. So Rag is saying, can I manage my startup as a CEO on H4 no EAD if I'm not taking a salary?
I suggest you don't do that because on H4, you're not supposed to be working, and managing your own company is working. So you should wait until you get your H4 EAD.
Okay. All the best, Rag, and I know you will get it. So go apply for it. Thank you, Prashanti. Now let's take up this next one. This is from Nirav. Hi, Nirav. Thank you for joining us here on YouTube. And Nirav is asking, how does the H1B cap lottery process impact the priority dates of petitions? Are there selected that are selected? Sorry. Let me take that again. How does the H1B cap lottery process impact the priority dates of petitions that are selected? And what are the implications for petitions that are not selected, particularly in terms of maintaining the beneficiary's immigration status and eligibility for future cap filings?
I don't understand what he means by Nirav means by priority dates, because the priority date is usually used for green card petitions, not used for H1Bs or for registrations. But trying to decipher what Nirav is asking, um, once your H1B lottery is selected, um, then you file for the petition, and uh, whoever files the petition first, it's first in, first out. So
Mhm.
people who file their petitions earlier will get approvals, or they will process their cases first. Um, for petitions that are not selected at all, then you can try in the next lottery, and you could be selected. It does not in any way impact, your next lottery, because the lottery system is a lottery. It's completely random. So it doesn't matter how many times in the past you have applied for the cap lottery.
Okay, that's interesting. Thank you so much, Prashanti, for taking that up. And thank you, Neera, for participating with your question. And
Also,
yeah.
to the beneficiary's immigration status, if you're not picked in the lottery, then your status remains whatever your status was. It's status quo, basically. You have to continue to remain in status. If you're not in the country, of course, then there's no question of status. If you get picked in the lottery and you file your H1B petition, then as of October 1, or whenever your H1 gets approved, then your status changes to a H1, whichever is later. So that's how it impacts your status.
Sure. Okay, thank you so much. And friends, don't forget that, this is your opportunity to join us with your questions. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. Also, best thing is you can comment your questions and we will be happy to take them up. So just check us out, not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So yeah, now coming back, Prashanti, to some few of our questions before we head on with the other questions from our audience in Facebook. Well, I have this next question, and that is: are there any restrictions on changing employers after being selected in the H1B cap?
Yes, that's also a good question, actually, because a lot of people ask me that question. They file for registration through some employer, and that employer doesn't want to file a H1B petition, and they think that they can now file a H1B petition since they're selected in the lottery through another employer. So that's not possible. The lottery and the selection is tied to the employer that did the registration. So if the registration gets selected, then the employer that's filed the petition, filed the registration, must file the petition. Of course, once the petition is filed and approved and you started working, you can always file for a transfer of the H1 from that employer to another employer. So if you do want to move employers, that's the way to do it. But you cannot do it before, you know, before you start working for the original employer.
Okay. Yes, many people actually ask this, and sometimes it's like they want to change from employer A to employer B or to employer C, and it becomes difficult, I think, right, Prashanti? And they're not allowed to do so.
Correct, yeah, because the registration, as I said, is tied to the employer. So unfortunately, if the employer is not willing to file a H1, and that's completely possible nowadays, because they do the registration in anticipation that there will be work available, because they don't have to show necessarily the work availability at the time of registration. And then they are not able to file the H1B petition because they're not able to find work,
Mhm.
because something has changed, because the market has changed. And we see a lot of registrations are wasted because of that. And that's the reason USCIS sometimes conducts a second lottery, because even though they're selecting more people than they should, even in the first lottery, they're selecting about 100,000 or 120,000 when we only have 85,000 slots. They're
Mhm.
accounting for that, but their accounting falls short because many more people don't file, and they sometimes that's why have a second lottery.
Right. You think it's going to happen this time as well?
We have to wait and see. But even if there is a second lottery, it's not going to be big numbers. It'll just be a few
For a
cases.
smaller number of people. Let's see. Let's see, friends. We don't know what's going to happen, so we'll just have to wait and watch about the second lottery. But now let's concentrate on folks who got selected in this lottery and who are planning their next steps or are already on it. So, yeah, now next question for you, Prashanti, is if you can tell us, are there any restrictions on changing? Oh, sorry, we took this. So, is it okay for a candidate to work on CPT or OPT while waiting for H1B approval?
That's also a very good question because I've been receiving that, a lot of people asking me that question. A lot of people think that once they get selected in the registration, that they should work for the that company who filed their registration, and filed their H1 maybe, even before the October 1st or before the H1 gets approved, they should be working with them on CPT and OPT. It's not necessary that you should be working for them. You could be working for another employer and start working for this employer once the H1 gets approved after October 1st. So you could be working for a completely different employer on CPT and OPT. But your question was more, do we have to work on CPT and OPT once it gets selected? Yes, you have to continue maintaining your status until you change status, until your change of status gets approved. You have to continue maintaining your status on F1. And if that means that you're working on OPT, then you have to continue maintaining your status on OPT. And if that means having to work because STEM OPT requires you to uh, you know, uh, work for money, then you have to continue doing that in order for your H1 change of status to get approved. Otherwise, they'll say that you're not on valid F1 status and they will only approve your H for consular processing.
Right, right. Thank you, Prashanti, for taking this up as well and for the detailed explanation. Now let's go on to our next question, and that is, what happens if an H1B petition is selected but later withdrawn by the employer? Can the candidate reapply? Like you already touched on it just now a bit, but can they reapply?
If the registration is selected but then withdrawn, is that what they said?
If the H1B petition is selected but later withdrawn by the employer?
Ah, well, depends. If is it withdrawn before the H1 gets approved, then you're not considered to be cap exempt. You'll have to file again for registration next year. But if it was withdrawn after you start working for them, then you will still be considered to be cap exempt. And then you can file your H1 using that 60 days grace period, uh, you know, and find another job within the 60 days. Or if you already have another job, just file for a transfer.
Okay.
And it is cap exempt. So.
Yeah. Well, thank you again, Prashanti, for taking this up. And folks, if you're resonating with Attorney Prashanti Reddy, her, taking up each of our questions and patiently answering them so well, why don't you give her a call, or maybe you can choose, for your case as well. So her number is where you can reach out to Attorney Prashanti Reddy, 212-354-1010, or go email her at prashanti@reddyesq.com, or yes, go check her out at www.readyesq.com. And also, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. If you haven't as yet subscribed, what are you waiting for? Subscribe now, friends, and share this with your friends and family who could benefit a lot with all the latest information we have on US immigration. So, yeah. Now let's take up some more of our questions from our audience in Facebook. So, Control, if you can please display some of them, please. Let's go on with them. So we got this First question from an anonymous participant. When you file for I 130, you choose the service center. Do we have the choice? Please help. Thanks.
It's can you choose the service center? No, you cannot choose the service center when you file an I-130. You have to. There is a list of service centers that I-130 goes to, based on where your if you're the petitioner, wherever you're living. Uh, Based on the state that you're living, you file it at that service center.
Okay. Thank you, Prashanti, for taking that up. Let's go on to this next one, which says after approval of EAD I 765 and I 485, what is it? What is next? Does I 485 go with insurance of green card? And does the I 130 and when does the I 130 get approved?
Does I-485 go with issuance of green card, and when does I-130 get approved? Um, yeah, but so usually I-130 will get approved before the 485 gets approved, or both will get approved together. And after the 485 gets approved, then there's an issuance of the green card, because that's when they get the card in the mail. So first you most probably get an I-130 approved. First you might get a 765 approved, which is your employment authorization, because that's given as an interim benefit while the petition is pending. Then you might get an I-130 approved, and then the 485 might get approved, or the I-130 and 485 could get approved together. And once the 485 is approved, you'll get I-797 approval notice, and then you will get the green card, the actual card, in the mail. It'll be mailed to you.
Okay. That's nice. Thank you so much, Prashanti, for taking that up. And now let's go on to this next one, which says, hello, my husband and I are in the middle of process of marriage green card. He is in Mexico. I'm in US citizen. I am the US citizen, and our I-130 got approved, and we are waiting on information from NBC. My question is, as a US citizen, does it affect anything if I decide to get Medicaid? Medical in my case.
I don't know what Medi-Cal is, but Medicaid. So it doesn't matter that you're getting Medicaid, as long as the applicant, the beneficiary, has. Even it may not matter even if the beneficiary doesn't gets Medicaid. But what is important is that the beneficiary should not be considered to be a public charge. The beneficiary would be considered to be a public charge if you know they've as per at least the present definition of a public charge, and that keeps changing again, and it might change again under the Trump administration, because under his previous term they had expanded the meaning of public charge. But presently, public charge means a person who has received actual money for sustenance, and a person who has received long term, um, has been admitted long term into a rehab kind of facility at the government's expense. So those are the
Okay.
two uh, factors which will disqualify you from getting a green card based on the public charge rule. Um, Also, you as the petitioner will have to have we sponsor them and fill out an I-864, which is the affidavit of support, which means that you have to have enough income to be able to sponsor them, depending on your family size, $25,000 or more. So if you're on Medicaid, does that mean that you don't have sufficient income? Uh, so I'm not sure what it is, but you have to be, if you're not able to sponsor them because you don't have sufficient income, then you might, or you're retired, you might, you have to get another sponsor, then an additional sponsor, a joint sponsor, who will fill out again the affidavit of support and submit their tax return. So as you see,
Okay.
there's many nuances to it. It's not just, uh, they might be, I've answered questions that you might not have asked also, because you may not have known to ask them.
Yes, yes. And actually, they've just put up a situation about themselves. So Of course, and I do not know what is Medical. So thank you so much, Prashanti, for taking that up. And I hope that this was sufficient and a good answer for anonymous participant from our Facebook group. Thank you so much. So let's go on to this next one. This is also from an anonymous participant asking, "Hi, I petitioned for my mom's green card in June 2024. She was interviewed 4 weeks ago at Santa Ana office. I-130 was approved the next day, but I-485 is still pending after 4 weeks. Is this normal nowadays?"
Well, a 485 can take a while. It takes 12 to 18 months for a 485 to get approved. So that's how you have to count the processing time. Not from the date of the interview. The interview can take place anytime in between. It's not necessary that the interview will take place at the fag end uh, of the case and then it'll get approved immediately after. So processing time varies. So I would just look at the overall processing time and see whether you're within the normal time or not. So if you've applied in 2024 June, it's still not even a year. I wouldn't worry.
Okay. Well, thank you so much, Prashanti, for taking this up. And now let's go on to this next one saying, "Hello, I'm looking for an immigration attorney. My husband and I have been married 5 years and we have a house and children. We have filed I-130 and it is being reviewed. However, my husband's I-485 was declined due to not sending the correct documentation. I sent 2022 W-2 and not 2023. We have to appeal with an I 29 209B. They are revoking his EAD to work. Has anyone gone through this? And do you have any recommendations? Do you have lawyers or attorneys that can help ASAP? Absolutely, yes. We have Attorney Prashanti Reddy here. And Attorney Prashanti Reddy, what would you like to say to this?
Definitely, you can call me up and I can give you a free consult, and then we can decide, how we can take the next steps. And this is an example of why you shouldn't be filing the petition yourself, because this could be an easy fix and you didn't have to get a denial. It's possible that you can also maybe consider refiling your petition or filing an appeal. You could do either one, and we can look into it and once we know more about your case. Yes, unfortunately, the EAD will no longer be valid because the 485 has been denied.
Mhm.
Remember, when you choose between filing an appeal, refiling a case, there are many considerations. So you have to do what is right in your situation. In some situations, it's just easier to refile. In some situations, you cannot refile because maybe the person is out of status and if they're not married to a US citizen. In some instances, it's important to get EAD, so they might want to refile so that they get the EAD again, because a motion to reopen can sometimes take a while. So these are the things to consider when deciding, and also it depends on why it was denied and whether USCIS is likely to approve the case on appeal or it's a better idea to refile the case entirely. So these are the considerations that we have to discuss before we decide which approach to take.
Right, right. Thank you so much, Attorney Prashanti Reddy, and well, anonymous participant. If you're watching us right now, you can get in touch with Attorney Prashanti Reddy on her number 212-354-1010, and her email address is prashanti@reddyesq.com. And when you do contact her, don't forget to let her know that you got the contact or you watched her here at Immigration Talk Show. So thank you so much, Prashanti, for taking this up as well. And I do have a couple more questions if you have a little more time, maybe.
Sure.
So, Prashanti, this next question that I have for you is if you can also tell us, what happens if an H-1B petition is selected? I think we've taken this. So, this
Yeah,
next
we
one. Yeah. How can an employer prove the job, a specialty occupation to meet H-1B eligibility?
How can the employer prove that the job is a specialty occupation to meet the H-1B? I think we kind of discuss this a little bit
Okay.
um, with reference to specialty occupation, but very briefly, you have to show that the position requires a bachelor's degree in a specific field. And how you show that is you can show that it's common in the industry to require a bachelor's degree in a specific major. How do you show it's common? You can print out DICE and Monster job site listings, and you can print out several to show that, look, this is a position, and all these positions require a bachelor's degree in that field. You can also go with the employer's uh, previous practices. So if they've hired a person with a bachelor's degree in a specific field previously for that particular job, you can show proof of that. You can also go to websites like the Occupational Outlook Handbook, which lists positions and um, basically talks about what the common requirements are for that position. So these are three ways where you can show that the job is a specialty occupation. If you're not able to show any of this because maybe the industry generally doesn't require a bachelor's degree, but you require because for some special reasons, then you have to show the complexity of the job and why you require a bachelor's degree and how your job is different from other jobs, and and it's why your job is more complex when compared to other jobs, and therefore you might require a bachelor's degree in that particular field.
Okay. Okay. Thank you, Prashanti, for taking that up. And well, before we go, if you could also tell us about what should employers avoid when offering remote or hybrid work in an H-1B cap petition.
It's perfectly okay to provide remote work or hybrid work. You should put all the work locations in the LCA, so please make sure you do. Please make sure you pay the salary that is the highest among all the locations. That's a requirement. Also, what you have to make sure of is that you keep track of your employer. So if they're moving houses, they might move without telling you, and then you would not have filed an amended petition because the work location has changed. Most probably, salary has changed. Then they fall out of status. So please inform your um, employees that they need to let you know, and you need to file an amended petition before they change their home location if they're working out of home. You also have to be aware that if it's a home location, that the offices can come and visit your home. And you have an LCA posting requirement at the work location. So if that's your home, you have to post it on your fridge or wherever it is that everyone can see. I know it sounds ridiculous, but that's a requirement. And you have to be ready to welcome the officer into your home, show them your workspace, and answer any questions that you have if there is an FDNS visit.
It's very interesting. And thank you so much, Prashanti, for taking that up. Absolutely important. I hope that friends, you are, taking notes and are able to follow what we have been discussing. And thank you so much, Prashanti, for taking that up as well, very patiently answering each of our questions. So I think with that, we have definitely covered almost all. But still, if we have anything left, Prashanti, maybe you would like to give an end note before we leave.
Um, File your H-1B petitions carefully. Use an attorney or an expert to file them. You have won a lottery, and it is really a lottery in the true sense because it's difficult to get through. So don't waste that opportunity. Make sure you file your petition correctly and in a timely manner.
Sure, absolutely. Very, very nice of you to say that and remind friends out there. So thank you so much, Prashanti. It was great having you with us today. And I hope to see you soon again.
See you again next week. Thank you, Nipasa.
See you, Prashanti. Thank you. Have a great day. And folks out there, you can also contact Attorney Prashanti Reddy. And in case you especially want a one on one discussion, every case is different. So why not give her a call? Her number is 212-354-1010. And you can also email Attorney Prashanti Reddy at prashanti@reddyesq.com. And when you do, please do not forget to mention that you watched her here on Immigration Talk Show here on our channel. And she'll be happy to, assist you and Well, that said, you can also subscribe to our channel. Don't forget to do that. Our handle is at Immigration Talk Show. You can find us not just here on YouTube, but also on LinkedIn, Facebook, X, on Instagram. Connect with us, stay connected with us. And yes, this is it for now. You can also contact me, by the way, in case you have any questions, which we will be happy to address, with an attorney. And my number is 408 335 6444. You can call me. You can also WhatsApp me. That's my WhatsApp number. And you can also email me at nipa@staffingly.com. So this is it for now. But don't go anywhere. Keep watching Immigration Talk Show because there's a lot more coming here. And there's so much good and latest information on US immigration that you really do not want to miss out on. So keep watching and bye for now. Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session. So, thank you so much, everyone, for joining us. And if you think that this episode is going to be helpful for your loved ones and your folks out there who could benefit, especially with today's discussion, please do not forget to share this link with them. And they can join us, they can watch us, they can even ask their questions if they have any, because we're going to have a very esteemed immigration attorney who's going to join us and will be very happy to give you the answers. But before we head on to welcoming our guest for today, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope that you'll keep that in mind and feel free to join us. And you can do that by commenting wherever you're watching. We are live right now on YouTube, LinkedIn, and also on Facebook and on X. Check us out and do not forget to connect with us also. Follow us, subscribe to our channel at Immigration Talk Show. That's our handle. And also, you can check us out. We are on Instagram. So join us, friends. And that said, today's discussion is going to be on what legal protections do international students have at US borders. Yes, students are really facing a lot of situations right now, I would say, with their CVIS, and also some of their visas are being revoked. We'll discuss all of that. And, to join us in this discussion today, it's my honor and a pleasure to, welcome one of Canada's top immigration minds, none other than David L.P. Garson, with over 30 years of experience. David is the managing partner at Garson Immigration Law and is certified as a specialist in immigration law by the Law Society of Ontario. So, yes, recognized by the international who's who of corporate immigration lawyers as one of the top 10 most highly regarded immigration attorneys in Canada. David brings unmatched insight into cross border business immigration as well. And he has advised everyone of multinational tech giants to senior executives and is a past chair of both the Canadian and American Immigration Lawyers Association. So, really very honored to have you with us today. Welcome, David, once again. How are you doing today?
I'm good. Thank you so much for having me. It's a pleasure to be here.
Always a pleasure. I mean, we met last year. So much has happened since we last met in
I would
November.
say so. I think that's an understatement. Yeah.
So true. Every day we are waking up to new updates, new rules, and things to keep in mind. So, David is going to help us, with most of our questions today. I have some, and I'm hoping that viewers out there watching us are also going to drop their questions, since we are lucky to have David with us now for an hour. So, David, what would you like to tell folks out there? What can they expect in today's discussion?
Well, I think obviously there's been a lot of media with regard to everything that's been going on. It has become far more, um, I guess, prevalent in the sense of you see stories all the time of people that are going to the port of entry. They're having issues at the port of entry. Um, a lot of it is certainly true, and a lot of it is, I think, generated a bit of anxiety and nervousness. So I think what we want to discuss or go through is, okay, so what's true and what isn't true, what's happening and what's not happening. Certainly there's headlines every single day, as to what immigrants and non-immigrants are facing, not only at the port of entry but when they're inside the United States, and things of the sort. So I think that we have to look at this kind of carefully, and we have to understand that while things have changed, certainly it isn't the same as it was a few months ago under the previous administration. I don't think anybody would acknowledge that that's the case. But at the same time, is it quite so severe as we are seeing now? So I think that's what we have to talk about, and we have to take a look at.
Today. And friends, stay with us. We are going to, discuss all of this. In fact, with all these news, with the 300 students and having their CVIS terminated, it's crazy, having a normal day and getting sort of shock like this news. So I'm sure it's going to be interesting what we have. And, to help us out with our questions, I have this first question to you, David. If you could tell us, what basic rights do international students have, when especially they arrive at the US airport or the border?
Unfortunately, a student is a non-immigrant going to the United States. So any non-immigrant who's trying to enter the United States and is not a green card holder or a citizen doesn't have a lot of rights. You can't really avail yourself of the Constitution and say, here I am protected under this section or that section. So if you're a non-immigrant, a student or a worker or anyone, a visitor, and you're at a U.S. port of entry, an airport or a land port, then your rights aren't very fulsome. So an officer at a port of entry can question you and discuss why you're there, what you're doing, what your paperwork is in all of that situation. And people say, well, do I have to answer? Well, yes, you do, if you want to try to gain entry to the United States. If you don't answer and you say, I refuse to answer that, or I'm not going to do this, then of course you are subject to removal and not being let into the United States. So, long-winded answer to your question, what rights does a student have? Not a lot. I mean, you in a polite way can request to clarification. If you think that things are going badly, you can ask for forbearance or patience. You can try to speak to the officer and determine why things are going this way, or what can be done to rectify that situation. But in terms of availing yourself of, a law or the Constitution, unfortunately, not a lot.
Okay, so I think there's not much, but it's always best to stay informed. I think knowledge is power in this case, especially when you talk about immigration. It's always good to stay updated because things are changing and we have to adapt every day.
And
So,
I think it's important to self-assess too before you go to a port of entry, right? You have to self-assess your risk. You have to take a look at, okay, well, this is what I've been involved in, or this is what I've been saying, or this is me on social media. And so before you go to a port of entry, you have to take a look at that and say, well, am I putting myself in a position where if somebody looks at my social media or looks at my tweets or, in where I've been, am I going to have a problem? I think this is such a shock to the system because this has not happened before in this type of numbers per se. I mean, there's always been people who've come to ports of entry and been refused entry to the United States. I mean, happens daily, hourly, wherever it is. But I don't know that this has happened to such an extent, or certainly the media hasn't publicized this as happening to such an extent. So it is a very popular topic. And that being the case, when somebody goes to a port of entry, especially now, and they know that they've been doing things or saying things or being involved in things that the US would consider to be anti-nationalistic or anti-US, then you have to take a step back and assess, okay, so what could happen to me at the port, and is this a good idea for me to travel at this time?
Yes, I mean, I hear so many immigration attorneys saying it's best to not travel right now. If you're in the US, stay in the US and stuff like that.
Well, that's an interesting point. We know that there have been many students who got emails from the Department of State recently who basically who asked them to self-deport based on previous activities or minor criminality or things of the sort. So being in the US doesn't necessarily help you either. If depends what you've been up to. But to your point, if you don't need to travel, then outside of the US, then probably not the best plan to travel in that regard. That being said, if you're a student who's going to school and you're in the US to study and you haven't been doing anything that would be considered untoward, then you shouldn't come, and your F1 is still valid, and nobody has sent you an email to self-deport, then you should be fine. I mean, you really should. I mean, I suppose any officer at any port of entry can give you a hard time, as they could, but I don't know that they would. I mean, we still have to consider that there's probably 1 million people or so traveling to the United States on a weekly basis, and the CBP doesn't have time to be obstreperous or stop people from going in, for frankly speaking, for the sake of it. So I think you do have to, as I say, look at this in that if you don't have to travel, maybe not a great idea to travel. But if there is something you need to go to, then I think that as long as, going back to our self-assessment again, as long as you are satisfied that, you know what, I'm here to study, I'm in my whatever STEM field or medical field or whatever you're doing, and I'm too busy to get involved in anything that I shouldn't, then I don't know that travel would be a problem.
Yes, yes, very true. Very well put, I would say, David. Thank you so much. So, and also, about social media, like we were speaking, many are advised to also deactivate or even delete their accounts. So, that's it. Because, nowadays, social media has become everybody's part of life. They wake up to that, they put an update with everything. So, I think nobody thought that it would, come back at them so soon like this.
I think you also have to be careful too in your social media on a certain way. If you wipe everything, I know there are people saying, okay, well, bring a burner phone to the port of entry,
Yeah.
or wipe all your phone, the social media in your phone, or wipe your phone. I think that's going to raise a lot of questions if you do something like
Yes,
that.
it's going to
If you
raise suspicion.
Exactly, if you go to a port and they look at a phone, there's nothing on it. All of a sudden, the officer's going to go, wait a minute, what are you hiding? Right? Like what's going on here? That's odd. I mean, look, I'm an old man. If you look at my phone, I have a bunch of stuff on my phone. It's not it would bore you to death, but there's a bunch of
Yeah.
stuff on the phone. But if I show up at this point with a phone that has nothing on it,
What
they're going to
happened?
think
Yeah.
bad thoughts. Exactly. Yeah.
True, very true. Yes, that's it. Folks out there, thank you so much for joining us. I do hope that you're enjoying this content and are able to, resonate. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also, yes, like, share, and subscribe to our content. Hit that bell icon so that whenever we have, discussions like these, you're also notified and can join us by participating. Also, you can ask your questions, you can even contact attorney David Garson here. So also you can join us on call. You can call in this number, where you can call in is 425-436-6335, and the access code is 988-888. Okay, so David, I have more questions, and if you could
Sure.
also help me with a few answers, as in, like, even if with a valid F1 visa, can a
Mhm.
student still be turned away at the airport? And if so, why would that happen?
So, yes, the port of entry has ultimate responsibility for entry to the United States. So anybody can be turned away. So, for instance, people can get as a I'm a Canadian, and as a Canadian, for example, I don't need a visa from a consulate. So I could go to a border. I could say I'm applying for an F1. I have my I-20. I'm going. Can you give me the status? And they can say yes, or they can say no. I can go to a consulate if I'm not a Canadian and I need to get a visa, and I go to the consulate, and the consulate issues the visa, and then I travel to the port of entry. But ultimately, it is the port of entry that has final decision-making power. Okay, so the U.S. immigration is run by several different departments of government. The consulates are run by the State Department. The port of entry is run by the Department of Homeland Security. If you file at a service center, it's USCIS. I mean, it's still under the Department of Homeland Security, but there's the Department of Labor. I mean, there's different organizations that have different purviews. So if you go to a port and you say, okay, I have a visa, whether it be an F1 or an H1 or any other kind of visa, and the port can say, sure, more often than not, they're going to let you in, right? You just got the visa from the consulate. Everything seems to be fine. Consulate was satisfied. You're attending the school you said you're attending, satisfied that your documents are in order. But when you get to a port of entry, that officer can ask a lot of questions. They can ask questions about where you've been. They can ask questions about what you do. They can ask questions about what are you studying, what clubs do you belong to, what are you interested in. They could ask to see your phone. They could ask to look through your computer. So they can ask all of these questions, and during that time, they may come up with something that they find is either, in their view, makes you inadmissible, or a possible problem, or expressing anti-U.S. sentiment. And if they see this, then yes, they can stop you. They can put you, if they want, into detention, or they can turn you around where you would have to leave. So ultimately, yes. Again, long-winded answer to your question, but the port of entry can absolutely stop you from entering, and they can cancel your visa at the port as well if they want to.
Yes. I think what we need to do is raise no suspicion at all. You have to give them the idea that, what you're telling them you're going to be in the US for, you have to come here to just do that. Nothing else. I mean, even you may be
That's
passionate about
exactly.
something else. Yeah.
I mean, that's the debate, right? We can sit here and discuss this, but the absolute debate on this is, you're a student. You've had to go to great lengths to get that student visa. It's not easy to get a student visa to the United States, right? I mean, you have to prove temporary intent. You have to prove you have the funds available. You have to have been accepted at an institution that is notable and is able to issue an I-20. It's expensive to travel to the U.S. It's expensive to live in the U.S. I mean, there's a lot of stuff that goes into getting a student visa. And a lot of people want to get student visas to go to the United States because they think that will help them in their life and their career. And certainly there's no shortage of people who are applying. So as you're saying, I think you owe it to yourself to make sure that if you're going, that you're going for the reasons that the U.S. intends you to go for. The debate is free speech, right? The debate is that are you able to say what you want and do what you want? You're a person. You're entitled to have the ability to speak out on causes that are near to your heart. But you have to temper that, and I'm going to be practical here. Okay, this is a sort of a practical look at it. You have to temper that to the knowledge that you are not a U.S. citizen or green card holder, and therefore you have gotten permission to go to the United States and to go to school. So with that permission, the U.S. would argue you have responsibility. And the responsibility is to abide by their terms and conditions, meaning you want to come in here and study, great, we're happy to have you. That being said, you have to play nicely with how we want you to play. And I appreciate that there are many people who find that wrong or annoying or stifling. But it's not a case where you're on equal footing here. It's a case where, again, you're asking permission to do something. And whenever you ask permission from someone to do something, you know what? You have to abide by
Yes.
the rules.
Exactly. You have to prove that you are worth it. I mean, why you ask that permission for that you're allowed. So why do anything otherwise, right? So I
Hmm.
think we have to respect both I mean, we have to respect their decision that they have allowed you to come in to study. So just do that. And David, I would also like to know, there in Canada as well, are you facing anything in the borders, anything with regard to students you want to tell us?
You know, it's interesting. I think that there are many people. It's an interesting time. I've never seen a time like this. I'm dual licensed. I'm licensed in Canada and the United States. So I see people coming to Canada and I see people going to the US. And
Yes.
it's an interesting dichotomy. It's an interesting comparison because the people going to the US are going, and a lot of Canadians want to go to the US. I mean, since the election in our office, our inquiries to go to the US has tripled, because a lot of people are attracted to the sense of maybe capitalism and ability to get further ahead in the United States. And at the same time, you have people in the United States who are unsure about themselves there, and so they want to come to Canada. They feel that it may be easier for them in terms of the life they want to live. So we have seen people wanting to come to Canada to go to school, or people wanting to come to Canada to work or stay. Um, there was a case, I think, and I don't know much about it, and I'm going to even talk. It's kind of hearsay, but there was a lady at Columbia University, or was quote unquote self-deported to Canada, meaning she doesn't have status in Canada, but came to Canada to avoid having issues with ICE in the United States. So you do see incidences of people who will come to Canada to try to avoid what they think may be problems for them in the US. That being said, Canada is well aware of that. And with the issue of tariffs and some combustibility between the two nations right now, I think Canada's being careful not to roll out a welcome mat, in the sense that, first of all, we have our own issues with regard to our economy and our ability to house people and all that kind of thing. And our immigration system has been severely problemed. I don't think that's a word, but I'm going to use it, for a number of years. Has had severe problems. How about that? For a number of years. And so I think people would want to say they want to come to Canada, but I think in Canada, the public may not have an appetite to take many more people in that regard.
Okay, that's very interesting. Like you said, it's a very interesting time because there's just so much happening, right? I think
Yep.
it's not like any other boring day. It's not like a day is repeating again. Every day
Hmm.
is new with so many updates. So, yes, thank you, David. And well, let's go on with our questions. We got more. So, what actually happens during secondary inspection, and how should students handle that situation calmly and safely?
So in terms of secondary inspection, so what happens is that if you come to a port of entry and they have issues regarding you and your entry, they will send you to secondary inspection. Now, it depends where you're coming to a port of entry, but if it's a land port of entry, then they send you over to drive over to the side. If it's at an airport, there's a secondary inspection office. It's the office behind the booth. So when you come in and you see CBP officers standing at the counter, basically saying, okay, what are you here for? How long are you there? All that kind of thing. They'll send you over to secondary inspection. At secondary inspection, they'll ask you to sit down. As they look you up, they may go through your documentation. Now, at that point, they could start looking at you and your social media and things of the sort. In fact, they sometimes do. And if you're going in and you say, I'm whatever, Mary Smith, then they'll look for Mary Smith and see what you've said or what you've written or things about you. If they Google you or they go on LinkedIn or something of the sort. When they, I guess, investigate, what they'll do is they'll come to you and say, all right, well, Mary, what have you been doing here? Where do you go to school? What is your, again, they'll ask the questions that we talked about before. Do you belong to any organizations? I see you said this on this date. What do you think of that? I mean, they can ask anything they like. Can we see your phone, please? Now, it's my thought on that, by the way, that if they ask to look through your phone and you are amenable to them looking at your phone, then I would unlock it. I don't necessarily know I'd give my code away, but I'd certainly unlock it and then give it to them. All that being said, they can seize your electronic items if they want to. They have that authority. And they can also not let you in. They have that authority. If you don't acquiesce, or if you're not cooperative, then they can basically say, listen, we're not letting you in. Tough. It's too bad. They can do one of two, three things. They can expedite remove you, which is a very bad thing because it's a bar to the United States, or they could let you withdraw your application for entry, in which case you leave. In either event, obviously the bar is bad, but if they let you withdraw your application for entry, even though you're not barred, you're in the system, so it may make it difficult next time you want to go in.
There you go, friends. Try not to, create any sort of suspicion ever. And thank you, David, for taking this up as well. So, moving on, I have more questions. But before that, I would like to tell folks out there you can keep commenting, you can ask your questions, and we are going to address to them very, very soon. So, you can comment wherever you're watching. We are live right now on YouTube, LinkedIn, X, and also on Instagram. So do not forget to also subscribe to our channel. Our handle is at Immigration Talk Show. So that's it. Thank you, David, once again for joining us. In fact, you can also contact Attorney David Garson, and that you can do by, emailing him as well. Sometimes, you have your questions, you don't want to ask it here so publicly. You can leave him a message or email him at david@garsonil.com. Yes.
Yep.
So, David, another question I have for you is if students are required, to answer every single question that's asked by border officers, or are there limits to what they can be asked?
I mean, you would think so. I'm trying to answer this in a way. I don't know that an officer would ask a question that would be in a term inappropriate, or they shouldn't. And I think there's an ethical obligation that an officer has. And, it's a tough job to be a CBP officer. It is. I appreciate the fact that there's a lot of discussion on this. And Lord knows I see both sides. But it is a tough job. I don't know that an officer would ask a question that would be perceived to be, I'm putting this in quotes, inappropriate. I think that the questions they will ask will lend itself to, are you admissible to the United States? Are you a danger to people or to the U.S.? Have you done things that would make you inadmissible? Now, in terms of where the line is there, I guess everyone has their limits, or everyone has their ability to decide what they want to answer and what they don't. I was talking to someone who was telling me that they have a visa to get to the United States. And when they came into the US, the officer was asking lots of questions, and they answered the questions. And the officer basically was saying, well, why can't an American do what you're doing? This was not a student visa. And the person said, well, I don't know. I got a visa so I could do this. And I suppose it would be up to whoever made the decision to give me the visa to answer that question, which was a good answer, I think. But I think the way they said it, too, was a very, in a very practical, forthright way. I think it goes without saying, but an officer will also give back what they get. So if you're going in there and you create an attitude, then you're going to get a lot of attitude back. If you are polite, then they may not be polite back. I can't say they would be, but they're more likely to be polite in that regard. So when you say answer every single question, you can, if a question you don't think is appropriate, you can ask in a appropriate way. Well, I'm sorry, I don't understand. I'm trying to come in as a student. How does that relate? You know what I mean? In the sense of creating a situation that you can address the question and query it, meaning you could ask for clarification. You can be as careful as you can. That being said, again, there aren't a lot, you don't have a lot of wiggle room or rights in this regard at a port of entry. You just don't. And there's no magic bullet here that I can say, but you quote this section of the law or this case and they have to back up. That's just not the case.
There you go. Yes, I think sometimes we may not have the answers, and we don't understand. And is there anything like right to remain silent or anything as such, David?
I mean, you can certainly do that. They can't force you to answer questions, but again, that will go towards you being able to get in. You know what I mean? You're talking about, you take the Fifth, which is a part of the U.S. Constitution under the Fifth Amendment, but at the same time, you as a non-immigrant, again, you really don't have constitutional rights in the United States.
Okay, right, and especially at the entrance, I guess, in the airport or
Oh
anything as
yeah,
such.
yeah.
Right. Thank you, David, for taking that up. And we have Drive 10. Hi, Drive. Thank you so much for joining us on YouTube. So let's take up his question. I am an international student and I'm planning to travel to India for a short trip,
hmm
but I've been hearing about students being stopped or even sent back at the airport when they return to the US. What kind of legal protections do I actually have at the border if something like that happens to me?
You have to be able to, as I said, you self-assess and you try to be as fulsome as possible with the documentation that you have and the information that you have. So, for instance, if you're coming to the port of entry and you've gone to India, you're coming back, and you have all your documentation in order, I would probably have further documentation. In other words, when you got the student visa, you had to show evidence of your ties to India, right? You showed evidence that you had family there. You had showed evidence that you had financial ability to pay and the financial ability to support yourself. So I would actually have with you, you don't necessarily have to present it unless they ask for it. I would have copies of the information that you first submitted at the consulate to get the student visa, just to show that, yeah, no, everything is the same and I have this. Also, if you're attending school and you're going home, where are we here? I guess we're coming to the end of the year. So if you have your next semester and you are registered in courses, I would have proof of that. I would have copies if you've gotten your marks from your previous semester. I would have proof of that, showing that you've attended school and that you've completed the courses you were supposed to complete. And if you are staying, if you're staying in an apartment or a house and you have a lease, I'd have a copy of that. So I guess my point is that it's sort of a package of documentation that you may want to bring with you just in case, because if they're going to deny people entry at the airport, they're going to tell them why, right? They're going to say you did this or you were there or the like, or we don't believe you're attending school or we don't believe you're going back to school. But if you show at least as much as you can that this is what you're doing, you are here to go to school, you have gone to school and you're going to go to school and you can support yourself, you have somewhere to live temporarily, then that could address a lot of the questions.
Right, right. Thank you so much, Drive 10, for joining us with your question. And thank you, David, for addressing this. So, coming back to our questions, if you could also talk about the important documents these international students should always carry, especially when entering the US to avoid any sort of problems.
Yeah, I mean, I think in terms of when you say always carry, you should always carry the documentation that you are a student, meaning you have the electronic. You should download a copy of the I-94 card. If they didn't give you the paper copy, you should have a copy of the I-20. You should have, as I said, if you're going to the school, you should absolutely have information that you're attending. If you're leaving the US, everything I just talked about, you should have with you, just because. Okay, if you come back just without any kind of real proof of anything else, then I think that you could invite more questions. They could say, well, how do I know you're going to school? Well, here, I have this. So you have somewhere, how do I know you can support yourself? Well, here. And shows you have ties at home. What were you doing? And be prepared to answer questions. I mean, I think that's the case. I mean, if somebody asks you a question, be prepared to answer the question. What are they going to ask you? What are they concerned about? This goes back to our self-assessment. They're concerned that you are coming to the United States to do what you said you're going to do. You're going to go to school. Show proof you're going to go to school. Show proof you've been in school. What if you belong to clubs? My advice, join clubs like the chess club. Okay? Join the yearbook. Don't join organizations that would be considered to be problematic organizations. And I think that if you're quite plainly, if you're smart enough to get a study permit, a student visa to go to school in the US, you can figure that out. You should know that, there are organizations that may not help you with regard to your US activities or your US student visa. And yes, I appreciate the fact that if you were a U.S. citizen or you were a green card holder, you could do certain things. Sure, but you're not. So keep that in mind.
Yes, absolutely. Thank you, David, for making that clear. And when you talk about studying in the US, I mean, whether it's just academia or so many co curricular activities that you need your grades on, it's going to really keep you so busy. I don't know how do people make time for any other things. Well, um, anyway, we got Kritika also who joined us. Hi, Kritika. Thank you for joining us on YouTube. So let's take up her comment. I'm here. I came here on a B1 visa that was valid for 6 months, and I ended up staying 8 months due to a medical emergency. I didn't
Mhm.
file any extension. Am I already in trouble? And is this $998 per day something I could actually be charged now? I think
I'm
this is
not
a
sure
new.
about the $998 per day, but in terms of in trouble, you overstayed. Unfortunately, you did overstay your visa. Yes. I would leave immediately, to be quite honest with you. I would not stay longer. Being out of status in the United States is never a good plan, especially now.
Yes.
So this isn't something you should play with. In that regard. And I'm sorry, I don't know what the $998 per day is.
Yes, actually. And Kritika, I understand it was a medical emergency, but I mean, it's crossed over 2 months. I really hope that you were not in a situation where you couldn't have informed. So if you were, it's going to maybe backfire at you again. So, but I hope that you're fine now, Kritika. Thank you so much for joining us with your question and all the best. Let's go on to our next question. And if you can tell us, can border officers go through a student's phone or laptop? We've already discussed this. If that happens, what can the student do? I mean, unlocking the phone and giving it to the officer. But yes, tell us more.
Yeah, just to go back on Critica's, uh, I lost you here for a minute. I'm sorry, I'm trying to find you. Do you see
No
me?
problem.
Or,
Yes, we can.
oh, okay. Going back to yeah, all right. Going back to Critica's question too. The longer you stay, the worse it is. And if you get to that 180 days, it's a 3-year ban. So, you know, leave. That's the best advice I can give there. Now, sorry, in terms of what can they go through your phone? Absolutely, they can go through your phone. Yes, they can go through it. I mean, if you go to a port of entry and they say, I want to go through your phone or go through your computer, yes, they can do that. They can look through it. Now, you can, if you don't give them the access code and you refuse to open it, then they have 2 or 3 options. The first is they can say, fine, they can stop you from going into the United States and turn you around. The second is they can let you in, but seize your phone and give you a receipt for the phone so that they can go through it. Or 3, they can let you in. Now, I don't know that the third option is going to be very likely, but they can absolutely do that.
Okay. Thank you, David, for taking that up as well. And now, if you can also tell us if a student is told that their visa is being cancelled at the airport, do
Mhm.
they have any right to ask for help or talk to someone before they are sent back?
They can ask for clarification, or they could ask to call an emergency contact or something of the sort. They don't have a right per se. They can ask to speak to a friend, or they can ask to speak to a lawyer. But I don't know that they'd be given the right to do that. If they're going to be canceled at the airport, they would have to be told why. I mean, they're going to be canceled They normally would be told. There'd probably be an affidavit that they would have to sign. They'd be asked questions. It's there'd be an interview with regard to what's going on, what they said, and then the officer would say, I am not letting you in, or I am canceling your visa under this section of the act. So if that occurs, then, they can ask for further clarification or to let someone know, or for any kind of, I guess, kindness the officer wants to show. But there's no right to any kind of, appeal to a court or to a tribunal right there. No.
Okay, so that was just leading me to the next question, but probably it's going to be invalid, because if someone is denied entry, and can they really challenge the decision, or is it like the final right there at the airport?
Well, it's pretty final at the airport. Let's put it that way. I mean, if you're at the airport, there's administrative appeals when you're within the United States. I don't claim to be an expert on when you're in the sense that and what appeals you have through courts and administrative bodies when you're in the United States. But at the airport, there's not a lot that can be done for you. If they're going to refuse you, they refuse you and they send you back.
There you go. Okay. Thank you so much, David. I know these answers are not very hopeful, but it's better to know
but
now.
we are delving into the worst case scenarios here too.
Yeah.
And I appreciate why we're doing it. And that's absolutely fine. It's just that I think we do have to note that this is what happens if you're in that position. Okay. If you're in the position at the port where things are going south, then I think you have to be in a position or as I say, try to have the presence around you to figure out, okay, what can I do or say to this officer that would make a difference for me? Meaning, even in a common sense, practical way, what can be done that helps me in this situation? Because if I try to be overly hostile, it's wrong. If I try to get overly nervous and so I can't speak and it becomes sort of, I get hysterical, that's wrong. That's not going to help you. I think the best thing you can do is to try to keep your wits about you and me, if I'm there, and understand what is going wrong and what I can do to try to remedy it. Mm-hmm. It always helps. I keep going back to this, and I'm sorry, and I know I'm being repetitive, but it always helps to sort of be on the side of the angels, meaning be on the side where, okay, look, I haven't done anything wrong. I haven't said or belonged to organization. I haven't said anything that's going to be construed to be problematic, and I don't belong to organizations that the U.S. is concerned about. So why am I having a problem? Okay, because if you start in that premise where you are involved or saying things or doing stuff, then right away you're starting on the wrong foot, right on your back foot, and that could be an issue.
Okay. So I think you really, really need to consult with an attorney, because right now, you may think that it's going to be okay to speak of few things, but I think it's best to know what to speak, what not to address, and how to stay compliant and safe. It's most important to play safe at this moment. So thank you so much, David. And yes, folks, you can also contact Attorney David, and that you can do by emailing him. And his email address is david@garsonil.com. And go visit www.garsonil.com. So, David, we do have more folks who have joined us with their questions. So let's take up. This is Sonia. Sonia is asking, I'm still in the US on an H-1B, but my I-94 expired 20 days ago while my employer is working on an extension. Can I still fix this without leaving the country, or does this situation now count as an overstay?
I mean, after your H-1 expires, normally you can remain in the US for a maximum of 60 days or until the authorized validity period. But if it's expired, I mean, realistically speaking, there's not much you're going to do. I mean, in the sense of staying there that I can think of. I mean, I guess the question is that why you didn't make an application to change status while you were still in H-1 status, even to B status as a visitor, in that regard. I think that, and then try to change status back. In other words, there's opportunity to submit documentation when you're in a certain status in the United States to help you. If you're outside, if you've expired then chances are you're going to have to leave and go get a visa from a consulate. So your employer would have to get an approval, but then that goes into the cap too. If it's not an extension, then you may be subject to the H-1 cap, and then you may have to leave. If you get it, you then can go and get a new H-1 visa, but the extension itself may not be possible.
Okay. All the best, Sonia, and I hope you figure out. And I think it's best to be safe, stay safe. And let's go on to our next question from Sony. Thank you, Sony, for joining us. Sony was there on our previous show as well. Thank you. Good to see you back again with another question. So, saying, my parents are coming to US and B1 visa for a visit. How long can they stay here without issue, and what documents do they need with them while traveling? Do they need to carry passport all the time while traveling?
So, I mean, as you probably know, if they're coming to the United States on a B1 visa, once they come to the port of entry, they're granted, normally it's 6 months. Normally they get 6 months, meaning it goes into the system unless they do it differently. So you can, first of all, go on the USCIS website under My I-94 and check the status time you were given. So if you come to the port of entry and they let you in, then you can go on the USCIS website and check, okay, I was given status until whatever day I'm given status to. So then you'll know what the length of time is. The second thing is, as you probably heard, if you're going to stay longer than 30 days, then you have to register. Actually, no, if you're coming by airport and through, then you're given the I-94. So that should be fine. So there's no need for that. Secondly, when you come to the port of entry and they're asking, what are you doing? I would make sure they have their return ticket. So it shows when they're going back. If they're staying with you, they may want to have a letter from you saying they're going to be staying with me for this period of time. They're my parents. I'm in the US in this status. They're visiting me. If they're coming here, they should have, if you're, just have it with them. They don't have to present it unless they're asked to present it. But if they work, they should have proof that they're employed. If they live somewhere, proof that they have a house, in that sense. So if they're coming to the United States and they're going to the port and the port's saying, okay, well, why are you here? They're here to visit their child. And this is where they're staying. This is how long they're staying for. This is their return ticket. This is what they're going back to. Again, I think you want to bring copies of the documentation that you use to get the visa itself to begin with, and have it with you. You don't necessarily have to present it to them. If you can pick them up at the airport, maybe a good idea to show up at the airport and pick them up. But what they want to know when you come to a port of entry is that you're here for a temporary period. You can pay for yourself when you're here. You're not going to do anything. You're going to work without status or anything like that. And you have means to go home and a way to go home. So that's what they're going to look at.
Yes, and I think what has lately become very important is also your return ticket. So this is something that you might want to have it with you, even when you're entering the US. The proof that you're actually going to go back on that date. So
Yep.
yes, Sony, thank you for your question. Thank you for participating. And we have Rahul. Hi, Rahul. Thank you for joining us on YouTube. Saying, I have heard that American Civil Liberties Union offers resources and guidance on immigrants' rights and can provide assistance if you're facing issues related to your immigration status. How reliable is this?
Sure. No, you can, but you're not going to be able to avail of that when you're at a port of entry. I mean, when you're at a port of entry, it's not going to be very helpful. But if you're in the United States and you're facing issues with regard to your immigration status, you can absolutely avail yourself of the American Civil Liberties resources. You could also avail yourself of other immigration attorneys' resources, meaning if you're in the US. I have a unique type of practice in the sense that because I sit in Toronto, so we do a lot of border work. So I've been doing a lot of media myself with regard to the border and what happens at the border, because that's a lot of what I see. But let's say you're going to school in Oklahoma, or Texas or Florida, and you're running into problems there in those states, then yes, you can avail yourself of the resources of the American Civil Liberties Association, but also there's many fine lawyers in those areas that can probably help you as well. If there's something to be appealed, if there's some way to sort of attack the problem. I think that and it wouldn't be someone, I mean, obviously it's not me. It's people who are there on the ground, who you can see, who can give you a lay of the land. What I believe is that if, for instance, you are told to self-deport, or there's issues with regard to your status, then the first stop you should go to is somebody that knows what they're doing and what they're talking about. It's easy to go online, it's easy to go on Quora or Reddit or something and ask questions, but you don't know who's answering those questions. If you can afford it, then you should see someone who can assist you and give you reliable information.
Very true. And it's best to consult with an immigration attorney and have one personal one for yourself always, because they will know your case in and out. They know where you were born, what you're doing, what you need to do, what your status is, and everything. So, yes, and in fact, if you need an attorney, especially if you're in Canada or the US, or you keep shuffling in these two countries, then why not contact Attorney David? Also, Attorney David Carson is going to be available on email, and you can email him at david@garsonil.com and go visit www.garsonil.com to get to know more about immigration attorney David Carson. So, well, David, we do have some more people who have asked their questions on our YouTube channel, so I would like to address to them as well quickly,
Okay.
because I feel like they are a little related to our show right now. So this is like, I'm a business owner from Canada. Do you think I can self petition and apply for L1A?
So if you're a business owner in Canada and you have a company in Canada and then you want to establish a business in the United States, you can look at it it's called a startup L1, meaning you're starting up a business and you're transferring there. That being said, you can't be well, you can, but it'd be a very difficult L1 if you're the only employee, right? So in other words, if you can't, let's say I have a small business in Canada, I'm the only employer, myself and my spouse are the only employees, and I'm going to establish in the US and then do a startup L1 there. It's possible theoretically, but I would look at it, if you came to me, I would look at it and say, well, how strong is this case? Because I don't know it would be especially strong, because they want to know that both companies are still going to be operating, that the Canadian company can support the US company. In those types of situations, you need a business plan. So I guess in answer to your question, yes, it's possible. That being said, the conditions and the criteria have to be met, and it has to be somewhat clear and precise.
Thank you, David, for taking that up. And folks out there, don't forget to subscribe to our channel, especially if you're resonating with all our content and what information Attorney David is here to give out to. I mean, it's very, very interesting so far. Been discussing from a different point of view, I would say also. So yes, subscribe. Our handle is at Immigration Talk Show. And also check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Connect with us. Let's go on to our next one. This is from Status saying, ma'am, F1 visa refusal slots open or not?
I'm
That's
not
the
sure I
question.
understand the question.
Is F1 visa refusal slots open or not?
Sorry, what do you
The-
mean F1 visa refusal slots open or not? If
exactly.
you're
Okay.
refused an F1, if you're refused an F1, then it's, you can reapply. If that's what you're asking, if you can reapply for the F1, yes. But frankly, if there's not a lot of documentation that's different, it would be a pretty tough application. So I don't know how that would go.
Yes. But thank you, David, for taking that up. Now we have Paulo asking, when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies.
Mhm.
That was the agreement they signed. Is that true, David? What do you want to say on this?
Yeah, there's a temporary intent requirement. I'm not sure if they're referring to immigration to Canada or immigration to the United States, but there is a temporary intent requirement. And when you're making application for an F1 visa to the US, or a student visa, a study permit to Canada, you're absolutely saying that you will return to your home country. Where that became, if we're talking Canadian immigration, where that became, I guess you could say, almost hypocritical, is the fact that a lot of Canada's immigrants came from the student population. So while you had to say that and prove that, at the same time, you could still enter the express entry pool to apply for permanent residence and everything of the sort. So it was odd. You're saying I'm going to go home, but at the same time, I'm applying for permanent residence. And in the US, it's kind of similar, right? I mean, you have to prove temporary intent when you apply for the F1, and then you do the OPT. And if you are in the STEM field, you have a longer term OPT, but then your employer, is trying to get you an H1, and then from the H1, possibly labor cert and then perm. So while you, again, the dichotomy or the separation is interesting. You're proving temporary intent because that's what you have to do. And at the same time, a lot of the immigrant population is taken from students who have had to prove temporary intent.
Okay. Well, that's interesting. And thank you so much, Paulo, for your question, and also David for, taking that up. And we got this one from Shreya. Quick question. What would be the RFE for someone who's working on job duties? Isn't much related to their master's degree. Would that be a specialty occupation? And my company gives very detailed job duties, roles, responsibilities, qualifications, etc. The only issue is my master's degree in information systems, MS, with data SC courses and job in network engineering. However, I have STEM OPT Indian work experience for 2 years, BTech in CSC approved. So, and
I,
is specialty occupation is judging the role by company or the candidate who's applying? Seems like USCIS judges the role rather than the candidates.
Well, for this, I'm assuming you're talking an H1. If we're looking at that, then I think that, yeah, they look at both. When you're doing the H1, your degree should be in a closely related field in the sense that it makes sense that you could do this job and you've been trained to do this job, and it does go to the role as well, with regard to the duties and responsibilities of what is something that is clearly professional in a specialty occupation. So, I mean, in terms of what would the RFE, that's a request for evidence, be? In that regard, it depends upon what is written in the submission, but the degree should be in a field that is related to what you're doing, and the role itself should be in a field that's related to the degree or something that they're satisfied you can undertake.
Okay, okay. Thank you so much, David, for taking that up for Shreya. And Shreya, thank you once again for your question. And I think we have taken up our YouTube questions with that. So thank you, David. I still have more questions, so probably I'll quickly address to them since we are running short of time. So if you can tell us, can issues with a student's CVIS record,
Mhm.
like it was just fixed or was recently terminated, is it going to affect their chances of getting back into the US?
Oh, sure. I mean, yes. I mean, if your CVIS record is terminated, then you you need to get a new CVIS. If it's terminated by the school. There may be a reason for it being terminated by the schools, for whatever it is. But you should probably appeal that with the school, or see if you can get a new CVIS, meaning a new acceptance with another institution. And then if you can get that, then you may or may not have to apply for a new visa, depending upon the expiry of your current visa. But yes, if your CVIS has expired, then or has been terminated, you need a new CVIS, and you have to go back to the school to try to appeal that, or go to another school to try to get a new CVIS.
Okay. Thank you, David. Thank you for taking that up as well. And folks out there, I hope you're resonating. Do not forget to subscribe to our channel. It's at Immigration Talk Show. So, David, maybe I think what we could help out folks out there watching us, especially if they're students, what steps should students take before flying back into the US, to really make sure that they do not run into legal trouble at the border?
I mean, to wrap up, I think that we have to go back to where we started with, and that is we self-assess. We determine what we've done, what could be our issues, where the problems could be. From that self-assessment, we then try to address what we think our weaknesses in when we're coming back. The best advice is not to do anything that would get you in trouble. It sounds trite and obvious and maybe a bit ridiculous, but understand, the climate, what's going on, what is expected of you and what your responsibilities are. It's just that, okay? unless you want to be a martyr, unless you want to be an advocate in a certain situation that may not get you very far, then perhaps you have to consider what is expected and what you need to do. It's harsh. It's a harsh statement, and I appreciate that. And I appreciate the fact that, we talk about individual rights and we talk about our ability to speak freely and our ability to be who we are. All good. But, there's an old saying, do you want to die on this hill? I mean, that's it's, you don't want to be a person that ends up making a point, but having your visa canceled. So I guess the first thing is you self-assess. You do what you're supposed to do as best you can. Now, that isn't to say that you couldn't have issues even when you do what you're supposed to do. But I think the chances of you getting into trouble are a lot less. I think you have the documentation with you that you're supposed to have, including, as I said, a copy of the application that you applied for with your F1, so that you have it on you in case there are questions. And in the end, I mean, you try to keep your wits about you, answer questions truthfully, transparently, and address the questions that the officer asks. So it's their job to ask you questions, and they're good at it. Let them ask you the questions. Answer those questions. Don't answer questions that aren't asked when you're at the port.
Exactly. Everybody's doing their job. And I think if you're going to be here in the US, you should also just come here and do your job. So thank you so much, David, for this really amazing and informative session, for so patiently taking up each of our questions, answering to them, and it was really lovely having you back here with us. I mean, this was our first show this year, so it was wonderful having you once again.
Pleasure being here. Thank you for having me, and be well.
You too, David. Thank you once
You
again.
too.
Folks out there, you can contact attorney David Garson, and that you can do by emailing him. His email address is david@garsonil.com, and you can also go visit www.garsonil.com to get to know more about attorney David Garson and the law offices of Garson. So thank you so much, David. Once again, it was lovely having you. Such an honor and a pleasure, and I'm looking forward to having you back again soon.
Thank you so much. It's great to be here.
Thank you, folks. Thank you for joining us. Do
Bye-bye.
not forget to subscribe. Bye bye, David. And our handle is at Immigration Talk Show. Subscribe to our channel, hit that bell icon so that whenever we have these webinars, you're notified and you can join in by asking your questions or sharing our content, because there's so much people can benefit from all these amazing webinars we have, because they're very informative and they're free. So subscribe. I would say it's free of cost, and just let's support each other, I would say. So check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram as well. On X, we are at IMI Talk Show. That's our handle. But everywhere else, we are at Immigration Talk Show. So check us out. Also, friends, you can message me or call me on my number. My number is 408-335-6444. This is also my WhatsApp number. So in case you have any questions which we can address to our attorneys and guests who join us, feel free to leave your questions on messages. I will definitely check each one of them and, yes, address to them. Also, you can email me at nipa@staffingly.com. And once again, stay with us, because we have another very interesting session lined up just after less than an hour at 4 p.m. Eastern Time. I and my co host Sam are going to be back again with Daily Immigration Dose, where we're going to have another very interesting session, I would say. So stay with us. And until then, of course, keep enjoying your day and check our space out at Immigration Talk Show. Bye for now. Hello and welcome everyone to Immigration Talk Show. I'm your host Napasa, and I have a very interesting webinar lined up for you. So stay with us before we have our guest for today join us. I have this very important disclaimer to read out. So, folks out there, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, X, and also on Instagram. So, check us out, connect with us, and don't forget to subscribe to our channel at Immigration Talk Show. Hit the bell icon so that whenever we have discussions, you can also join us and ask your questions. Better even, this could be like an opportunity for you because we have these amazing immigration attorneys join us where you can get immediate answers to your questions. Yes, friends, and that's it. Today we are going to discuss about 100 days in, how the Trump's campaign return is already shaping US immigration. So we are going to speak at length about this today and touch up on many things. Of course, we know every day that there have been a lot of changes and a lot of things that are affecting and shaping the US immigration. So stay with us, friends, and let's explore this today. So today's guest is a very, very amazing managing attorney, Ingrid Boris Perez. And she's an accomplished immigration attorney with a passion for helping immigrants on her legal journey. Yes, friends, because she was also born and raised in Brazil, Ingrid personally experienced the immigration process when she moved to the United States herself at 9 years old. And this first-hand understanding really fuels her commitment to providing empathetic and effective legal representation. So, without further ado, please help me welcome her once again to our show. Hi, Ingrid. How are you doing today?
Hi, Napalsa. Nice to see you. I'm doing well. Thank you so much for having me.
Thank you so much for joining us. Good to see you. And yes, your new office seems all set now.
Yes, it is.
All right, lovely. So, very interesting topic we've chose to discuss today. What would you like to tell folks out there to expect from today's discussion?
I think people should expect, a lot of information. It is a lot of moving pieces, a lot of moving parts all the time. There is always something new in the world of immigration these days. Sometimes it's hard to keep up. So, I think that it's important for people to understand that, it may seem by design. There are a lot of changes, and that is where the country is going, and we have to learn to adapt to it.
Absolutely, we have to. There's no other option, friends. We need to learn the changes, keep ourselves updated because we cannot give an excuse that we didn't know about it. We just have to know everything about it, especially that we are immigrants and all the rules and laws apply to us. So that said, friends, you can also join us in this conversation by commenting wherever you're watching or dial this number to join us on call. And the number is 425-436-6335, and the access code when they ask for it is 988-888. Join us. So, Ingrid, with that, I have my first question. Now that President Trump is back in office, and we have already seen his first 100 days when it comes to immigration priorities. So, would you like to highlight some of the most important ones that we saw in the last 100 days? Hey, Ingrid,
Goal is the
sorry, we lost you a little bit. Could you just go
Yes,
for
can
it?
you hear me?
Yes, yes, we can.
Okay. So I think what stands out in most people's minds is, and the things that people are seeing every day is the level of enforcement, immigration enforcement that we're seeing. Of course, we were anticipating enforcement at the border, sending the National Guard to the border, promising to rebuild the wall, and using the military to enforce entries or prevent entries at the southern US Mexico border. Those things were expected, and I believe a lot of those things are happening. Border crossings have come down significantly. So those things have started to take effect. The other piece of this that is most in our faces, I think, is the internal enforcement that we are seeing. Obviously, there's a lot of videos and a lot of news out there about people getting um, stopped by ICE, arrested, and placed in deportation proceedings, or being removed outside of the United States. We see a lot of that as well. And also enforcement for people who are here in United States with status. So we see people who have student visas or even permanent residents who are being detained and placed into removal proceedings as part of the internal enforcement, internal immigration enforcement. So we see a lot of that as well. I think, though, that it's important to keep in mind that the numbers are also something that people should be, aware of, because according to, I think, some reports by ICE, the data that is reported by ICE, the number of deportations in and of themselves have not increased. The numbers have stayed relatively steady. It's just that the targets and the people who, are being enforced, immigration is being enforced, is changing. I think it's just more in our faces, these stories that we see every day. So there's a lot of that going on. I think another thing that, has changed significantly is the humanitarian protections for immigrants, right? So limiting asylum access, terminating TPS and other humanitarian routes. These things are things that are being litigated in court. So there's a lot of changes in that area, but that is something that the Trump administration vowed to do, and something that they, pursued for sure. And of course, I think the one sort of change, or one sort of priority that stood out the most and happened earlier in the administration was the attempt to end birthright citizenship. I think that is a significant step in enforcing and changing immigration policy. Of course, that is not in effect right now. The Supreme Court will hear this case in May. So we're waiting to see what happens with that.
Absolutely, yes. Thank you so much. I mean, yes, you brought us those great and important highlights. Throwing back to Trump's 100 days already. I know how time flies, and it feels like he's been here for quite some time now, because we've seen so much happening, and every day is an interesting day with new updates, new things in how we're catching up, and how's it going with you and your law firm, by the way, IBP law firm.
I think for us, we're trying to stay in our lane, in the sense that we are sticking to what we know. Of course, there's a lot of interest in immigration services, and different ways to navigate different issues. We are sticking to what we know best: employment-based immigration, family immigration. Of course, we have to stay updated on all the changes to make sure that our clients are getting the best representation. And it's what we always have done. It's how we operate. And I think, this time around here in the office, in the first few months, it was very stressful, very difficult dealing with all the changes. But, like anything else, we get used to it. We're resilient. We care about the clients, and we're going to do everything we can to, take care of them, and make sure that things work out for them.
Absolutely, yes. Always. And we'll sure hear one of your stories very soon. But before that, also, Ingrid, if you can tell us, have there been any executive actions or policy changes so far that, are directly affecting visa holders?
Yeah. So in the beginning of the Trump administration, I mean, I know we're only, we're barely 100 days in. It's still the beginning. But I think in the very few days, there were many executive actions or executive orders that Trump signed, asking the various agencies, the various departments within the Department of Homeland Security and within the government, to review policies and make recommendations. So those things, I believe a lot of that is still going on, and we're waiting to see what a lot of those recommendations are going to be. There is, a policy of America first. And I do anticipate that visas like TN or H-1Bs and Es, we're going to see some different policies and different recommendations as well in regards to those visas. To I think the Trump administration goal is to protect U.S. jobs, American jobs, and revisiting policies around those specific visas to see which recommendations that the administration would choose to adopt. We also have, TN specifically will be looked at, I believe, next year. The agreement between the United States, Canada, and Mexico is set to expire, and there will be renegotiations around that as well. So I expect some changes in the TN visa category as well.
Sure. I mean, I think all we can expect are more changes every day. That is what is happening. And I think by now, the people of America, the immigrants, and everybody in America are ready. They are ready for all the changes that are being thrown at them. So let's get on it, and more changes on TN as well as expected, so we'll look for it. Friends, if you are here, don't forget to subscribe to our channel for more updates and the latest updates on US immigration. Our handle is at Immigration Talk Show. Check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. And also now, hi to Sakshi, by the way. Hi, Sakshi. Thank you so much for joining us here on YouTube. We will take up your question very soon on the show. Just stay with us. So, Ingrid, I was saying, we really wanted to know what kind of cases are you seeing most frequently in your practice lately? And what challenges are people facing in those situations?
Well, happy to say that, we've seen a lot of H-1Bs, a lot of EB-2IWs, a lot of O-1s for individuals who maybe were not selected in the lottery for the H-1B. I'm seeing definitely an increase in interest in e-visas, which is great. I think that there's an interest still in people who want to come and invest in the United States and who want to live the American dream. We focus mostly on employment-based immigration. So those are the kinds of cases that we're seeing. And I'm glad that, people still want to come here, employers still want to hire, and it's great.
It is. All right. Perfect. Then thank you so much for sharing that with us as well. Any specific case you want to share that's coming to your mind, or something that's different?
Yeah, absolutely. So I'll share actually a good story. About a couple of weeks ago, we had a family of 5 in my office, and they got their green cards through the EB-2 and IW category after waiting for, I think, like almost 2.5 years. So it was a really great moment. It was a family of 5, a couple and their 3 kids who have a business in the United States, and they were able to really build that business and create lots of jobs, and the business was a great addition to the economy. And finally, their green cards arrived. They did not get an interview because really these clients did everything perfectly. And also, I think they were very lucky. Things worked out for them. And they got their green cards, and it was so wonderful to see that happen. And it felt really great. And then just yesterday, we got another family-based green card approved. This was a marriage-based green card application, and it was approved without an interview. So that was surprising because we were expecting practically all cases to be called for interviews, all clients to be called for interviews. And I definitely see more interviews, happening. But it was a nice surprise to see that these 2 specific cases were approved without interviews. So that was really nice, and I'm sure that the clients are all relieved.
That is so wonderful. I mean, yes, like you said, we are expecting more interviews. We were expecting these RFEs, but lucky for these 2 families that, they could make it so easily, really. So I think this is a shout out to all friends out there that, that you can also get lucky. Don't think too much. If your documents are on the right path, on the right place, all updated, there's nothing really to worry about. So I think best is always to consult with an immigration attorney for your case so that you're guided on the right path and see how easily you can come through it. Yeah, and why not contact attorney Ingrid Perez herself, you can call her on her number 407-906-0068, or go email her at info@ibplaw.com, and definitely go visit www.ibplaw.com. So that is, those were really amazing stories. Thank you for sharing, Ingrid. And yes, surprising, because at least, with all the news, we were not expecting that,
Yeah,
but lovely, really lovely to hear. So,
I think you have to share the good news too, right? All the approvals, all the conquerors, and all of that. I think it's important to share those as
very
well.
important, yes, because it gives out hope and a positive side. People sort of, they feel very anxious right now, and when you say stories like these, makes them hopeful.
Yeah.
Yeah, and well, now if you can tell us, have there been any updates or trends in how NIW petitions are being reviewed?
This is my favorite topic. I love talking about NIWs.
Go ahead.
so, I think the last time we talked about NIWs exclusively, and we were talking about the different, the new policy guidance that came out January of this year. And and in talking with other attorneys and seeing trends and doing our own analysis of trends internally, we definitely see that immigration has shifted, right? Some people may say that it is, they're moving the goalposts, right? And I do agree with that sentiment quite a bit when it comes to EB2 and IWs. So now we are learning to adapt and anticipate these goalposts being shifted. I think that over the last month or so since I've talked to you, there's a lot of people who contacted my office with RFEs, requests for evidence, on I-140s for EB2 and IW that they either filed on their own or with another law firm, and they were looking for help to respond. And I've been collecting these RFEs for quite a while now, just so that I can have my own database and look at these. And I see that immigration is, definitely looking for broader impact in a person's endeavor. But what does that mean, right? Broader impact, really, I think in the eyes of immigration today for the EB2 and IW is how strategically, how will your endeavor benefit an important strategic interest of the United States? How is it going to help make America number one on the global stage? How is it going to help an industry in the United States be number one on the global stage, right? So, and I'll give you an example, a micro and a macro example, right? A micro example could be, perhaps you are an engineer, or maybe you're a specialist in your field, and you were able to do a project or solve a problem, right, that maybe nobody could solve, and you were able to do it very quickly. And you set sort of a new standard now, right? Even if you were doing this on a project or for your employer, well, that is significant, because now you are having a broader impact in the field, right? And you could come to the United States to have that same impact in the US field, right? So in the US engineering field, you can come and you have this special technique or this technique that improves a certain process. So that is how, on the micro level, right, an EB2 and IW may work. On the macro level, right, by virtue of you coming to the United States and helping the US industry or the US field become more efficient because you're introducing this new technique, it will help the United States become a leader on the global stage in that specific industry. So I think that for EB2 and IW petitioners or self-petitioners, it's really important to understand what immigration is looking for as far as the impact is concerned. Now, I know that not everybody, will be submitting petitions with attorneys, but if you want to understand how to perhaps argue your case, right, you have to show immigration that the problem you are solving is going to help the United States become a leader. It is going to help the United States be number one, right? We're talking about American exceptionalism here, and that is what the United States is looking for in EB2 and IW petitions. So we've still received approvals with EB2NIWs. Of course, we're getting RFEs as well. But that is what the focus should be. I think also, it's important to be very strategic with these filings, not dump everything at USCIS, at the officer who's going to be reading your case. Really be strategic and focus on maybe 1 to 3 points, right? 1 to 3 arguments of how your endeavor will help the United States. That is how we're approaching these filings right now, and just trying to make them leaner, more succinct, and really just, to the point of exactly, driving the point home that we really want the immigration officer to come away with.
All right. There you go. Thank you so much, Ingrid, for sharing that with us. And we should definitely speak with Sakshi and reply to her comment as well. So let's take that quickly. Sakshi, hi again. She's saying, I've heard rumors that Trump campaign plans to tighten the eligibility for green cards, especially for workers from certain countries. As an immigrant who's already been waiting for my green card for a while, what could this mean for my application?
Well, I think that, we heard, well, during Trump 1.1, we had the Muslim ban where people from certain countries were unable to come to the United States, and a lot of people were affected by that. We do have reports as well that Trump is putting restrictions on certain countries, although that has not been official yet. And I think the New York Times was reporting something like there was a list of like a three tier list, a red list, a yellow list, and maybe an orange list of countries. I don't recall exactly, but if you were on the red list, then these people would now be allowed to come to the United States. People on the yellow list, or the countries on yellow list, had to have heightened scrutiny, and maybe the countries on the orange list had to, abide by some requirements from the United States in order to have their citizens be able to come to the U.S. So I have not seen anything that is official yet. However, I do have clients from the countries that were mentioned on those lists that are worried, right? They're worried because they're in the process, they're in the immigration process, and they're worried of whether or not they won't be able to, actually complete their immigration process during this administration or until this ban is lifted. So I think as of right now, there's nothing official yet. This was, something that was reported in the New York Times, but I think it's definitely something to watch and something that, people should be prepared for, and not make, if you're outside of the United States, don't sell your house, don't sell your car, wait until you have that visa on your passport so that you can, make that transition, more confidently.
Right, right. Very, very good advice, I would say. A good tip, because we need to make sure, be 100% sure first, and only then move forward, especially big decisions like, your properties. So thank you so much for that, Ingrid. And now, Sakshi, thank you also for your question. If you have any more questions, please feel free to comment. And folks, you can also join us on call. The number is 425-436-6335, and the access code is 988-888. Join us. And hi, Parker. Well, hi. We got another question, so we'll quickly take that up as well. Bhargav is saying Trump's immigration crackdown to target 2 million undocumented individuals with criminal records, or final removal orders via large scale enforcement actions and workplace raids. Does this policy mean that? I think Bhargav is still typing. But what would you like to say for this first part? Anything, Ingrid?
Yeah, so this is a very ambitious goal. I think it was reported somewhere that the goal is to deport 1 million individuals, 1 million undocumented people a year, which is a very ambitious goal. It will cost the United States a lot of money to be able to do that. I think I think people have to be mindful of what they hear or see as headlines on the news and what could actually happen, like the real logistics that it is required in order to make this happen. One of the things that has been said recently by the Trump administration is that they want to expedite these or make these removals faster, which is why they are removing people to like El Salvador, for example, without giving them the opportunity to have their case heard in court. And of course, there's a lot of controversy around that because our entire American system of justice is based on this idea of due process, right? So right now that is being challenged in the courts. And I believe that there is a pause right now where the Trump administration cannot deport people this way. And if you think about it logistically, to deport 1 million people a year is, requires a huge operation. At the same time, the Trump administration is removing, firing judges and limiting the size of the judiciary and immigration courts. So it becomes very difficult to achieve this if the infrastructure is not in place. So at that point, we run the possibility of having these actions that bring a lot of shock to the population, right? And that is challenging court. And I think makes it harder for them to achieve this goal. So I think it's really important to keep that in mind. I think I mentioned earlier that the numbers that have been reported by ICE and Customs and Border Protection, as far as the number of people that have been removed, have not changed significantly from last year. And that is, enough, that is in part because removing people from the United States requires an infrastructure, and our immigration removal infrastructure is not great. And I'm not talking about detention centers. I'm talking about judges. I'm talking about cases in immigration court that have been lingering for years and years and years. Asylum applications that have been also pending for many, many years. Just a system that is completely broken and operates, by mail. And it's very difficult for people to navigate the system. So, that is the infrastructure that I think, any administration should focus on if they want to make immigration more efficient, if they want to resolve the problems of our current immigration system. The things that we have going on today doesn't meet the needs of today's society. And I think that's very important to understand.
Absolutely. And we got the second bit of Bhargav's comments where he's asking, does this policy mean that anyone who has committed even a minor offense, such as a misdemeanor, could face deportation? Or are there specific criteria for determining which crimes make someone eligible for removal?
So this is a great question. Under the Biden administration, Biden did issue a set of priorities, of enforcement priorities, which really allowed, immigration enforcement to focus on a specific subset of individuals who were in the United States that the prior administration had identified as removal or enforcement priorities, right? People who had convictions, criminal convictions, those were the priorities. Trump did away with those Biden priorities, and there's no real, understanding with Trump other than everybody is on the chopping block. We still have crimes that make people removable from the United States, right? That make people inadmissible, meaning that if they have those convictions on their records or those activities, they aren't able to get a visa or unable to get permanent residency. That has always been the case, But what we are seeing is, and especially what is being reported, is that, there is greater enforcement now for violations that are relatively minor, that may not fit within these crimes of moral turpitude, or these crimes that make people, eligible for certain immigration benefits. Those violations are also people with those violations are also being targeted. And of course, there has been lots of reports of people with minor traffic stops or, traffic citations or misdemeanor convictions that have been targeted. And I think it's really important for people who are permanent residents, people who have green cards, if they have a criminal conviction of any kind, speak to an immigration attorney before you leave the United States, because there's been a lot of reports about green card holders being, detained at the border because they have money. Important to keep that in mind.
Yes, absolutely. And also, I hear people are facing sort of some difficulties, coming back into the US again if they have stayed way too long outside, maybe in their home countries. Would you like to say anything about that as well?
Sure. Sure. Yeah, and that's happened to a few of my clients as well. I mean, and sadly, a lot of my clients, even those, even green card holders and naturalized U.S. citizens, are calling us and asking, hey, should I be worried? And my advice is, any for a green card holder, any non-citizen, anytime you leave the country and you re-enter, you are asking for permission to come back in, right? Obviously, if you're a US citizen, the US has to let you in. If you're a green card holder, they will generally let you in, but if you have something on your record that flags more, secondary inspection, they will take you to secondary inspection and ask you questions. I think in that situation is really important that people have an immigration lawyer's card available in their if they're ever in that situation. It's also really important that people do not sign anything at a port of entry unless they know exactly what it is they're signing, because Customs and Border Protection can have you sign or can ask you to sign a document where you are abandoning your permanent residency, and you don't want to do that inadvertently. And I'm not saying this to spread fear or anything, but really just to spread awareness that you can say no, right, to signing anything, and you can ask to speak to an attorney first, and it's very important to know that you have those rights. um, so I think that for people traveling as well, it's important to have your documents in order. It is important, if you're a permanent resident, to maintain your residency in the United States. You don't want to be spending a majority of your time outside of the United States, because that could, cause a CBP officer to conclude that you are trying to have it both ways, that you're, just coming to the United States temporarily to keep your green card. So it's really important that you maintain your physical presence here, file your taxes, do everything the right way, be a good citizen so that you can become a US citizen eventually and not have to worry about this anymore.
Okay, okay. Thank you so much, Ingrid, for taking that up as well. And thank you, Bhargav, for your question. We also have Ganesh join us, so let's take that up as well, Ingrid. This is about J1. So I'm on J1 visa right now, and I've been told that Trump administration might impose new restrictions on certain visa holders, especially in sectors like tech and healthcare. Could these changes affect my ability to stay in the US after my program ends?
Well, it depends. It depends on how you're looking to stay in the United States after your program ends. So, for example, assuming that you're not subject to the 2 year home country requirement, of course, right, where a lot of J1 visa holders are subject to the 2 year home country requirement, and later on you want to switch to H1B or an O, or maybe you meet a US citizen and you decide to get married and get a green card, right? So it just very much depends on how you're planning on staying here in the United States. But if you're specifically thinking about tech and the healthcare sector, right, I think it's important to review the priorities of the administration, in these specific fields, and how they perhaps, are being advanced, right, through immigration policies. So in AI, for example, right, there is an executive order or an executive memo that talks about the importance of the United States advancing AI, right? So look into that, because that is something that may affect immigration policies. Again, we're still within the first 100 days of the Trump administration, and we're waiting to hear these recommendations that Trump ordered all departments to make, right, to revisit the policies and things like that. But can it affect certain sectors? Absolutely, right? So, in part of Donald Trump's platform is to keep America competitive, right? Keep America as a leader in the world stage when it comes to different industries. And if technology and healthcare, if those are areas that, the United States has a priority in, then I think,
Yes, for sure, Ingrid. Thank you so much for taking that up as well, and um, thank you, Ganesh, for your question. And folks out there, please feel free to join us with your comments. And to all those of you who resonate with our content and whatever Ingrid has been sharing with us, her expertise and knowledge, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. We are not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So, Ingrid, can you hear us now? We lost
Yes.
you a bit. Yeah, I'm so sorry. We lost you a bit. But if you want to add more to Ganesha's question, you may.
Oh, I'm sorry. No, I was just going to say that I think that, there's still a lot to be seen. I'll just wrap up by saying that we're still waiting for those recommendations for specific sectors, but I think it's always important to kind of know where the priorities are of the administration, because I think that will inform a lot of immigration policies as well. So just, be on the lookout for that.
Okay. Thank you, Ganesh. Thank you, Ingrid, for your question. Thank you, Ganesh, for your question. And thank you, Ingrid, for taking that up. So, Ingrid, also wanted to know if, you know, because are we seeing more requests for evidence, RFEs, or denials in employment based immigration cases under the current policy?
I think in the world of self petitions like EB1As and EB2NIWs, EB2NIWs, definitely, there has definitely been an increase in requests for evidence, especially out of the premium process, office. I think that if you're filing a case, premium process, expect an RFE. So I think in those fields, we're definitely seeing an increase in requests for evidence. Um, those are discretionary benefits. And because of the recent policy guidance changes, applicants are adapting, attorneys are adapting. And I think the USCIS officers who are learning, to navigate this new guide are also adapting. We are seeing a bit of, inconsistent requests for evidence where, perhaps newer requirements are being created, right, where they don't necessarily exist in the law. So I think it's important to, keep in mind and be strategic on the responses, right? And if cases do get denied, which they have been getting denied as far as EB1As and EB2NIWs, and the demand for EB1As is also very high, and those cases are very difficult. I think that, it's important to keep in mind the options, whether to refile or, do a motion to reopen and reconsider. I think that the industries that are perhaps, or the individuals, professions who are perhaps hardest affected by the new guidance are people in the IT industry, software engineers. These individuals, I think, are having a harder time convincing immigration, to approve an NIW, just because of the new policy guidance. And of course, what happened over the last, couple of years since 2022, where there was just so many people applying, or so many people submitting petitions in this category. And there was I think now we're going through a period of recalibration in these types of visas.
Right, right. And you were saying about new things that they are asking for. So biometrics is what I hear. And another one is addresses, their home addresses, even for H1B applicants only. So would you like to highlight anything on these lines, or if it's already started, the practice has already started?
I think, for employment-based visas, it's very important for employees and employers to stay compliant and on top of, these cases as much as possible, because there has been announcements that there will be more in-site inspections, confirming that the individual is working at the location, that it's a bona fide job offer. I think it's very important for employees, people on H-1Bs and different work visas, to keep their documents with them, organized in a safe place, make copies of everything, keep everything stored in a really safe location, keep track of dates. Keeping track of dates is incredibly important, especially if you're here with family members and maybe family members came to the United States after you, keeping track of their dates as well, because you don't want to inadvertently or, unintentionally miss a deadline. No, I always tell people, put on your calendar, that status expires, in 6 months, so you can plan and have enough time to figure that out. I think that's also really important. And any travel plans need to be discussed with your attorney. I think that's also very, very important in this world.
Yes, yes, absolutely. Thank you so much, Ingrid, for highlighting those very important points to keep in mind. And yes, friends, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And you can also check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So check us out and join us now to ask your questions. All you have to do is comment wherever you're watching, or call us on this number 425-436-6335, and the access code is 988888. So today, friends, we're discussing on 100 days in, how the Trump's campaign return is already shaping the US immigration. And we have with us none other than attorney Ingrid Perez. And yes, it's really nice to have her here, to explain to us and shed light on all these questions that we have for her today. So thank you once again, Ingrid.
You're
And
welcome.
we do have more questions, so we will address them. But also at the same time, I would like to tell you that we will take up some of our Facebook questions that we receive in our group. So, Control, please display them soon. But meanwhile, Ingrid, if you can tell us also, how have visa interviews and consular processes changed, if at all, since Trump resumed office?
The biggest change that has happened is the interview waivers, right? During the prior administration, a lot more people qualified for interview waivers. And now a lot more people have to have interviews at US embassies and consulates abroad. So that has been the biggest change for sure. And, one thing that I would also add is that in certain countries, we're seeing a lot more scrutiny for employment based visa applications where the embassies or the consular officers are refusing the visas and sending the petitions back to USCIS for reconsideration. So I think that for any person going to an employment based visa interview, whether that is an immigrant visa or a non immigrant visa, it is very important to be ready to discuss your case, be ready to talk about your qualifications, where the job is going to be, the work that you're going to do, and how you are going to be able to actually do the work, right? So I think it's really important to prepare for the interview and be ready to talk about the work, your profile, your background, your resume. All of that is very important so you don't run the risk of the consular officer having doubts about the petition that USCIS approved and having it sent back to USCIS and refusing your visa. I think that's very, very important to prepare.
For sure, yes. Thank you so much, Ingrid, for telling us that as well. And I hope that people out there, folks out there who have joined us, all viewers, I hope you're taking notes and keeping in mind as well. So, yes, if there is anything we can help you or assist you with, with answers, do comment. And yes, our handle is at Immigration Talk Show. Subscribe and ring that bell so that you will be notified whenever we have discussions like these. Right. So, Ingrid, let's take up some of our Facebook questions now. So, this is saying, my friend's I-140 got denied recently at first attempt, even without getting an RFE. Has anyone got this experience? Any chance to be approved? EB3 unskilled.
So that has never happened to me, but I know that that has happened before. I would tell your friend to look at the reasons why the petition was denied and see if they can do a motion to reopen or reconsider. It's kind of hard to say exactly without understanding the reasons for the denial. You know, if for example there wasn't an RFE, are you sure there wasn't an RFE? Because a lot of times USCIS does send an RFE, but maybe you never get it in the mail, or the employer, the petitioner, never gets it in the mail. So it's very important to monitor these cases, because if you don't receive the RFE in the mail, right, it's like you never got an RFE, but it was actually sent over. So it's important in those situations to contact USCIS and make sure that, if you see on the case status website that an RFE was issued, that you actually received the RFE. So double check that. But yeah, so I think, keeping in mind the dates on the denial and the dates, the deadlines to file a motion to reconsider is really important in this situation. It's hard to say without understanding exactly the reasons for the denial.
Right, right. It is happening. So thank you so much, Ingrid, for taking this up. And now let's go on to our next one. This is from an anonymous participant. Hello. Usually, how long the process of I-130? My husband is my sponsor for my I-130. He applied that was last year, August. Thank you.
So the I-130 is an immigrant petition for the family category, assuming that this husband is a US citizen and the person is outside of the United
Mhm.
States. Unfortunately, these cases are taking a really long time. The processing for an I-130 petition by a US citizen spouse for a foreign spouse who's living abroad is incredibly long. Even on the USCIS's website, it's saying that it's something like 3 months or so, which is insane, right? Compare that to if a person is here in the United States, and it's a spouse petition by a U.S. citizen for a foreign national who's physically present in the United States. That case can go significantly faster, especially in a situation where the foreign national is also filing a concurrent green card application or an I-485. I've had those cases get approved relatively fast compared to just how the I-130s are taking for spouses who are outside of the United States. I have a lot of I-130s that have been pending for longer than a year. And when we do inquiries with USCIS, there's nothing we can do because according to the normal processing times, these are taking some 30 plus months, which, you know, um, it's really unfair for a couple that, to be forced to live apart from each other for that long. It's really difficult on the family. So I can imagine how difficult it must be for this person as well. Check the monitoring, check the case processing times, make sure that you're always on that website. And as soon as you're able to submit an inquiry as to why the case has been going on longer than it's supposed to, make that inquiry.
Right, right. It sounds very interesting and sad at the same time. And with all this, I mean, this whole, process, this long wait, I mean, relationships also could see many changes because of the challenges that they have to stay distant from each other, right? Ingrid, has it ever happened to you?
It's
Do you
very
have any cases like that?
well. I've had cases where U.S. citizen is filing for a petition for a foreign national, and then their relationship doesn't work out, because the distance is so it's difficult. I mean, things like that happen, right? That's unfortunately it does. But it does create such a strain in the couple, right? Especially for perhaps one person who's trying to, you know, go back and forth, usually the US citizen who's going back and forth between the US and the spouse's country to make sure that they maintain that relationship and to see each other. It's really difficult. And flights aren't cheap. Travel's not cheap. It's a huge financial strain.
Yes, true, true. Thank you, Ingrid, for highlighting that as well. Now we'll go on to our next question. This is also from an anonymous member saying, hi everyone, I'm currently on H1B. Control, if you can zoom in a little bit, please. I'm currently on an H1B and recently transferred roles within the same company from a product manager position to a software engineer role. I made the move assuming it would be a smooth internal transition, but I've now realized that an H1B amendment should have been filed before switching, since the roles are quite different. And has anyone been in a similar situation? Did you have to face consequences, or were you able to fix it by filing the amendment after the switch? Any guidance or suggestions would be greatly appreciated. Trying to stay calm and figure out the best next steps before talking to HR or anybody legal.
So this is a situation where legal should have been, brought in before this change for sure, because the H-1B is tied to the position. I mean, even if it's within the same company, product manager and software engineer, those are two completely different job titles. And I'm gonna, go out on a limb here and assume that they have completely different job descriptions, job duties. So for sure, an H-1B amendment should have been filed before the switch. In this situation, there may be an able to save this person's case by doing a non-protunct request. Um, and I would say speak to the attorney as soon as possible and bring this up to his or her attention to get this resolved, because you want to make sure that you stay compliant with your H-1B.
Right. Right. Thank you so much, Ingrid, for taking that up. And anonymous member, I wish I knew your name, but thank you for your question. Let's go on to our next one. Vignesh is asking, when can I expect my PD to become current? EB2 India, May 2015.
I wish I could tell you, but I can't. Um, you know, we'll see if we have any jumps in the new quarter, of this year, and we'll see if we have any jumps in fiscal year, next fiscal year, October 1st. But I'm sorry, I wish I could give you an answer. I don't know.
Yes. Sure. Thank you so much, Ingrid, though. And folks out there, Vignesh, also please do not forget to subscribe to our channel and hit that bell icon so that you're notified whenever we have updates on this as well. And we really look forward to visa bulletins every month. So let's hope for the best for you. All the best. Now we got another anonymous participant asking, if F1 student decide to change it E2 in the middle of the degrees, will it have a negative impact during the interview?
Um, I think like any other change, like I have a lot of individuals who change from tourist or B2 status to E2. Based on this question, I am assuming that the person is going to apply for an E2 at the consulate abroad, so they will be going to an interview. I think that it is, expected for the immigration or the customs. I'm sorry, the consular officer to ask questions around the F1 students' activities. To make sure that they weren't inadvertently working without authorization or anything like that in the E2 company. I don't necessarily see a problem with this, because if you have been maintaining your non-immigrant status, you're now just switching to another non-immigrant status. I don't see a problem with it, though. We live in a different world now, so it's very important to be prepared. If you're doing an F1 change in the United States, where you're just changing your status with the USCIS, you're probably not going to have to be going to an interview abroad. And this change can be approved by USCIS. However, if you then later on decide to get an E2 visa, you should be just prepared to, provide evidence that you were maintaining your status, and all of that, so that they don't refuse your visa for those reasons.
Okay. Thank you so much for taking that up, anonymous, and also anonymous participant, for your question. I think with that, we have definitely covered all of our questions from our audience, Ingrid. And also, I did have a couple more questions. So before we leave, if you could actually give out some legal tips that you give out to families or individuals out there who are waiting on green card approvals during this period of change.
Yeah. The question that I get asked most often after we file a visa application or a petition or a green card application is, what's going on with my case? Once we file a case with the immigration authorities, we don't know what's going on with the case. Immigration communicates with us by mail, right? We can't see, unfortunately, behind that wall where the immigration cases are being handled to know exactly what part of the process you're in, right? But I can generally explain that, first a case has to go through the normal background checks. Under the current administration, there is, more extreme vetting. So these cases probably will take longer, the further in we go. So just expect the cases to take long, and not there's not much that can be done to make things go faster. So I think it's important to have patience and understand that the government operates on their time and not on our time. Immigration is slow, it's bureaucratic. it's important to be patient. So just so that you can maintain your sanity. And that's maybe not so much legal advice, but just more, personal advice so that you maintain your sanity during the process, and not go crazy waiting for when things are going to happen. However, of course, on the flip side of that is if a case does go beyond what is typical, right, then there are ways to address that as well. But for the most part, I think it's important to just you know, remain updated on the case, make sure that, you track expiration dates, communicate with your attorney, especially if you're moving, update your address with immigration. That is very important. Carry your documents with you, especially now where, we're seeing a lot of domestic enforcement. It's very, very important for people on H-1Bs or green card holders, anybody here on an F-1 visa to carry proof of their status with them. That is incredibly important.
Yes, extremely important points. Thank you so much, Ingrid, for highlighting them. And I hope you've taken down those tips, friends, before we ended our show. So I think I can only say thank you so much, Ingrid, for your time and for sharing your expertise and such important updates and information here in today's session. So it was really lovely having you here with us today.
Likewise, thank you for having me.
Thank you, Ingrid. And folks, do not forget to contact attorney Ingrid Perez herself if you especially need a one on one consultation with your case. Her number is 407 906 0068. And you can also email attorney Ingrid at info@ibplaw.com and go visit ibplaw.com to get to know more about attorney Ingrid Perez and IBP Law. So thank you so much once again, Ingrid. Have a wonderful day. I hope to see you soon.
Thank you. Likewise.
Sure. Folks, you can also join me or ask me your questions. You can write to me. My email address is nipa@staffingly.com, and you can also call me on my number. This is also my WhatsApp number. My number is 408 335 6444. And I hope that you really resonated with today's session, with Attorney Ingrid Perez from IBP Law. It was really lovely having her. Don't forget to check her out. She's there also on LinkedIn, and check us out. We are on, not just on YouTube at Immigration Talk Show. Do not forget to subscribe to our channel. Share this handle also with your friends and family who could benefit most because we come up with the latest updates on US immigration. So please share this and ask them to like and share as well. So, yes, check us out. We are on Facebook, LinkedIn, X, and on Instagram as well. Thank you once again, everyone, for joining us. But stay tuned because we got some really amazing webinars lined up here on our channel, and you would not want to miss out on these latest updates and great informative sessions that we have. So yes, we do have more joining us. So we do have Deepika Gupta, who's going to join us very, very soon. Dr. Deepika Gupta at 9 a.m. Eastern Time. We also have Ms. Attorney Uma Mantravadi joining us at 3 p.m. Eastern Time. So check them out and stay tuned here on Immigration Talk Show. Bye for now. Hello, everyone, and welcome back once again to Immigration Talk Show. I'm your host, Napasa, and I have another very interesting and insightful session lined up for you. So stay with us. Yes, and before we head on with today's discussion, and I have our guest join us, I have this very important disclaimer to also read out. So, yes, friends, by watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind. And also, welcome once again to Immigration Talk Show, friends. It's going to be very, very interesting because we are going to have another very insightful discussion. And yes, this has been creating actually a lot of uncertainty and concern in the recent months, if we look back as well, border issues or visa delays and sudden changes at US consulates worldwide. So, all of these things are what we're going to discuss today. And, if you've recently also faced some sort of unexpected questioning at the airport, long visa wait times, or are even confused about, shifting policies from CBP or consulates, you're not alone. And you're welcome, very much welcome to ask your questions, to clear your doubts, and you can do so by commenting wherever you're watching or join us on conversation on call and do that by dialing this number 425-436-6335, and the access code is 988-888. So yes, without further ado, to help us unfold today's discussion, please help me welcome Attorney Justin Rivera, Senior Immigration Attorney at Boston Immigration Litigation, based out of Houston, Texas. And Justin always brings a wealth of experience and deep commitment, to helping individuals and companies successfully in immigration maze. But also, it's always great having Justin here with us because his insights are really very helpful. So hi, Justin, once again, and welcome to Immigration Talk Show.
Hey, thanks a lot for having me. It's good to be here.
Yes, same here. So I'm looking forward. I know sometimes we don't have too much of good news to share with all of our audience, but these are important points and we really need to mention. So yes, today's discussion on the topic trouble at the border, what CBP, visa delays, and consulate changes mean for you. So I think it's only obvious what we can expect, but do highlight some points so that people out there stick with us.
Yeah, I think it's imperative moving forward as we've kind of got we've gotten through the first quarter of the year, right? We're pretty much moving into the mid part of the year, and we're starting to collect data. We're starting to have information that's going to give us an inclination as to what to expect over the next 4 years. And I think that most of that data has led to the conclusion that what you can expect is a more aggressive approach when it comes to immigration in the United States. And that's going to be applied across the board. And that means USCIS will probably be more stringently adjudicating their cases. CBP will be more stringently reviewing people for inspection and admission, and the consulates will be, utilizing the enhanced vetting to more heavily scrutinize applications for visas. And so I think across the board that's already been seen, and it's gonna lead to a need to educate and prepare individuals for all aspects of immigration, not just the filing at USCIS. I think the days where you can just send someone abroad and confidently know that they will come back into the U.S. are gone. I think that that's just how it is. And to just anecdotally mention it, so to give you guys an understanding of kind of what we're dealing with right now, I actually this morning had an individual who got a visa, an H-1B visa, issued to them on, I believe it was the 11th. They picked up the visa on the 11th, I believe, at the consulate in Hyderabad. And they went to travel yesterday. And while they were traveling, they were stopped in Qatar and actually told that they could not board their plane because their visa had been canceled. Now, this visa was only issued 6 days ago, and it was approved by the consulate. Between that time, when it was approved and when this individual traveled, the consulate canceled the visa, did not notify the individual why the visa was canceled, and gave the individual no opportunity to respond to an issue or provide additional information. He had no idea whatsoever that this had happened. Now, this is the first inclination of this that I've seen, but according to him, when he was in Qatar, when he was at the airport, he was actually stopped by individuals who basically took him aside and waited until members of the U.S. Embassy actually came. And those individuals told him that he couldn't come in. What was really ludicrous about the whole situation was they could not explain who canceled his visa or why his visa was canceled. There was nothing. There was no paperwork provided. There was nothing communicated at all to this person. He was literally just told, you can't travel into the US on that visa. They turned him around and had him leave. So that's the kind of world we're living in presently. And I think people need to be aware of it and prepared to deal with those issues. Now, this person I truly believe will exist as an outlier. At least that's my hope. But we'll have to kind of wait and see. But I do want to kind of give you that personal story about something we've dealt with very recently that highlights what it's like traveling abroad right now.
That's crazy. I mean, if the person didn't even know why he had to go back, he doesn't know. I mean, I what about the situation now? Even now, there's no real.
So they told him to contact the consulate for an explanation. Now, what's interesting about that is it is very hard to get someone from the consulate to speak with you while your visa is being reviewed. After your visa is approved, it's darn near impossible. You can't just walk into a consulate and say, hey, I have a visa that got canceled. Can someone talk to me? You're not going to get into the consulate without an appointment. And so we are corresponding or attempting to correspond at this time with the consulate to obtain some sort of information. Now, the caveat to all of this, truthfully, is before his visa was issued, he was someone who had one of those SEVIS termination emails.
Mhm.
And at the time, our thought process was, well, that's in relation to his F1 visa. You know, it has no bearing on the H-1B. Otherwise, it would have been brought up at the consulate when they were doing his interview. My thought initially is, hey, maybe the officers were wrong. Maybe they thought the F1 being revoked, the F1 visa, somehow played into the H-1B, also somehow being revoked as well. That's possible, but it doesn't make sense. Like there's not a justification for that. Like it's not logical to say that, oh, that F1 student visa, which by the way was actually withdrawn at the port of entry because of this case. I won't go into the further specifics of it, but it had actually already been withdrawn, this visa. So when the SEVIS termination happened, it actually canceled or revoked a withdrawn visa, which makes even less sense. All that is to say, we don't have a justification. We're trying to get one from the consulate. I will let you guys know, like next time I'm on, what the conclusion of that is. But I think at the end of the day, the problem is you've just inconvenienced this person. Like this person now has to very likely go to another visa interview, hopefully get issued a visa because they already had an issue getting it given to them the first time, and then travel again and hope that they can come into the United States. And by the way, just to put a button on the end of this individual isn't somebody who works at, a 7-employee consulting company or one of these employers that the Trump administration clearly is targeting in regards to H-1Bs. This person works for a university. They work for a prominent university. And the fact that that person is now incapable of returning to their employer at that university because of this mix-up, it's ridiculous. But I think it is telling in that we'll see a lot of this kind of stuff happening over the next couple of years.
Sure, sure. I mean, we just have to be ready for anything and everything, friends, and also be prepared. I think the best way possible with all the documentation, right? But still, we don't know what can happen. Let's just hope that we are lucky and pray hard. I think that's all we can say for now. But let's come to our discussion for today's topic, friends. And yes, I do have questions. And quickly, I'll just say hello to Yuri. Hi, Yuri. Thank you for joining us here on YouTube. We are going to take up your question very soon, but stay with us for now. So, Justin, we've really heard a lot about these secondary inspections lately, and if you can explain what they are and why travelers are increasingly being flagged for them.
So, yeah, I think secondary inspection. So, just to explain what secondary inspection is, when you come into the United States, you go through CBP, right? CBP has the ability, the authority to uh, inspect you and ultimately grant you admittance to the United States. Now, most people's inspections are brief. It's a couple questions, maybe none, and then you're flagged in. Look at the docs, say hi, where you going, where you working. That's it. You come in. Others, typically people who have a flag in their immigration record. Maybe something like they've worked with an employer that's previously been flagged, or they work in a contractor situation where they work for an end client. Maybe someone who has been in the U.S. for a long time on one type of visa and then has moved to another visa and is then coming in. It's a litany of justifications that are now being utilized. But by and far across the board, when secondary is invoked, it's because there is allegedly some information that is displayed on CBP's data hub that leads them to believe that they can ask additional questions. Now, I think before the administration change, that CBP secondary inspection was something that was more readily available for kind of outlier situations, circumstances where maybe there was a clear flag that was placed by FDNS, who is USCIS's fraud detection agency, in relation to a case, and the person's taken into secondary in question for that. Now, we're seeing it used with a much broader scope, and secondary inspection has been utilized now on, visa holders, legal permanent residents, and there's even been occurrences with U.S. citizens being taken into secondary inspection, which is really interesting because a U.S. citizen can't be denied entry to the United States, but they're still taking them into secondary, which is, it's odd. But once you are in secondary inspection, you are there for as long as they tell you you are there. Meaning, if they want to hold you for 2 hours, they can. If they want to hold you for 8 hours, they can. And during that time, they have the ability to review any of the electronic devices that are on your person and any of the information that you have on hand, physical copy of a resume or something like that. So I think before, most of the time when you had someone traveling into the U.S., the thought process was you got your visa. Let's say you're on an H-1B. You got your visa. You got your approval notice. You got, your an employment verification letter saying we need this person to work in the U.S. You're good to go. That was before. I think nowadays people need to be prepared for the thought of CBP having deferred inspection occurrences with way more regularity. And unfortunately, we've heard about certain ports of entry specifically that have more aggressive CBP officers than others. I specifically would highlight Atlanta, the airport in Atlanta, who we've gotten reports of officers doing really questionable activities. Anyway, once you're back there with CBP, they have access to everything you have on your person, and they're gonna, ask you any questions related to anything in relation to your immigration record. That could be, previous H-1B, previous F-1, your current H-4. Anything is on the table. Now, I would be kind enough to CBP to say that before the administration change, the only people they were really hounding on were people that they thought that they already had issues for fraud, like fraud finding issues. And they were basically just trying to get the person to admit to the commission of fraud or misrepresentation so that they can put them in expedited removal. Nowadays, I think that they are more aggressively employing intimidation tactics with the end goal of trying to secure more expedited removal orders to make their immigration records look better. That's my personal opinion. Now, the reason for that is to go around and deport people that are in the country illegally, you have to find them. And it may not be that easy to actually find people that are actively hiding in the United States. Someone that comes in through CBP has to be inspected and admitted. They avail themselves to the officers. So if someone's right in front of them and they think that they have a way to get that person removed or cancel that person's visas, I kind of think that's the way they're going to behave presently. And I think we've seen that play out with a unfortunately high level of frequency over the past few months. And that's really it. I mean, that's kind of all of it in a nutshell. It's unfortunate. It's disheartening, but I think it speaks to the anti-immigration desires of the present administration.
Right, and it's happening. So, friends, whatever you've been hearing is true. And I know this is really bringing up a lot of different mixed emotions, rather. People who had dreams to come to America, they're now rethinking, rather, or maybe routing out to different countries as well. That's what we hear. I mean, I'm just saying it from the news. So, yes, that's there. But anyway, yes, friends, traveling is still on, but do make sure of your plans and see that, yeah, I think all your documents they need to be on point for sure. And now let's go on to my next question. What specific categories of travelers, whether students, workers, or visitors, should be most concerned about being questioned by CBP upon entry?
So I think that students engaged in OPT and STEM OPT, I think, should be very cautious over the next few years with travel in and out of the United States. Um, I don't think it's any secret that Stephen Miller, the proponent and architect of the Trump administration's immigration policies, Stephen Miller does not like that the F1 students have work authorization. They, take the stance that that work authorization is unnecessary, and that after individuals complete their studies, they should either, transition to another visa or depart the United States. Basically, once you're done studying, you should go. You should leave. It's ridiculous, obviously, because the United States benefits from highly educated individuals remaining here and working, and usually a lot of those people transition to an H-1B. But those individuals, I think, they're definitely being targeted at a significant rate. H-1B holders who work for traditional, bigger organizations, like really, your Metas, your Googles, your, all that stuff. Those people seem okay. The people who I think are seeing the biggest pushback are people who work in contractor situations, people who work at third-party client locations. I think those individuals have been getting pulled aside in secondary more. There is a really big. I've just seen this from several cases. There has to have been with CBP some sort of internal memo or something issued about verifying somebody's placement when they're working at a third-party location. And that's either, through them producing a client letter or producing the name and, the contact information of a person that can verify their placement at the location. I think those are the individuals that I've seen with the biggest level of pushback. And that all being said, there's also been individuals who've come in on B2 and had their visas canceled. I think there was a very big public hubbub recently about some European kids who were trying to go on vacation in Hawaii who got their visas canceled because they admitted that while they were in the US on B2, they might actually do some work for their client that was, in Europe. And they said, that's not the purpose of the B2 visa. Your visa's canceled. So they will look at everyone across the gamut. But in terms of the general people that I think have the biggest risk in travel right now, I think it's the F1 students that are here solely subject to work authorization, and the H-1B holders at contractor companies.
Right. Well, thank you so much, Justin, for that detailed explanation. And folks out there, thank you for joining us. Hi, Jay Bhatt. We are going to take up your question very soon.
And please feel free to comment, whatever questions you have. We are going to take them very soon. Also, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also, check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Follow us, subscribe to us, and stay connected. So, yes, I think let's go on to the next question that I have for you, Justin, is why do some immigration experts suggest that returning to the US should be treated like attending another visa interview?
Because it has the potential to be, honestly. When you go to the consulate for your visa interview, um, generally, the officer's trying to affirm at the consulate that the statements and facts within the petition are accurate and correct, and that the individual will utilize the visa within the parameters of what the visa is for. Perfect example that would be, if you're applying for an H4 and you go, what are you going to do while you're on the H4? And you say, oh, I'm going to go, in the United States and I'm going to live with my spouse. Are you going to work? And you say, yeah, I'm going to work. Well, you have to have an EAD to work. So unless there's some level of clarity there, saying, oh, I'm going to work once I have an approved EAD or I have an approved EAD, you might be operating outside the confines of what the visa allows, which is a problem. So that traditionally was something that you dealt with at the consulate. And at the consulate, they have the opportunity to review any of the information that you submitted in the DS-160. The DS-160 can ask if you've ever overstayed your visa. Have you ever been violated your status? Have you ever had a visa canceled? So all of those things are grounds for scrutiny. Before the new administration came in, that was all done at the consulate. And then once you came in with CBP, and you would hear of the very extreme outlier individual situations where CBP deferred inspection led to an expedited removal. And it would almost always be a dead to right situation where, FDNS has basically clearly established some sort of fraudulent activity in relation to the company or the individual. They come in, they put them in secondary, they procure a document, or they get an omission that, oh yeah, I did something that was fraudulent. You go through expedited removal. Now, because they have really augmented the purpose of secondary inspection to encompass previously, unthought of scenarios or issues, now you have secondary inspection being used almost like an opportunity to do another visa interview. It's another opportunity to, say, use an H-1B, for example, go through the petition, but not only the petition, the individual's immigration history in the country as well. And that's something that I think people need to realize as the kind of new reality. Now, the difference between the consulate and CBP is obviously when you go to the consulate, most of the time your interview's 10, 15 minutes. Outlier situations, they might take you into another room to ask you a couple additional questions. But by and large, it's a quick thing. It's a fast process because the consular officer has, 40 other people to see today, so she's just trying to move people through. Secondary inspection is not like that. Secondary inspection is intentionally slow. It is an intentionally drawn out process. The reason for that is the CBP officers are basically trained to utilize making an individual uncomfortable, with the underlying purpose being that you're going to want to avoid the situation you're in. And eventually, if you're worn down over a certain amount of time, you're just going to give up. And you're just going to say, all right, whatever, say whatever you need to say to get out of the circumstance. And that difference is important because it really highlights the fact that by and large, the consular officer, they're going to be looking at you and saying, okay, I'm going to try to adjudicate this fairly. We hope. CBP, just based on what I've listened to over the past couple months, I am not giving that kind of good faith to anymore, especially in certain locations. I think the desire is more actively to cancel visas and have people removed. And that's why I think now the consulate obviously getting your visa is important, but if you have any of these factors that have been highlighted so far, a previous overstay, a violation of status, a problematic employer in your work history, anything, a speed bump, a ticket, an interaction with the police, any of that needs to be prepared for, because when you come through CBP, they can, and in this current day, very likely will raise it as an issue.
Okay. Well, there you go, friends. I hope you're taking notes. And thank you so much, Justin, for that detailed explanation. So, we should take up some of our questions from our audience since they've been waiting. And let's go ahead and take up Yuri's. Yuri's asking, if my visa is delayed because of changes in consulate policy or new procedures, do I have to recourse? Can I appeal or request expedited processing to mitigate the impact on my situation?
So you can request an expedite of your visa appointment under certain circumstances, and those circumstances are country specific. Generally speaking, an expedite request is for something like an extreme humanitarian justification. I think off the top of my head, in Canada, you can expedite for a humanitarian reason or for a work-related reason. Like an example being, I am on an H-1B. My employer needs me in the U.S. by, uh, June 1st. And if I'm not there by June 1st, I'm going to lose the work opportunity. I'm probably going to lose my job. So there are ways to expedite the appointment. Now, once the visa interview has occurred, if you're placed in administrative processing or your passport is taken and they're saying, we're going to issue the visa, if your case is being held up, there are very limited things that you can do. If you're in a 221G, you turn over the documents and information that they ask for, and you're placed in the queue to wait. Sometimes you can move things along if you're able to show that you have urgent travel. Like for example, I had a client once who the consulate had their passports for, I think we'd been going on 10 days, 10 to 11 days, and they had tickets showing that they needed to travel because it was almost New Year's and they were trying to get back to the US. And so I sent the tickets in to the consulate. I said, look, can we do this for them? Like, we need to move them along. And they did issue the visas the next day. They gave them back passports with the visas and everything, and they came in. Outside of those kind of certain, outside of those avenues, it's generally hard to get your case expedited. So yeah, I think for the most part, it'd be, proving imminent travel, the need for imminent travel. And then you have to have proof. You have to have actual proof, meaning, airline tickets showing that you're going to be traveling, and consulates will typically be sympathetic to that. Outside of that, there's really not much more you can do.
Okay. All right. Thank you so much, Justin. And Yuri, I hope you got your answer. Thank you for joining us. Don't forget to subscribe, friends. Our handle is at Immigration Talk Show. Check us out, and also check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. All right, so now let's take up Jay's question. Jay is asking, what if CBP holds my documents at the border for more than the standard amount of time? Should I be concerned, and how can I get the legal assistance to resolve this quickly?
So there's not really a standard amount of time in terms of secondary inspection. And remember, this goes back to the idea of a delay tactic. There is a benefit to the officers in making you uncomfortable and having you wait for long periods of time in between rounds of questioning. Makes anybody irritable or scared. If your devices are seized by CBP, they have two things they can do. They can do a quick search, which is where they basically have you unlock your device and they look through the device. Which they're going to kind of maybe go through your texts, look at your emails, something, WhatsApp, whatever. So that's kind of usually the route that's gone when it's like you're put in secondary, but they don't really have anything concrete against you to actually have a finding placed against you that'll get your visas canceled and get you revoked. The other method is an enhanced search, and that's where they basically have technology that they can use to look through your devices for specific documents or information. I don't have a perfect understanding of the way the system works, but my inclination and what I've gleaned from others is that they basically will look for certain words, because they already have a preconceived notion, and then they're just looking for what they want to get the proof, the definitive proof. So one thing that they're big on is the idea that, someone paid for an H-1B employment. And so what does that mean? That means you paid the H-1B employer in return for them to sponsor your visa, or you paid for the filing fees to USCIS, or the attorney fees. So they'll look for, paid H-1B, paid attorney, paid job, and they will look through your devices to see if there's anything that comes up that reflects that information. What they're looking for is, the dead in the water, the silver bullet. They're looking for, is there a text that says I'm paying this in return for this, or is there an email that says something like that? And then can they use that document to work backwards against you and say, hey, we have this and you said it, like you clearly said it, so you did this, right? And that's what they'll use to cancel your visa and put you in expedited removal. So those are the different ways in which they do the search. Now, either way they do it, they're not going to do it quickly. They're going to be very slow. I think we're looking nowadays at a traditional secondary inspection being 2 hours long. And the purpose of that, again, is to make you uncomfortable. But I think it's very important to remind people that in order to have your visa revoked, during a CBP inspection, have your visa canceled, it requires you to either make an affirmative statement to them that you have done X, whatever offense it is that makes you inadmissible, or have them procure evidence that establishes that you did X, which leads to you being inadmissible. Absent of those factors, they have to grant you admission to the United States. An example that I will give is I had someone who went through, I believe it was Logan Airport in Boston, Massachusetts. They went through Logan Airport and they were in secondary inspection for 5 hours. And they were there for 5 hours. They said they spoke to 3 different officers and 1 supervisor. And at the end of the day, even though they were told repeatedly, we know you did this, we know you committed visa fraud, like just confess and everything will be okay. He said, I stuck to my guns. I had talked to me, the attorney, beforehand, and I knew what was true and what wasn't true. And I just, kept reiterating the truth of the matter, and they had to let him in. And he ended up being admitted to the United States. Now, have I subsequently told him, hey, maybe don't travel for like 3 years? Yeah, I've absolutely told him that. But I say all of this to tell you that there isn't traditionally a way for them to do these kinds of things without justification. There has to be a basis or a rationale to the decision making that's made. So while it is frustrating that there's this increase in secondary inspection, I think as long as an individual has been prepared thoroughly to understand what the process looks like and what to say and what not to say, not because not saying it is withholding the truth, but because you're not saying something because you're not trying to avail yourself to information that could lead to a problem. I think that's all important. I think that's why it's really important to either, speak with the employer before you're traveling or speak with an attorney, just so you have that opportunity to be prepared in the event that this happens. And so I hope that answered your question competently. Yeah. And how can I get legal assistance to resolve this quickly? It's a good question. And that's the real big issue with going through CBP. You're not entitled to legal representation because you haven't been admitted to the United States. So yes, you can present evidence of representation by an attorney, but then you're at the discretion of the CBP officer whether to invite that, whether to allow that. And I would say by and large, they're not going to do that because they don't want to get an attorney involved, because they know that once the attorney comes in, it shuts down a lot of the intimidation factors that they are dependent on to get the result that they want.
Right. Well, there you go, Jay. And thank you so much for, this very interesting question. Thank you, Justin, for taking that up, really. And now I think we should take up generics as well.
Hi, generic. I'm sure that's not your name, but I wish I knew your name. Anyway, so for H-1B holders already in the US who are petitioning for a second term, 3 more years, that is there anything that they should be concerned about?
Yeah, I mean, not in terms of travel, obviously, generally speaking, but if you're just talking about filing a USCIS extension, yeah, I think you should be concerned with an increased rate of RFEs, just to be blunt. You're probably looking at a significantly higher risk than during your original petition's approval of getting a request for evidence, probably for specialty occupation, if not for something else. But yeah, I think really that's it. I mean, you're just probably going to be looking at more RFEs. The idea that there was going to be kind of like a big surge in site visits for H-1B holders hasn't really occurred that much. I don't know if it's my honest belief is that they're waiting until after quota, after H-1B quota, so after the end of June. I think from July to September, the end of that, I think that's where you're going to see a bunch of H-1B site visits occurring, because because I think what's going to happen is they're going to approve cases and then try to subsequently invalidate them, like basically get cases denied for people, like basically, once the person transitions to H-1B, issuing a notice of intent to revoke or something like that. That's just theory. That may or may not be true. But for people that are looking at second extensions, I think that, you're probably going to have a higher rate of a specialty occupation RFE. Now, if it's an H-1B where it's the same petition, it's a continuation of employment, without change. There's likely going to be less scrutiny on those. But I think that where there are, extensions with change or amendment plus extensions, I do think that there's going to be a higher level of scrutiny on those cases.
Okay. Thank you, Justin, for highlighting that, and thank you for that very interesting question as well, generic. I hope folks out there are taking points because these are very important points that we have been discussing. And also, Justin, what do you have to say about the latest, that they are asking for biometrics as well for H-1B applicants? And that is also apart from address changes, which you need to also update to the USCIS.
Well, yeah, I mean, biometrics are one thing, but as just speaking personally, the AR-11 stuff, like we people need to be careful with the AR-11 stuff because there, I think I saw an F1 RFE that actually just came into our firm a couple days ago, where the person was filing a change of status, and they're basically saying that they never updated their address where they were living, and that their failure to do so was a violation. So that's interesting, but that is to say, I think it's imperative to make sure that you're updating your information. You can't leave any cracks at this point. There can't be anything that's left out there that gives rise to the possibility that USCIS can try to claim you were violating status or seek to revoke your visa.
Right. Thank you so much, Justin, for telling us about that also. And now, what would you like to tell us? What are the key documents that travelers should carry to be prepared for unexpected questioning also, or document requests at the airport?
So, generally speaking, if you're an H-1B holder, I think at this point it should be routine to enter with um, your petition. You should have your H-1B petition. I would have an employer letter that says that you're currently employed and they have continued need of the individual. You obviously need a copy of the approval notice and the visa and all that. You need all that to get in. But the other thing to remember is when you're coming in now, you need to make sure you're aware of the fact that what you have on your person is subject to search. So anything you bring in, particularly that's an electronic, is something that can be looked at. So do you make the decision then to travel without your laptop, and just travel with your phone? Do you make the decision to just travel with your work phone and bring your personal phone in, or ship it into the United States ahead of time. These are all factors that I think people need to consider that they would never have thought they needed to consider before. So while it is important to carry certain items, I think it's almost equally as important, if not more so important, to not carry certain items. I've been pretty much telling everybody across the board that I don't think it's smart to travel with your computer anymore. If you do travel with it and you're coming into the U.S., you should ship it in. That way, it's not physically on your person. And that's really across the board. I don't even care if like you were the most squeaky clean person who's never had any immigration record problems. I still would generally give that as a recommendation. So yeah, I mean, really in conclusion, it's just, you need everything that establishes that you're coming in for the intended purpose of the visa. But I also think stuff that's not going to help with that might be stuff you decide not to travel with.
Okay. Interesting points. Thank you so much, Justin, for taking that up. And now, also, if you could tell us, what are some common mistakes that travelers make during CBP inspections that can actually lead to delays or even worse, um, especially denied at entry?
I think people need to be aware that you have to actually stop and think about the things that you're saying, as particularly to the initial inspection officer. And what I mean by that is this. I had a case that I worked on a couple months ago where essentially the person was coming in and they were being asked questions like, like, how did you get this job? How did you get a job with this employer? And he was like, oh, he said something along the lines of like, oh, I was working for a company on F1, and they told me, if I got selected, if my case was selected, they'd file for me, and then I would work for them. But when I started working for them, they would get a percentage of the purchase order. And the officers was immediately like, somehow inferred from that statement, oh, this guy paid for his H-1B. And because he's paid for his H-1B, we can cancel his visa and put him as expedited removal. He went into secondary inspection where basically no matter what he said, no matter how hard he tried to explain that what he was talking about was the purchase order and how there's a contract between, employer, vendor, and end client, and there's a purchase order, and that the employer takes a portion of the purchase order as payment. That's what he was talking about. In no way was he talking about paying the company for his H-1B or the company garnishing his wages in return for them filing his H-1B. It didn't matter what he said. They had already formed this conclusion based off of what he thought was a really innocuous statement during that initial questioning that they then worked backwards from to get to the point where he ended up being removed. He ended up undergoing expedited removal. So that's what I mean by you have to be thorough with your answers, because you need to say what needs to be answered and nothing more. If you are asked by a CBP officer when you're coming in, and you're coming in and they say, hey, where are you gonna be going? You should be answering, I'm gonna be going to my work or to my house, or I'm gonna be going to fulfill the obligations of my visa. What you shouldn't be saying is something like, oh, I'm going to go do X, Y, Z, and then I'm going to go on the coast, or I'm going to go over here and do this, or I'm going to go visit my family and friends for a couple days. All that stuff is fine. But when you start word vomiting to the officer, then the officer's looking at you thinking, well, this person seems like they're nervous or there's something wrong. They're behaving in a way that's questionable. We should probably get them put in secondary and see what we can get out of them. So I would say just be prepared to answer the questions purely within the prism of what's being asked. Don't offer up any more information than what's being requested of you, and try to be calm during the situation. I think most people and most times you're going to be okay. But just weirdly, because of the world we live in, we do need to make sure that we are prepared. And that's why I've told pretty much anyone that I do consultations with now about travel, I want you to prepare as if you're going to secondary inspection. Because that way, ready and collected during the situation.
Right, right, right. So thank you so much, Justin. I think we just missed the last line. If you can just repeat.
Yeah, it's the weather. Just in conclusion, I would just say prep. Prep to
As
travel
if there's
back
going
into
to be
the U.S.
secondary
as if
inspection
you're going to
again.
be in secondary. Exactly. Yeah. Thank you.
All right. All right. So there you go, friends. I think, yes, it's always good to be best prepared and most prepared, but also be prepared for the worst. Have a plan B just in case, so that you're not that heartbroken at least, or you know what to do even if something bad, the worst case scenario happens. Anyway, yes, I think now, Justin, we'll just take up some of our Facebook questions as well before we leave. So, Control, if you can display them, please. Um, so, yes. If you can zoom in a little bit. Okay, this is Alice Anderson. Hey, I've been managing a business that serves US clients remotely for a while, but we never formally set up a US entity. With all the recent tariff issues, the market's been quite unstable and it's impacted our operations. Ironically, that shut slowdown gave us the space to explore the L1A route and consider opening a US office. But since things are slow right now, we don't have active contracts in the US. So we're not sure if that would make the visa harder to get. Do you think it's still worth applying at this stage, or should we wait until the market stabilizes a bit?
So a new office L1A it is an actionable route, but it is very very heavily scrutinized. The new office L1A, it's tough because you basically have to show that you're coming in to establish this business. What is the plan, what is the model, what are you going to be doing, what is the connective tissue with the foreign entity, how is everything going to be accomplished. And you're basically asking USCIS to either say, yeah, I buy this, or they're going to say, no, I don't really think that's what you're doing. You're just kind of trying to get a visa to come into the United States. And it makes it very hard. We even at my old firm, we would typically discourage new office L1As, even for individuals that qualified. So in the era of Trump, I think that you are looking at a difficult situation. The L1A, by its very nature, is it's document intensive. It's very heavy. You have to supply a lot of information. And then when you add into that the fact that you now have to establish that you're opening a new office, it's going to make it more difficult. Do I think you can do it? Yes. Do I think that it's going to be harder to do now than it was even 6 months ago? Absolutely. But it is an option, but you have to have really strong documents. I mean, you really have to have everything ironed out to where you clearly show what the model is going to be, what's the capital that's invested, who's going to be doing what with that company, what is your anticipated hiring looking like, how are you setting things up for that organization and how quickly it's going to grow, and then go forward from there. But yeah, I mean, I think it's possible. If that's something you actually want to discuss in more detail, I would actually recommend scheduling a consultation, and then we could take it up in more detail.
Absolutely. And there you go. You should definitely consult with Attorney Justin Rivera, and you can go check out Boston Immigration Litigation on LinkedIn as well. You can find Attorney Justin Rivera. Thank you so much, Alice, for that question. Those questions, rather, the situation that you're going through. And now let's take up this next one. This is from anonymous member. We are currently in the US on L1 visas that expire at the end of the year. I started a delivery business last year and I'm considering changing to an E2 visa. I'm planning to purchase a vehicle and rent a commercial space for a year. Is it mandatory to hire an employee immediately for the E2 visa application in this situation? And what are the advantages and disadvantages of pursuing an E2 visa for my delivery business? Will it be worth having a vehicle and business place? I would really appreciate your thoughts and suggestions.
Yeah, so that's an interesting question, and that's funny that this happened because I actually had someone else recently talk to me about an E2, and they were looking at E2 versus L1. I want to take a step back and tell you this immediately. If you're in an L1 and you're in the U.S. working subject to an L1, like I assume it's an L1A, you need to be looking at the L1A to EB1C route for a green card. That's I really think the pipeline that you should be trying to explore, much more so than I would worry about moving over to an E2 visa. Is it possible for you to move over to an E2 visa? Yes. There's a lot of planning that needs to go into that. And I think that it's going to be difficult for you to do transitioning over from an L1. Is it mandatory to hire an employee after the E2 visa? I mean, I think it's position specific, but the advantages of the E2 are, it's obvious that you have your own business and that's great. But when you have an L1, the L1 is kind of not the gold card, because I don't want to use a Trump term, but it is like the higher tier standard of work visa. I mean, yeah, the O1 is slightly above it, but the L1 is really great because it allows your opportunity. I mean, it allows you, if it's an A, to transition to that EB1C, which is one of the easiest green card pipelines there is. And so, yeah, I would need to look at your case more specifically, but it's weird. This must be something that is like circulating right now on the internet. It has to be this idea of going from L1 to E2, because this is the second or third time this has been brought up to me. I would look at the specifics of your case, but barring a significant change in my current opinion of the E2, I think being on an L1 is the better route 9 times out of 10.
That up, and thank you, Justin, for taking that up. And now let's go on to this next one. This is also from another anonymous member. Control, if you can please display that, please. Oh, sorry, not anonymous. This is. Could you please zoom in a little bit?
This was written by a mouse.
Masahi. Hello all, I filed my I-140 and concurrently my wife's I-485, I-131, and I-765 all at the same time, putting them together in one packet. My I-140 was just recently approved. Are my and my wife's I-485 processed together, or are they processed separately? My I-765 was also approved, and USCIS sent me my EAD card, but my wife's one hasn't been here yet. So, looking at my USCIS account page, estimated processing time of the I-765 in 38 months. It's stupidly long, it says. So, she's wondering whether their cases are going to be reviewed and processed separately, even though she is his dependent.
So they typically run them together, on average. Yeah, I mean, typically they should be run together. Your EAD being approved, though, and your wife's not being approved is not entirely uncommon, but it can happen. When a dependent's petition gets split off from the primary, it usually is because there is an issue related to that person's status or previous time in the United States. So, for example, like let's say hypothetically, you and your wife, you've been in the United States, you're filing to adjust status, and before that, your wife was in F1 status, and there was a violation of status for whatever reason. They could split it off and issue an RFE specifically on your wife's application, and that's completely unrelated to yours. So yeah, if it's been split off, that's definitely a possibility. I know that's probably not the answer that you want, but it's very likely what's occurring. The other thing that could be occurring is just that USCIS is stupid, which they definitely are, and they adjudicated your 765 and just forgot to do hers, which could also happen as well. You can usually use the EMA tool to reach out to USCIS to get an update. If you've already done that, you can try calling them to get information. They weren't helpful in the last administration. I've got to imagine they're even worse now. But those are really kind of the only avenues you have to explore, because you can't really proactively submit anything because you don't know what the issue is. So those are really your only options.
Thank you, Justin. Thank you. And I think we just have a couple more and we'll quickly take them up. So, Control, if you can just display that, please. So anyway, I'll go ahead and take up CL visa. I mean, I'm selected this year in lottery. Uh, so okay, let's take this one first. Sasi Raj is asking, "Hi, are people who got into H1B lottery this April this year going to expect calls from software companies here in the US? How will be the IT industry market for new H1B visa holders this October 2025? Can new H1B visa holders expect interview calls?"
I don't know what that means. I'm a little confused by what the question there is. If you're picked in the lottery, it's because you had an employer that agreed to sponsor you for an H-1B, and that sponsorship is based on the fact that at the time of filing, you have a job offer, a bona fide job offer,
Already.
an actual opportunity. Yeah. So if you get to the stage where your H-1B is selected and you're taking interviews, that doesn't make sense. You know, your employer is responsible for having that work lined up. And if they don't have that work lined up, then that's a problem. Now, alternatively, if I want to paint this in as nice a light as possible, maybe that question is trying to say, you know, I got selected for an H-1B with ABC Consulting Inc. And ABC Consulting Inc. is trying to make sure that I have a long-term project to be placed on when my H-1B is filed. And if that is the case, and you're saying what's the IT market going to look like, I don't know. I think generally the economy's not looking great right now. I'm just going to be, blunt with you. That I'm just being honest with you. The markets are doing what the markets are doing because of volatility, and there has been a lot of talk in big industries about hiring freezes. And anytime hiring freezes become the commonplace, that they're not adding new employees, especially to bigger companies, that's really the first cost cutting measure. You're saying, okay, we're going to stop on the expansion and deal with what we have. If you continue down a road where profitability is an issue, the next part becomes reduction. And so, yeah, I think that, look, things could definitely change immediately. We've already seen how the president behaves. Tomorrow he can cancel all the tariffs. Who knows? We're really living on the coattails of the whims of a person who makes decisions based on mood. So the tariffs could end up being gone, or they could raise taxes on everybody. We really don't know. But what I can say for now is, if you have a selected H-1B and you have a project that's a confirmed project, you need to file. Like, you need to file and you need to get that H-1B in and get it approved before all these companies start pulling back on their need for contractors and third-party placement individuals.
Mhm. Thank you, Justin. Thank you for taking that up. And now this last question of the day is from Sia. I'm selected this year in lottery. My B1 B2 visa was rejected in 2017. Can it affect my H1B visa interview? Can I mention in DS 160 that my B1 B2 was rejected before? Please advise.
Yeah, I think a question in the DS 160 is if you've ever been denied a visa or had a visa revoked. So it's something you have to disclose, because if you don't disclose it, you're making a material misrepresentation, and you're not going to get your visa, and you're going to have a fraud finding placed in your record. So, yeah, you have to disclose it. I think that as long as the rejection or refusal of the visa isn't tied to something that makes you permanently inadmissible, it's not going to be an issue. So, yes, you have to disclose it, provide an explanation, justify what happened, and you're fine. 95% of B2s are 214B refusals, which means that you haven't convinced the officer that you're going to either visit the U.S. temporarily, that you have non-immigrant intent versus immigrant intent, or that you haven't shown you have strong enough ties to your home country, which would lead them to believe that you're going to abscond and stay in the U.S. 214Bs can even just generally be issued as, like, I don't like the cut of your jib, like, I don't like your vibe, and as a result, I'm issuing a 214B. So if that's the case, it's super common. It's not going to be a problem for you. If it was due to you blatantly making a misrepresentation, then yes, it's a problem. But I would say 9 times out of 10, no, it's going to be fine, and admit it. The last thing I'd give you guys before we get off the call, Don't try to hide stuff from consulates. You don't know what information they do and don't already have access to. The government has a system that connects CBP to DHS. They share information. Assume that if one entity has it, the other entity has it. The worst thing you can do is lie and then get caught lying at the consulate, because then you will get a permanent ban to the United States. So, yes, in conclusion, yes, bring it up.
Yes. There you go. Thank you so much, Justin, for taking all of these questions from our audience and from me as well, so patiently, and for all the information you shared. I loved this conversation we had today. So much good information and important information from your end. So thank you. And maybe if you have any end notes or tips or anything you want to say to everybody watching us right now before we leave.
No, I'm good. I got to get a drink of water. I've been talking for like an hour straight. It was a pleasure having me on. Thank you very much.
But thank you so much, Justin. Yes. Have a great day ahead and see you soon.
Yeah, you too. Bye.
Bye bye. Folks out there, do if you do need to have a one-on-one consultation with attorney Justin Rivera, you can also call him up, and his number is 844-592-7366. You can also email him at, sorry, I'll repeat the correct phone number. It's 844-592-7336. And the email address where you can get in touch with attorney Justin Rivera is support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation. And also, don't forget to check them out on LinkedIn. They are Wasden Immigration Litigation. Also, friends, if you have questions that you would like to address, and which I could take up in our next webinar to the attorneys, you can also contact me. My phone number is 408-335-6444. This is also my WhatsApp number. And you can also email me at nepa@staffingly.com. So thank you once again, everyone, for joining us. If you haven't as yet subscribed, subscribe now. Our handle is at Immigration Talk Show. Also, share this handle with your friends and family who could benefit most with all our U.S. immigration content, the latest ones, especially, because we don't miss out on updating you as soon as possible. So check us out and share this handle, like, share, and subscribe, basically. So thank you once again, everyone, and see you soon. So stay tuned to Immigration Talk Show.